when you speak of remedial law, it is the means and methods whereby causes of action may be effectuated, wrongs redressed, and reliefs obtained. So kung may nangutang sa inyo, ano ang remedy? It's all about paano nyo i-assert ang karapatan nyo. So clearly, the remedial law plays a vital role in the administration of justice. Why? Because in its very core, it is really what? Giving life to the concept of due process. It is a means where the law hears before it condemns, one which proceeds upon inquiry and renders judgment only after trial, and contemplates an opportunity to be heard before judgment is rendered. Okay, so what is the nature of remedial law? Okay, well, it is law. It has the force and effect of the law. But the rules, okay, are subordinate to substantive law. And in case of conflict, we all know that substantive law will prevail, okay? Now, strict compliance is the general rule. It is not the exception to the general rule. And we will be discussing, if you look at your rules of court, tables of contents, diba? Ordinary civil actions, 1 to 56, provisional remedies, 57 to 61, and then you have special civil actions from 62 to 71. Okay. Now, just basic concept before I go to jurisdiction. No? Substantive law creates, defines, and regulates rights and duties concerning life, liberty, and property. Whereas remedial law does not create a right. Okay? Kaya may sinasabi nga na hindi ka makaka-claim ng vested right sa remedial law. So remedial law does not create right or obligations, but lays down the methods by which the rights and obligations, okay, arising from substantive law are protected, enforced, and given effect. So substantive law creates vested rights. Remedial law does not create vested rights. Substantive law is enacted by Congress, whereas remedial law, the Supreme Court is the one constitutionally empowered to promulgate rules of procedure. Now, balik tayo sa persons. Di ba, ang general rules of persons, laws are prospective in nature. Okay, prospective. So the general application is always prospective. Except, anong number one na exception? If the law expressly provides otherwise. Exception to the exception, unless it impairs a vested right. The second exception, okay, is in cases of criminal law. Okay, if it favors the accused. Exception to the exception, unless the accused is a habitual delinquent, not habitual criminal, habitual delinquent. The third exception will be curative laws. The fourth exception will be remedial laws. Remedial laws or rules of procedure may be applied retroactively. Okay, may be applied retroactively. Now, exception to the exception. Okay, remedial law may be applied prospectively only if the statute itself or the law itself expressly provides the same. And secondly, you cannot apply remedial law retroactively if, okay, if the case has already been decided with finality. Okay, kunwari, yung decision is final and executory na. After the decision has become final and executory, tapos biglang may law extending, okay, the what you call this, the period to file an appeal. But because the law has already attained finality, okay, already attained finality, it cannot be applied retroactively. Why? Because it will be contrary to the fundamental principle of immutability. Diba? Once the decision has attained finality, not even as a general rule, the Supreme Court cannot even change that decision. Okay. Now, the third is if to do so would involve intricate problems of due process or impair the independence of the court. And that's a case of Tan versus CA. Okay. Just to give you an example as to the difference between substantive law and rule of procedure. May bagong batas, okay, noon bago pa yon, no, nung family code, no. A new law under the family code, okay, limits the rights of an illegitimate child or a non-marital child to seek recognition or filiation. And this is the case of Bernabe versus Alejo. Ano ba yung facts ng case na yon? Si Public Prosecutor Bernabe had a illegitimate child, non-marital child. The child was born before the effectivity of the family code. So civil code siya. Okay. Anong nangyari? Then he died. Okay, he died. When he died, the wife died, the son died, tapos may isa na lang siyang anak. Now, the mother of the illegitimate child filed a case under the family code seeking the recognition of illegitimate filiation. Now, the daughter, the legitimate daughter, filed a motion to dismiss. Why? On the ground that the action has already prescribed. Why? Because according to her, if you're going to file a case for illegitimate filiation on the basis of secondary evidence, yung open, continuous possession of the status of an illegitimate child, it should only be filed during the lifetime of the putative parent. Natatandaan niyo yung persons, di ba? During the lifetime of the putative parent. Final niya, ganun, no? During the family code. Now, family code. Now, can the provisions of the family code be applied retroactively? Okay, be applied retroactively. And if it's applied retroactively, remember the child was born during the effectivity of the civil code, then technically she can no longer claim, file an action for illegitimate filiation. Anong sabi ng Supreme Court? Notwithstanding the fact that the action was filed during the regime already of the family code, you cannot apply the provisions of the family code retroactively because it will impair a substantive right. Okay. Now, sabi nga ng Supreme Court, the test to determine whether a law is substantive or not, the test is whether the rule really regulates a rule of procedure that is the judicial process for enforcing rights and duties recognized by substantive law. Okay. Itong batas na to is not a rule of procedure, the right of the child to file, because under the civil code, the period to file, if the putative parent died while the child is a minor, the child has 4 years upon attaining the age of majority to still file a petition for recognition of illegitimate filiation. Kung i-apply mo yung provisions ng family code, nawala yung karapatan na yun. Okay? And that is a substantive right which cannot be impaired because it has already been vested in the child. Is that clear? Okay, now. Okay, just give me a minute. My computer is there. Okay. As I said earlier, okay, the general rule is, okay, strictly comply with the rules of procedure. Liberal interpretation of the rules is only an exception to the rule, okay? Kaya before you invoke higher interest of justice, you should have a very compelling reason for you to be able to convince the application of the exception rather than the rule. Okay, now, let me proceed now to the rule-making power of the Supreme Court. Okay, remember, we go back to the Constitution. Yun naman ang pinaka-fundamental law natin. No? The Supreme Court has the power to promulgate rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts. So the constitutional faculty of the court to promulgate rules of practice and procedure necessarily carries with it the authority to overturn judicial precedents on points of remedial law through the amendment of the rules of court. And that's the case of Pinga versus Heirs of Santiago. The Supreme Court is also constitutionally empowered, okay, to establish rules for the admissions to the practice of law, the integrated bar, and the assistance to the underprivileged. But merong limitations rin, okay, ang rules na ang power ng Supreme Court. And that is the rules shall provide a simplified, inexpensive procedure for the speedy disposition of the cases. Okay, if you will look at the 2019 amendments to the rules on civil procedure, mas simple. Simple pero mas mabilis. Okay, and that is the reason why under the 2019 rules, you will notice that filing a motion for extension of time to file a pleading is not allowed except when the motion for extension of time is to file an answer, and the limit is 30 days pa rin. Pansinin nyo, even sa demerit of evidence, for example, if it's denied, you cannot bring it up on certiorari anymore. Okay? So yun yung mga gusto ko kasing i-highlight, but it will take some time, no? Lalong-lalo nung pagdating sa Rule 8. Okay? Okay, now. So the Supreme Court has the power to amend, repeal, or even establish new rules of procedure. Anong pinaka-example dyan? NAPES versus Court of Appeals. Before NAPES, if you file a motion for reconsideration, you have the remaining period within which to file your okay, I will repeat. Okay, before NAPES, okay, if you file a motion for reconsideration, motion for new trial, you have only the remaining period within which to file a notice of appeal if the MR or MNT has been denied by the court. But now the rule is different. NAPES is when you file a motion for reconsideration or motion for new trial and it's denied, you have a fresh period of 15 days within which to file your appeal. Okay. Now, the courts also have the power to relax or suspend technical rules of procedure. But as I said, no, that is more of an exception rather than the general rule. And what are the important factors to warrant the suspension of rules of procedure? Existence of special compelling reasons, the merits of the case, a cause that is not attributable, okay, to the fault or negligence of the party who is invoking liberal interpretation, lack of showing that the action was filed just to be for purposes of delay, and the other party will not be unjustly prejudiced thereby, and that's a case of Sarmiento versus Zaratan. Okay, now, when we speak of courts, our courts are courts of law and courts of equity. Anong ibig sabihin ng courts of law? Any tribunal duly administering the laws of the land. Courts of equity are also tribunals administering justice outside the law, being ethical rather than jural and belonging to the sphere of morals rather than the law. It is grounded on the precepts of conscience and not on positive law, for equity finds no room for application when there is a law. Okay. Now, courts of law therefore decides a case based on promulgated laws, whereas courts of equity adjudicates a controversy according to the common precepts of what is right and what is just without inquiring as to the terms of the statutes. Okay, now, okay, constitutional courts versus statutory courts. Constitutional courts are created obviously by the Constitution. Okay, it can only be abolished by, by amending the Constitution. Whereas statutory courts are not created by the Constitution. They're created by laws passed by Congress, and therefore may be abolished by the Congress by simply repealing the law that created it. Question, how many, okay, tell me if the Sandigan Bayan is a constitutional court or a statutory court? At nanahimik ang lahat. Diba? Yes, it was referred to, okay, in the Constitution, but it has to be, there has to be a law to create it. So technically, okay, all courts in the Philippines except the SC are statutory courts, which include, of course, the Sandigan Bayan. Well, it's constitutionally mandated, as I said, its existence is owed by the enactment of a it exists because of a statutory enactment. Okay. Now, so we have, sorry, I have to go to the basic lang. I know you all know this, but pardon me, that's my assignment on general principles. Okay, so what are the classification of courts? You have your regular courts, you have your special courts. Examples of your regular courts will be the Supreme Court, the Court of Appeals, the RTC, the MTC. What will be your special courts? The Sandigan Bayan, the Court of Tax Appeals, the Sharia District Courts, and the Sharia Circuit Courts. Then you have your quasi-courts or quasi-judicial agencies. Okay, very basic. Courts of original jurisdiction and courts of appellate jurisdiction. Courts of original jurisdiction, courts exercising jurisdiction in the first instance, whereas courts of appellate jurisdiction, superior courts reviewing and deciding cases previously decided by the inferior court. MTC is the first level court. It's no longer referred to as inferior courts. RTC, CA, Supreme Court. I'm talking about appeals. Okay. Appeal is a continuation of the case below. And that is the reason why Rule 65 is not appeal. It's not a mode of appeal. If you look at Rule 65, ang title niya, di ba, under siya sa heading ng Original Special Civil Action. Correct? And therefore, it is not a mode of appeal. So for purposes of illustration, if you have RTC here, and the RTC decided in an order denied your motion, for example, motion to dismiss on the ground of lack of jurisdiction over the subject matter, denied. Okay. MR, order denied pa rin. Okay. These two interlocutory orders, okay, will have to be filed if there is grave abuse of discretion amounting to lack or in excess of jurisdiction. You bring it up to the CA under Rule 65. In fact, the filing of this original special civil action does not abate the proceedings below. Hence, for it to be abated or suspended, okay, you have to have a TRO or a WPI. Correct? Okay. So they exist parallel to each other. Kapag wala kang TRO or WPI, okay, tutuloy ito sa baba, tutuloy yan. But compare this with appeal. Appeal is a final judgment. Okay? And when you appeal a judgment, which means tapos na yung proceedings sa baba. So pupunta yan sa taas. Is that clear? Okay, now. The RTC is an appellate court. The CA is an appellate court. The Supreme Court is an appellate court. Now, if the decision comes from the MTC, okay, except, okay, it can be appealed to the RTC, right? Under Rule 40. Correct? Ground, questions of fact and questions of law. Correct? Okay. The RTC acting, okay, as an appellate court, dito tayo sa side, appellate court. Okay? This is you file a notice of appeal. Okay, period to appeal, 15 or 30 days. 15 is its ordinary appeal, okay, but 30 if the case involves a record on appeal. Okay, record on appeal. In cases where multiple appeals are allowed, you pay the docket fee with court of origin. So going back to the, what you call this, going back to the concept of delegated jurisdiction, okay? The MTC, the MCTC, and the MMTC are granted delegated jurisdiction to to hear and determine cadastral and land registration cases in the following instances. Number one, where the lot sought to be registered is not subject of controversy and application. Number two, where the lot is contested, my opposition, but the value of the land does not exceed, okay, ang batas lagi does not exceed, napaka-importante yan, 100,000 such value to be ascertained by the affidavit of the claimant or by agreement of the respective claimants if there are more than one, or from the corresponding tax declaration of the real property. What is important is pag nagdesisyon na yung MTC, saan i-appeal? Just remember that the MTC decision will be considered as an RTC, as the decision of the RTC. Now, courts of general jurisdiction, courts of special jurisdiction. Courts of general jurisdiction, those with competence to decide on their own jurisdiction and to take cognizance of all cases, civil and criminal, of a particular nature. And courts of special jurisdiction, those which have only a special jurisdiction for a particular purpose or are clothed with special powers for the performance of specified duties beyond which they have no authority of any kind. Okay. May isang example dyan. And this is the case of GJH land. Okay. Now, the case, okay, so based on the allegations of the case, it was intracorporate in nature. Okay. When it was raffled off, it was raffled to the RTC acting as a court of general jurisdiction. Okay. Masyadong maaga pa para magpa-exam, no? Kasi baka umuwi na kayo pagkatapos ito. Okay, wait. Okay, but I am so tempted to say, hindi, isa lang, maiksi lang naman to kasi maiksi lang yung sagot. I just want to know para I'll be guided accordingly. Okay, makinig, ha? So there was a case that was filed and the complaint is one for intracorporate, okay, intracorporate controversy. It was raffled off, let's say, to RTC branch 123, a court that the RTC as a court of general jurisdiction. Basa yung judge. Hindi akin to. This is intracorporate. Okay. So what he did was he dismissed the complaint because sabi niya precisely, I have no jurisdiction and therefore ordered, okay, that the case be dismissed. Question, is the dismissal correct or not? Ano sa ganito lang ang choice. Isulat nyo sagot o mag-recitation tayo dito, di ba? Pero mas gugustuhin nyo. Maiksi lang yan. And then tell me, just give it to me so I would know. I just need kasi a feedback so I would know how to attack, teaching. Maiksi lang yung sagot. Did the RTC correctly dismiss the case? Okay, I'll just give you 3 minutes. So the question is again, did the RTC correctly dismiss the case? Okay, because the complaint is actually one that involves intracorporate controversy. The RTC that dismissed the case is an RTC which is a court exercising a court of general jurisdiction. Kasi sabi niya, dapat ito sa special commercial court. So dinismiss niya. No, the court is not correct in dismissing the case. The RTC as a court of general jurisdiction has the power to decide the case if it's within jurisdiction or remand the case to the court which has jurisdiction. Okay, I will just read it. No, the RTC must take cognizance of the case involving intracorporate controversy. Under prevailing jurisprudence, a court of general jurisdiction may act upon any case filed before it as long as it is not vested in another court or tribunal. No, the dismissal of the RTC was not correct. Being a court of court of general jurisdiction, the RTC still has jurisdiction over intracorporate dispute, notwithstanding the fact that it is not a special commercial court. The court does not lose its jurisdiction as RTC being court of general jurisdiction can hear and try the case, even one with intracorporate dispute. Hence, the judge is correct in dismissing the case. No, the RTC is not correct in dismissing the RTC has jurisdiction in cases involving intra-corporate controversy. Judge 123 should do is to re-raffle the case again to RTC, that is a special commercial court. The RTC should not have dismissed the case. The RTC will still have jurisdiction over involving intra-corporate dispute. Okay. No, the judge should not have dismissed, but rather referred the matter to the RTC designated as special commercial court. No, the dismissal is correct, is not correct. The law provides that RTC, being a court of general jurisdiction, has the power to try and decide, including intra-corporate cases. No, the RTC did not correctly dismiss the case. As a court with special jurisdiction, the RTC is given the jurisdiction over commercial-related subject matter. Okay. Notice lahat kayo, no. Kasi hindi ko nga naman tatanungin yun kung ang answer yes, di ba? So you followed your instinct. You have 1 point. Siguro kung liberal na konti, 2 points. Kasi no eh. Tapos nagkahiwalay-hiwalay na sa rason. Okay. Now, the nearest answer, kaya lang hindi masyado, but I think we'll get 4, maybe 5 kung mabait, is this one. No, the RTC is not correct in dismissing the case. The RTC has jurisdiction in cases, ito yung mali na parte, in cases involving intra-corporate dispute. It does not have, because the RTC where the case was raffled to is a court exercising yung general jurisdiction. May RTC na special commercial court eh. Ang mali is dinismiss niya yung kaso. What the RTC should have done, the RTC that is exercising exercising original jurisdiction, okay, is just to order the re-raffling of the case. Re-raffling of the case. May isang kaso, okay, yung Panday, Calleja versus Panday. That is an old case. Okay, where the Supreme Court said, okay, because the RTC does not have jurisdiction, as it was the RTC acting as a special commercial court. The only power it has, according to that old case, is to just dismiss the case. But here comes now JGH land, okay. Sabi ng Supreme Court, okay, the basic premise, okay, is that a court's acquisition of jurisdiction over a particular case, subject matter, is different from incidents pertaining to the exercise of jurisdiction. Remember the RTC, okay, remember that the RTC's existence as a court of general jurisdiction was conferred by law. Whereas the court's exercise of jurisdiction, unless provided by the law itself, is governed by the rules of court. Now, yung tinalaga yung isang RTC as special commercial court does not amend BP 129 that the RTC is also a court of general jurisdiction. Okay, and therefore it is wrong to say that it has no power. It has the power to order the re-raffling so that the case now can be raffled to the RTC acting as a special commercial court. Why? Because, okay, the exercise of the RTC's general jurisdiction or its limited jurisdiction as a special commercial court is only a matter of procedure and has nothing to do with the question of jurisdiction. Which means the RTC that's acting as a court of general jurisdiction erred in dismissing the case. It has the power to have it re-raffled or order the re-raffling of the case so that now it can be properly assigned, okay, raffled to the RTC as a special commercial court. Clear? And that is the case of JGH land. Okay. Now, last week when we did our evidence, notice that I asked 2 questions. The first question was a question that would only require, that only required application, no? You recall the procedure and then you apply. The second question actually called for the application of many principles. Okay, maraming prinsipyo tapos you decide. The third now is based on jurisprudence. And why did I stress this? Okay, because it is not enough for you to know the law only. You have to know jurisprudence. Because jurisprudence, the one decided by the Supreme Court, form part of the legal system of the Philippines. And that's a provision in, in the Civil Code. Kaya pag mag-aaral kayo, wag lang yung, sige, mag-aaral lang ako ng provision of law. Hindi kakayanin. Kailangan alam nyo yung batas. Kaya di ba may cut-off? What's the cut-off date for the cases? Okay, but sometimes, may mga kaso na outside, may tanong na ang sagot outside the cut-off. Lalong-lalo na yung mga importante na kaso. Okay, clear. Okay, so as I said, ako ang major take ko dito, you followed your instinct. But apparently instinct is not enough to get 5 points, huh? Okay. Any questions so far? Okay, let me just go back now to, jurisdiction. Yan. Okay. When we talk about concurrent jurisdiction is also called coordinate jurisdiction, is the power of different courts to take cognizance of the same subject matter. Where there is concurrent jurisdiction, the first taking cognizance of the case assumes jurisdiction. Okay. Please take note. Ano bang example niyan? The SC, the CA, the RTC have concurrent original jurisdiction to hear petitions for certiorari, prohibition, mandamus, and even quo warranto, correct? Okay. But even if it has concurrent original jurisdiction, hindi mo pwede sabihin sa kliyente mo, saan mo gusto? Gusto mo, diretso na tayo Supreme Court, ganito bayad mo, CA, ganito bayad mo, RTC, ganito bayad. Very wrong. Okay, very wrong. Malalagay ka nga sa scrap dahil gross ignorance of the law. Okay? Why? Because you follow the doctrine of hierarchy of courts. Okay? That is what will guide you to determine saan ko ba to ifa-file. Clear? Okay. Example, habeas corpus. Okay? Saan ko ba ipa-file tong habeas corpus? Dito ba ako sa CA o dito ba ako sa RTC? Tanong mo sa sarili, nasaan ba yung bata? Diba? If you do not know the whereabouts of the child, you might as well file it with the CA because the writ of habeas corpus can be enforced anywhere in the Philippines. But if you file it with the RTC, it can only be enforced and implemented within the territorial jurisdiction. That's Thornton versus Thornton. Okay? Now, so let's talk about jurisdiction of specific courts. Okay. The Supreme Court has original jurisdiction over cases affecting ambassador, other public ministers, and consuls, and petitions for certiorari, mandamus, prohibition, habeas corpus, and quo warranto. Okay. In the case of Ombudsman versus De Ventura, citing the case of Estrada versus Desierto, the parties seeking to question the resolutions of the Office of the Ombudsman in criminal or non-administrative cases may file an original action for certiorari with the Supreme Court, not with the CA, when it is believed that the Ombudsman acted in grave abuse of discretion. Okay. The Supreme Court has exclusive original jurisdiction over the following: petitions for certiorari, prohibition, mandamus against the CA decision, against the Commission on Election, the COMELEC, the Sandigan Bayan, and the Court of Tax Appeals. It has exclusive original jurisdiction over disciplinary proceedings against members of the bar and other court personnel. Now, kung matatandaan nyo, and if I remember, Article 8, Section 1 of the Constitution, okay? Di ba mayroon doon provision on certiorari? Okay, it's Article 8, Section 1 of the Constitution. Tapos meron kang certiorari 65. Pareho ba silang dalawa? The answer is no. Now, the certiorari jurisdiction of the Supreme Court has been rigorously streamlined so that Rule 65 admits cases based on specific grounds provided in Rule 65. And Rule 65 applies if there is no appeal or any other plain, speedy, and adequate remedy in the ordinary course of law. And the independent action for certiorari will only be issued if there is grave abuse of discretion, which is alleged and is proven to exist. Now, in the case of Aurelio versus Aquino III, and this is where the Supreme Court basically discussed the certiorari, the writ of certiorari as mentioned in the Constitution. It was held that petitions for certiorari and prohibition are appropriate remedies to raise constitutional issues and to review and prohibit or even nullify the acts of the legislative and of executive officials. Remember, ang Rule 65, okay, is for tribunals, entities exercising judicial or quasi-judicial function. Pero pagdating sa Constitution, yung certiorari referred to in the Constitution can nullify even acts of the legislative and even the executive kasi expanded yung concept ng certiorari sa Constitution. So with respect to the court, however, the remedies of certiorari and prohibition are therefore necessarily broader in scope and reach, and the writ of certiorari or prohibition may be used to correct errors of jurisdiction committed not only by tribunal, corporation, board, or entities exercising judicial or quasi-judicial functions. Okay? Clear. So iba yung konsepto na yon. Now, SC, exercising concurrent original jurisdiction. Pag nakarinig tayo ng concurrent, may isa pang court na may ganitong power. No? Now, it has concurrent original jurisdiction with the CA over petitions for certiorari, prohibition, and mandamus, especially when you talk about orders emanating from the RTC, the Civil Service Commission, the Central Board of Assessment, and don't forget NLRC because of St. Martin Funeral Homes. Diba? May decision na yung NLRC. You don't appeal it, you file a Rule 65 before the NLRC and other quasi-agencies. Okay, now, petitions for writ of kalikasan. Now, it has also original concurrent jurisdiction with the CA and RTC, again, over petitions involving certiorari, prohibition, mandamus, and quo warranto and writ of habeas corpus. I will repeat for the second time, please do not forget the doctrine of hierarchy of courts. The Supreme Court also has exclusive original jurisdiction, concurrent original jurisdiction with the RTC, with respect to cases affecting ambassadors, public ministers, and consul, with the CA, RTC, and the Sandigan Bayan for petitions for writ of amparo and writ of habeas data. Now, the Supreme Court has appellate jurisdiction, okay, to review, revise, reverse, modify, on affirm on certiorari, which means Rule 45, the following: all cases in which the constitutionality or validity of any treaty, law, executive agreement, okay, is in question. All cases involving the legality of any tax, impost, etc. All cases in which the jurisdiction of any lower court is in issue. All cases in which the penalty imposed is reclusion perpetua or higher. And finally, all cases in which there is only an error or question of law is involved. So by way of petition for review on certiorari, that will be your Rule 45. It has exclusive jurisdiction over decisions rendered by the CA, the Sandigan Bayan. Now, even over RTC, based on our drawing, if the appeal is based on pure questions of law only, and the decisions rendered by the CTA and bank, okay, hindi ng division, ha? It has to be the CTA and bank. Okay, and decisions rendered by the METC, MTC, and the MCTC in the exercise of their delegated jurisdiction in cases involving land and land cadastral cases, because the decision nga of the MTC is considered a decision of the RTC. And therefore, if the appeal is based on pure questions of law, you will have to file your appeal with the CA. With the Supreme Court, excuse me, with the Supreme Court. Okay. So Again, when do you say that that the issue involves only pure questions of law? When there is no need, okay, for the evaluation of the evidence. Always remember. So I'm very sure you have read in your reading na sinasabi the SC is not a trier of facts. Kaya yung pag sinabing SC is not a trier of facts, ang ibig lamang sabihin yan, pure question of law. Okay? So it does not require the evaluation or the re-examination of the evidence as a rule. Clear? Okay, I will discuss when the SC can... Okay, anyway, I'll discuss it now. As a general rule, okay, the SC is not a court that can try facts. Okay, but there are exceptions to that general rule. The SC may resolve factual issues in certain exceptional cases, such as when the conclusion is grounded on speculations, surmises, or conjectures, when the inference is manifestly absurd or mistaken or impossible, or there's grave abuse of discretion, or the judgment is based on misapprehension of facts, or the findings of facts are conflicting, or where there is not even a citation of the evidence on which the factual findings was based, okay, or the finding of absence of facts is contradicted by the presence thereof in the evidence or on record. The findings of fact are contrary of the CA are contrary with the findings of fact with the trial court, or the CA manifestly overlooked certain relevant and undisputed facts that, if properly considered, would justify a different conclusion, and the findings of the CA are beyond the issues of the case, or such findings are contrary to the admission of both parties. Okay. Now, how about the jurisdiction of the Court of Appeals? Ang Court of Appeals may exclusive original jurisdiction. Meron din siyang concurrent original jurisdiction. Anong example ng exclusive original jurisdiction ng CA? Actions for annulment of judgments of the RTC. Okay? Or concurrent original jurisdiction with the SC. Petitions for certiorari, prohibition, and mandamus against RTC, Civil Service Commission, Central Board of Assessment Appeals, other quasi-judicial agencies listed under 43. But please remember that the list in 43 is not exclusive. Just because wala doon yung quasi-judicial agency, ay walang jurisdiction. It is not exclusive. Ang out lang dun sa 43 will be your Court of Tax Appeals, COMELEC, COA, what else, and NLRC. Okay, not 43 because it will be based on 65. Okay. Now, it also has a concurrent original jurisdiction with the SC, and the RTC in terms of the petitions for writ of kalikasan, with the SC and the RTC against CPM, quo warranto, and habeas corpus, with the SC, RTC, and the Sandigan Bayan, petitions for writ of amparo, petitions for habeas data. Now, with respect to the exclusive appellate jurisdiction, dito mo lang i-appeal by ordinary appeal from judgments of the RTC and family courts over decisions rendered by the MTC in cadastral or land registration cases pursuant to its delegated jurisdiction, petition for review under Rule 42. Okay, but please take note, the exception to that are those cases decided by the RTC involving cases governed by the rules on summary procedure. Okay. Now, from decisions of the Office of the Ombudsman in administrative disciplinary cases and other bodies mentioned under Rule 43. Okay. Now, let's now discuss the jurisdiction of the RTC. Okay. Dito sa jurisdiction ng RTC, very important that you should read RA 11576. Okay. So first, let's discuss, okay, all actions incapable of pecuniary estimation is with the jurisdiction is exclusively with the RTC. The question is, okay, paano mo malalaman if the action is incapable of pecuniary estimation? Ito mahirap to, ha? Mahirap. Okay. You know, may kinausap akong isang bar examiner. Sabi ko, paano ba talaga sumagot? Okay, paano talaga ba sumagot? Kasi yung iba makikita mo very structured eh. Okay, ang maling sagot, unahin ko yung maling sagot, yung uulitin mo lang yung question. Kasi may mga ibang estudyante, okay, based on the facts, and the facts are follows, utang na loob, talagang, you know, alam mo nang hindi niya na naiintindihan, okay? Ang una, huwag mong baguhin ang style mo. Okay. Kasi yung style mo yan, kaya ka nakagraduate. Then all of a sudden, you have only 3 months. Tapos maiiba yung style mo. Ang hirap nun, di ba? So believe in your capacity. But okay. There are different styles of answering it. The first one is if you really, really know the answer. Yung bang, yung facts, ipinasok mo na kaagad yung law. Okay, yung facts, pinasok mo kaagad. Based on the facts, this does apply because, yan, yung dire-diretso lang. Yung iba, okay, law, and then you apply. Okay, and you'll never get wrong with that, no? Law, then you apply. Or the elements, and then you apply the elements one by one. So why did I mention that? Tinanong, does the RTC have jurisdiction? And yung question, okay, based on the allegations of the complaint, the principal relief sought is to collect, okay, it's a breach of, for example, it's a deed of absolute, a promissory note, okay. May allegation ka breach, pero ang prayer mo, for you to be paid, okay, for you to be paid, let's say, 2.5 million pesos. Okay. Eh, nakalagay sa allegation, may breach dun sa ano. Ang unang mong ilalagay is the test, okay. To determine whether the action is one capable of pecuniary estimation or incapable of pecuniary estimation, you put the test. If it is primarily for the recovery of a sum of money, then the claim is considered capable of pecuniary estimation. On the other hand, where the basic issue is something other than the right to recover sum of money, and the money claim is purely incidental to or a consequent of the principal relief sought, then the action in litigation is incapable of pecuniary estimation. And that's the test mentioned in the case of heirs of Padilla versus Magdua. Okay. Anong example ng subject matter incapable of pecuniary estimation? You want to nullify the deed of assignment and conveyance. Okay? You want to nullify it and incidental lang yung humingi ka ng damages. So if it's an action to rescind, that is an action incapable of pecuniary estimation. Kahit may figure pa yan, pero yan ay incidental lamang, okay, then it is the RTC. Okay, specific performance, okay, you want to enforce a contract, then may amount incidental lamang yan. Then it is an action incapable of pecuniary estimation. Pero kung nakalagay doon sa kwento mo, pati doon sa prayer mo, ang nakalagay, okay, bayaran ako, okay, hindi dahil sa mukha kang pera, pero gusto mo lang mabayaran ka, okay, and that's the principal relief sought, then the action is capable of pecuniary estimation and the jurisdiction will depend upon the amount. So if you are unsure, please try to memorize that test. Kasi hindi ka makakakuha ng zero. Okay, you will have something to write on. Is that clear? Okay. Okay. So another example, if the principal nature of an action is to cancel a contract to sell, di ba? Nagbabayad ka. Okay? Tapos may breach yung binibilan mo. Okay? Now you want to cancel the contract to sell and the defendant has already taken possession of, okay, plaintiff versus defendant. Defendant is the buyer. Okay? Seller now wants to cancel the contract to sell. The defendant is there, okay, in possession of the property. Now, the suspensive condition, which is to pay, was not fulfilled. The subject matter is still incapable of pecuniary estimation. Why? Because precisely the principal relief sought is to cancel the contract. Okay? And that is an action incapable of pecuniary estimation. Is that clear? Okay. The second is civil actions involving Title II or possession of real property or any interest therein, where the assessed value exceeds how much? How much? Anong 2 million? Ano? Yung civil 400,000 pesos, di ba? Exceeds. Okay. Now, when you say actions involving Title II, possession of real property or any interest therein, it is a real action. Okay? Now, if it exceeds 400,000 pesos, except forcible entry and unlawful detainer, the original jurisdiction, which is conferred with the MTC, if it exceeds, laging word yan, exceeds, okay, then it will be with the RTC. And when you say it is an action involving title to real property, it means that the plaintiff's cause of action is based on a claim that he owns the real property or he is entitled to the possession of the property. So therefore, the legal link between a person who owns a property and the property itself. Okay. Ano ang rule dyan? Okay. By the way, when we're reviewing this, imagine ninyo, ito rin yung mag-guide sa inyo pag gumawa kayo ng pleading. Okay. Your action is to recover action, let's say, publishana. It's an action to recover possession. Okay. Kung action publishana yan, real action yan, kailangan may what you call this, may assessed value. Kasi kung walang assessed value yan, how will you know anong court, okay, ang may jurisdiction to hear and decide an action publishana case? So you have to allege in your complaint for action publishana an assessed value. Pwede nyo namang inventohin, hindi naman kailangan mag-appendo ng totoong ano, di ba? Ang tawag dito, yung tax declaration. Basta yung inventohin yung amount less than 400,000. So sa MTC yan. In excess of 400 RTC yan. Okay. Paano kung unlawful detainer? Kailangan mo pa bang mag-allege ng assessed value? Hindi na. Because we know under BP 2129, basta forcible entry or unlawful detainer suit, which technically is a real action because you want to recover possession, the court that has jurisdiction over it is the MTC. So if it's a lawful detainer, forcible entry, okay to forget the assessed value. You don't even have to allege it. Simply because the jurisdiction is really vested with the first level court. But if it's an action, okay, let's say if it's an action for action publishana, action reindificatoria, utang na loob, do not forget your assessed value. Otherwise, without that, the court will not be able to determine whether it has jurisdiction. It will just dismiss the case. Clear? Okay. Now, actions in admiralty and maritime jurisdiction where the amount refers to demand or claim exceeds 2 million pesos. So kung 2 million court ang anong court ang may jurisdiction to hear admiralty and maritime jurisdiction? Yung amount ng maritime claim is exactong 2 million. What court has jurisdiction? Please don't answer God. No, because God does not. What court has jurisdiction? MTC, kasi nga yung rule exceeds. Lahat yan exceeds. Pansinin nyo, lahat exceeds. Okay? Now, third, matters of probate, testate or intestate, where the gross value of the estate exceeds 2 million gross. Alam natin ang gross versus net, di ba? Walang deductions involved. Okay? So gross, and it should exceed 2 million pesos. Kaya yung mga inferior courts, hindi yung 1 million, maliit na palang value yan kasi pang inferior courts yan eh. Mayaman-yaman kapag ka RTC, in excess pa of 2 million. That's what I always say, no? Now, In all actions involving the contract of marriage and marital relations, but that's the RTC Act as a family court, okay, which we will discuss later. And in all cases not within the exclusive jurisdiction of any court, tribunal, person, or body exercising jurisdiction, okay, which means the RTC is a court of general jurisdiction in all civil actions and special proceedings falling within the jurisdiction of the JDRC and the Court of Agrarian Reform as provided by law. Itong napaka-importante. In all other cases where the demand refers, okay, to the demand exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses and costs, or the value of the property in controversies exceeds 2 million pesos. Question, collection suit. Amount is, let's say, ang utang is 1.9 million. Okay. 1.9 principal. Interest, let's say, is 300,000. Attorney's fees is 300,000. Teka, nag-iisip ako, which means nag-mathematics ako, sandali. Okay. And then, interest 300, attorney's fees 300, 1.9 yung principal. What court has jurisdiction? Please don't, I could only hear TC. Narinig ko, TC. Okay. RTC, who says, okay, close your eyes if you don't want other people to see the answer. Who says MTC? Who says RTC? Ang tamang sagot ay TC. MTC, kasi ang nakalagay sa batas, exclusive of. So hindi mo i-include ang nakalagay. Basahin natin ulit. Look at the law, ha? Don't look at me. Mukha ba akong RA 7691? Hindi. Okay? In all other cases, the amount of which, okay, is exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and cost or value of the property in controversy exceeds 2 million pesos. So, clear? Huh? Okay. Now, all actions and special proceedings. Now, what if it's a case, let's say, tort, okay? Moral damages. Moral damages, 2 million pesos. Exemplary damages, 1 million pesos. Okay. Attorney's fees, 1 million pesos. What court has jurisdiction? Oh, talaga RTC, tama ka, sir. Okay, tama. With your smile, I cannot say you're wrong. Okay? Your smile convinced me that it is right. That is very right. Okay? Now, all civil actions and special proceedings falling within the exclusive jurisdiction of the Court of Agrarian Reforms. And then, of course, all cases not within the exclusive jurisdiction of any court, you need to tell the Court of General Jurisdiction. And then your intra-corporate controversies, okay, where the RTC now is designated as special commercial court, and petitions for declaratory relief is with the jurisdiction of the RTC. Petitions for injunction as the main case is also within the jurisdiction of the RTC, not with the Supreme Court. The Supreme Court, the CA, the RTC have concurrent original jurisdiction to hear petitions for prohibition. But petitions for injunction, RTC po lamang yan. Okay, question. Okay. Husband and wife. Okay, what's your name, sir? The one with the beautiful smile. Tukso, kunwari. Ako ba? Okay, what's your name, sir? Adrian, the lady beside you is? Jade. Adrian and Jade, husband and wife. Okay. Minsan may mga nabubuong love team pagka-preview. Okay. Adrian and Jade, husband and wife. But Jade, after their marriage, okay, decided to file a petition for declaration of nullity of marriage. Because, of course, Adrian is psychologically incapacitated to fulfill his marital obligations. Granted by the RTC. Granted. Okay. Now, after the court, and when the court granted, the grant was it was just for the declaration of nullity of marriage. There was nothing in the decision that touched on the liquidation and distribution of their 147 properties. Diba? The property relationship is not conjugal, diba? It is 147, which is co-ownership. You remember? Now I remember, ma'am. Okay. Parang yung iba, alam mo, pag nakaupo kayo dito, one of these days, pag may pauupuin ako sa inyo dito. Kasi yung iba talaga parang, tama ba yung sinasabi niya? Medyo. Okay, medyo. So the petition for declaration of nullity was granted, okay? And we know this from jurisprudence that the property relation that will govern the liquidation is 147. It's not ACP or CPG. Okay, 147. Hindi nag-liquidate. So they were in a state of co-ownership under 147. Years after the petition for declaration of nullity was decided with finality, years later, Adrian now tells the wife, I want to get my share of our co-owned properties. Okay? Now, sabi ni ex-wife, no, I don't like. Okay? So ito naman si Adrian, okay, went to you and ask you, what will I do? Madali yan. I'll file a petition for a complaint for partition. Tapos, the assessed value of the property, okay, let's assume is 1 million pesos. Okay. Ang tanong ngayon, ito, saan ifa-file? RTC acting as a court of general jurisdiction or RTC acting as a family, not acting because RTC as family court. Kasi may statutory na yan eh. Because if you look at the family court law, okay, when it comes to the property relationship, okay, property relationship, RTC as a family court has jurisdiction. So the question is, what court now has jurisdiction to hear and decide that case? What do you think? RTC as Court of General Jurisdiction. Who says RTC as a family court? Okay. May kaso, ang kaso niya is Nonato versus Barido. Okay. Sabi ng Supreme Court, RTC, okay, actually hindi pa nga, ang assessed value non MTC pala. Ang assessed value dun sa Nonato is MTC. It's MTC that has jurisdiction to hear and decide that case of partition, not even the family court. Why? Because the assessed value of the property, and this is a real action, is within the jurisdiction of the MTC. Kaya yung partition case na yun, dapat daw i-file sa MTC because of the assessed value. Nonato versus Barido. Okay. Now, concurrent original jurisdiction with the SC in cases affecting ambassadors, public ministers, and consuls. With the SC and CA petitions for certiorari prohibition mandamus against lower courts and bodies, petitions for quo warranto, petitions for writ of habeas corpus with the SC and the Sandigan Bayan, petitions for writ of amparo and habeas data. Now, does the RTC have appellate jurisdiction? Yes, appellate jurisdiction over cases decided by the lower courts in the respective territorial jurisdiction, except those made in the exercise of delegated jurisdiction, which are appealable in the same manner as decisions of the RTC. That is your section 34 of BP 129. And the SC may designate certain branches of the RTC to try exclusively criminal cases, juvenile and domestic cases, agrarian cases, or, for example, commercial cases. No? Now, kasama sa outline yung jurisdiction of family courts, hindi, di ba? If my recollection serves me right, hindi. Okay, now jurisdiction of, let me just finish, I know it's past 10 o'clock, no? But let me just finish jurisdiction of the MTC, municipal trial courts, and municipal trial courts. Okay. Okay, actions, the inferior court has jurisdiction, okay, in actions involving title to or possession of real property or any interest therein, but please take note that the assessed value of the property must not exceed 400,000 pesos. Now, also the under RA 11576, it also increased the jurisdictional amount cognizable, okay, by the MTC to in excess of 2 million. So if it's below 2 million, then it will have to be filed with the MTC. Now, with respect to probate matters, testate and intestate, the inferior courts of jurisdiction, of course, provided that the gross value of the estate does not exceed 2 million pesos, right? Okay. Now, okay. As far as 11576 is concerned, the jurisdictional amount cognizable by the MTC should be a demand exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, property of which should not exceed 2 million pesos, should be with the MTC. Okay. Now, let me just focus on the MTC. Okay. Ang MTC, pag may nakita kayong question, MTC, okay, ang dapat pumasok kaagad sa isip niyo, ito ba ay small claims? Ito ba ay governed by the rules on summary procedure? O ito ba ay ordinary civil action? Kasi iba-iba yung rules niya. Okay. So before I discuss small claims and revised rules on summary procedure, let's have first that 5-minute break I promised. Okay, let's have a 5-minute break. Thank you. Detainer cases, regardless of the amount of damages or unpaid rentals sought to be recovered. So if it's a claim for unlawful detainer cases, okay, to vacate and pay the amount of 10 million pesos, that is all right. Even if the amount of arrears you're seeking to be paid is in excess, okay, of the usual of 2 million pesos. Why? Because for forcible entry and unlawful detainer cases, the principal and only issue there is what? One of possession. And the amount is only incidental. But your attorney's fees should not exceed 100,000 pesos. Now, if the amount is in excess of what siningil mo yung kliyente mo, more than 100,000 pesos, hindi ka makaka-claim ng more than 100,000 pesos. Second, all civil actions except probate proceedings, admiralty and maritime actions and small claims falling under Rule 4 hereof, where the total amount of the plaintiff's claim does not exceed 2 million pesos, exclusive, please take note of the word lagi ha, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and costs. So when the probate proceedings, let's say the gross value of the property of the estate is just 1 million pesos, hindi yan small claims. Kasi nakalagay except probate proceedings. Pero sa MTC pa rin siya. Okay, so that's the first implication. And if you want to appeal, let's say it's a what you call this, it's an testate proceedings, my last will and testament, and you want, let's say, to appeal the order approving the will, okay, the probated na yung will, you want to appeal it. Okay, it is an appeal that will require a period of 30 days kasi it's capable, it's a special proceedings capable of multiple appeals, 30 days. May record on appeal. So in-appeal mo sa RTC, talo ka pa rin sa RTC. Is that final and executory? The answer is no, because while it was decided by the MTC, it is not governed by the rules on summary procedure, which means you can technically appeal it to the CA under Rule 42. Okay, on questions of law, on mixed questions of law and questions of fact only. Clear, ha? Kaya medyo kaya yan dapat i-drawing para hindi ka malilito. Okay? Now, complaints for damages where the claim does not exceed 2 million pesos, again, exclusive of interest and cost, do not include the computation of the interest in purposes of determining your jurisdiction. Okay, very important. Okay, this is small claims. I'm sorry, summary procedure. Cases for enforcement of barangay amicable settlements agreements and arbitration awards where the money claim exceeds 1 million pesos, provided that no execution has been enforced by the barangay within 6 months from the date of the settlement or date of receipt of the award, or from the date of the obligation stipulated or adjudged in the arbitration, award becomes due and demandable. So you have a situation where you availed of the katarungang pambarangay. Okay? And then you agreed, o sige, bayaran mo ko 500,000 pesos in 2 months. 2 months came, nothing happened with the compromise settlement. Okay? How do you now enforce it? You file a case before, okay, the MTC. Because that amount does not exceed 1 million pesos. And when you file it to the MTC, yun again, ang una yung tatanungin, ito ba under small claims, under ba ito ng revised rules and summary procedure, or ordinary civil action? Klaro, under the revised rules on summary procedure. Now, again, another new introduction, no? Cases solely for the revival of judgment of the MTC or the inferior courts, okay, pursuant to Rule 39, Section 6. Okay, if you recall Rule 39, Section 6, and if I were you look at it, no? Di ba you can file, there's a judgment, okay, there's a judgment. And the judgment was not executed within 5 years from the time the decision became final, from entry of judgment. That's the law. Was not done by mere motion. Di ba you have to file a petition for revival of judgment? Okay. Saan mo yan ifa-file? Ngayon, napakaklaro. Kung ang desisyon na pinag-uusapan natin is a decision of the MTC, okay, hindi na execute yan within the first 5 years from entry of judgment. You file it with the MTC. But it will be governed by the rules on summary procedure, not ordinary civil action. Clear? Okay. Next is civil aspect of violation of BP 22 or the bouncing check law if no criminal action has been instituted therefore. So if there's a BP 22 case, please do not file a separate civil action to collect the face value of the dishonored check. No. Why? Because the civil aspect, if you file a criminal case, is impliedly instituted and consolidated already with the criminal action. Now, all other cases not included shall be governed by the rules, regular rules of procedure. Okay. Bakit ba kailangan natin alamin kung ito ba ay civil action, small claims, ordinary civil action? Wait. A statement of claims, that's how we call it. Statement of claims. How many days to file a response? Pag small claims, how many days? Diba 10? Response. Meron yung mga hindi pwede mag-file ng reply, di ba? Okay. Meron yung first hearing. The hearing. 1-day hearing, correct? And then you have now your judgment. Okay? Walang hearing. Complaint. Answer, period. Do I look like the law? You can look at the law. It's okay. Period. How many days? 30 days, di ba? 30 days. Okay. My prohibited pleadings. I will discuss that later. I just want you to see why it's very important for you to determine ito by small claims, ito by procedure, revised rules and summary procedure. And then you will have your preliminary conference. Correct? And then 10 days from the submission of your 10 days from your receipt of the preliminary conference order, you will submit your position paper. Right? Walang trial. Okay. Posible magkaroon ng clarificatory questioning. Okay. And then judgment. Okay. The judgment, by the way, is immediately final and executory. Correct? The judgment here is appealable. to the RTC. Right? Okay. Original civil action. RTC. Kunwari, RTC yan. Okay. Or even municipal trial court. Okay. Complaint. 30 days. Answer. Wala nang reply muna. Para madali. Pre-trial conference. Pre-trial order. Trial. Judgment. Of course, may mga pleadings. No? And the judgment, if that's RTC, can be appealed to the CA under Rule 41 or the Supreme Court under Rule 45. And that's the reason why you really need to know what kind of rules will apply. Kasi iba-iba yung rules niya. Kaya pag nagtanong ng MTC, first level courts, ang una niyong sabihin sa sarili, ito ba ay summary procedure or ito ba ay small claims? Kasi ibang kanyang magiging rules. Or ito ba ay ordinary civil action? Kasi pwede pa rin ang ordinary civil action sa MTC. Lalo na pagka probate proceedings. Clear? Okay, now. So small claims, okay, is where the amount does not exceed 1 million pesos exclusive of interest and cost. So in your mind, if collection of sum of money less than 1 million, small claims yan. Pag more than 1 million, it exceeds 1 million, but less than 2 million, revised rules on summary procedure pa rin yan. MTC pa rin yan. In excess of 2 million, RTC na yan. Okay? Exclusive of interest and costs. Diba mas matatandaan natin eh. Okay? Now, a small claim is an action therefore that is purely civil in nature where the claim or relief raised by the plaintiff is solely for the payment or reimbursement of a sum of money. It excludes actions seeking other claims or reliefs aside from payment or reimbursement of a sum of money and those coupled with provisional remedies. Which means, okay, kung ang amount mo is 1 million or 900,000, humingi ka ng preliminary attachment. Huwag ka na mag-small claims. Revised rules on summary procedure yan. Clear? Okay. Now, the claim or demand may be for money owed under any of the following: contract of lease, contract of loan, and other credit accommodations, contract of services or contract of sale of personal property, excluding the recovery of personal property unless it is made subject of a compromise agreement, or the enforcement of a barangay amicable settlement agreements and arbitration awards where the amount claimed does not exceed 1 million pesos. Provided, again, no execution has been enforced, okay, by the barangay within 6 months from the date of settlement or date of receipt of the award, or from the date of the obligation stipulated or adjudged in the arbitration becomes due and demandable. Okay. Exact question. Kita niyo ako tumatawid dyan. Sabi niyo, labo nito. Kunwari reviewer, di ko naman maintindihan, sagasaan ko nga. So sinagasaan niyo ako. Okay? Sinagasaan niyo ako. So nagkabali-bali ang aking buto. Okay, ang mga ano. Tapos pumunta ako, basta na sinagasaan niyo ako. Tapos nag-claim ako ng damages on the basis of tort. Di naman niyo ako talagang sinagasaan totoanan. Negligently lang, kunwari. Sinagasaan niyo ako negligently. Okay? Tapos, I claimed for, let's say nga, mga tipong 500,000 pesos. And ang base sa kwento ko, it was negligent. No? Tumatawid ako, hindi nyo inapakan, naapakan nyo yung, instead naapakan nyo yung brakes, ang naapakan nyo naman yung accelerator dahil manghang-mangha ako dahil tumatawid ako. Yeah, nasa gasaan. Then I filed it before the MTC and the judge used small claims, the rules on small claims. Tama ba yon o hindi? Tama ba yun? 500,000. Talagang sasagasaan niyo ako kung di ko sasabihin ang answer. Of course, the answer is no, not covered by small claims. Kasi look at the amount, money owed. Utang ba yun? Number one, hindi. Contract of lease, contract of loan, contract of services, contract of sale of personal property excluding the recovery of the property. Dapat hindi kayo hingi ng writ of replevin. Okay? Hindi naman ako, miski mukha akong tanod bayan, pero hindi naman to enforcement of barangay, di ba? Hindi rin kasama. So anong mangyayari? MTC pa rin siya, but the amount is less than 2 million, okay? It will still be with the MTC, but it will not be governed by small claims. It will be governed by the rules on summary procedure. Clear? Okay. Pansin ninyo sa revised rules and summary procedures, sa small claims at sa ordinary civil action, lahat yan may prohibited pleadings. Okay, now, the common general provisions for revised rules and summary procedure and small claims. The following pleadings, motions, or petitions shall not be allowed. Okay. In civil cases, a motion to dismiss the complaint or the statement of claim. In criminal cases, a motion to quash the complaint or information, except on the ground of lack of jurisdiction over the subject matter or failure to comply with the requirement of barangay conciliation. So the defendant can file a motion to dismiss, can file in small claims and revised rules and summary procedure only on two grounds: lack of jurisdiction over the subject matter and failure to comply with the barangay conciliation. Don't file a motion to hear or resolve affirmative defenses. Don't file a motion for bill of particulars. Okay. It is prohibited for you to file a motion for new trial, motion for reconsideration of a judgment on the merits, or for reopening of proceedings. Okay. Question. Nag-file ng note, may natanggap ka notice of preliminary conference. Hindi ka naka-attend. Okay? Kasi nagkasakit ka ng COVID. Okay? Tapos, dininay yung motion mo to postpone. Okay? You filed a motion for recon on the motion to postpone, on the denial of your motion to postpone. Example, ha? Okay, para mas may figures. Okay, so you receive a notice of preliminary conference. Ang hearing, let's say, August 1. Okay. July 25, nag-file ka na kaagad ng motion to postpone on the ground na may COVID ka. At based on the rule, existing rules, no, health protocols, hindi ka pwedeng lumabas sa August 1. Nakatanggap ka ng order ng court the following day nung final mo, August 26, denied. Itutuloy daw. File ka ng MR the following day. Imagine may COVID ka, nagpa-file ka pa ng pleading sa denied. Okay, denied. Okay, denied. The court denied your motion for recon on the ground that is a prohibited pleading. Is the court correct? Is the court correct? Okay, I will repeat. You received an order setting the case for preliminary conference August 1. On July 25, you already filed your motion to postpone on the ground that you are COVID-stricken, and based on the health protocols, you cannot physically appear, okay, even participate in the video conferencing August 1. The following day, the court issued an order. You received it because it was sent by email, okay, denying your motion to cancel hearing. The following day, you filed a motion for reconsideration, and it was denied on the ground that a motion for reconsideration is a prohibited pleading, and therefore no other choice. Your MR has to be denied. If did the court, okay, validly rule on the denial on that specific reason? Yes or no? Who says yes? Who says no? Why? Secret. Okay, yan ang sagot. Kasi ayaw nyo naman sabihin, secret. Okay. Tama kayo doon. Wrong. Why? Because it's not a judgment on the merits. Ang nakalagay dito, okay, ang bawal, is a motion for new trial or reconsideration of a judgment on the merits. The order denying the motion to postpone is only an interlocutory order. or for the opening of proceedings. Kaya talagang pwede kang mag-file ng MR kasi it's an MR on an interlocutory order, and that's the case of Fabros versus Duncan. Okay. Bawal din to file a petition for relief from judgment, which, by the way, a petition for relief from judgment, pwede yan sa ordinary civil action. Okay? Motions for extension of time to file pleadings, affidavits, or any other paper. Small claims, revised rules on summary procedure, talagang di ka pwede mag-extend, miski pa yan answer. But ordinary civil actions, yung cases governed by ordinary civil actions, yes, it is true that you cannot file a motion for the extension of time to file pleadings, except when you want to file an answer. You can ask for a period of 30 days, only once. Motion to declare defendant in default, dilatory motions for postponement, unless it's grounded on acts of God, force majeure, or physical inability of the witness or the counsel to personally appear in court as supported by affidavit and medical proof. You cannot file rejoinder. You cannot file third-party complaints. You cannot file the motion for complaint in intervention or motion to admit late judicial affidavits, position papers, or other evidence except on the ground of force majeure or act of God, and motion for judicial determination of probable cause in criminal proceedings. So clearly, if you read the prohibited pleadings, those prohibited pleadings are not the same as the prohibited pleadings under ordinary civil action. Okay, now, for the first time, it is stated in the revised, in the expedited rules, that video conferencing is, as far as practicable, it may be allowed at any stage of the proceedings. Kaya dapat sa mga babae, maglagay naman kayo ng makeup, no? Para naman telegenic kayo. Matalo man kayo, telegenic naman kayo. Okay, anyway, okay. Now, sa mga lalaki, basta may barong at saka nakasuit. Okay na yung shorts, no problem. Hindi naman kita yan. Okay. Service, okay, pursuant to international convention, service made pursuant to the Hague Convention on the service abroad of judicial and extrajudicial documents shall be valid, and the period to answer shall commence from the receipt of the document. Okay. Now, let me now discuss, okay, rule on summary procedure. Okay. All pleadings must be verified. And the only pleadings allowed are the complaint, the compulsory counterclaim, the cross-claim which will be pleaded in the answer, and the reply. Walang rejoinder. Okay. Now, all pleadings must be verified. And all pleadings submitted under this rule shall comply with Rule 7 of the 2019 rules. Okay. Now, please take note that when we speak of complaints now, and even the answer, it must not only state it must not only be based on the ultimate facts, but also must contain the evidentiary facts. Okay. Now, all cases requiring prior referral to the barangay conciliation is a must, and it must be alleged in the complaint. In fact, when there is no showing of compliance with such requirement, the complaint shall be dismissed without prejudice on the court's own initiative or upon motion by the defendant, and may be refiled only after the requirement has been complied with. Question. The case was dismissed, okay, by the court motu proprio, because based on the allegations of the complaint, there was nothing on prior referral to the barangay. Eh, magkapit-bahay sila. Okay. Can you appeal the dismissal? Okay. Thank you for, I'm listening to him kasi look at his processing. Sabi niya, without prejudice, no. Very, very true. Kasi it's without prejudice. You don't appeal, you refile. But you must comply first kasi i-dismiss ulit yan, di ba? So sometimes, that's the reason why sometimes, if I listen to you, you say it, I can read naman. I'm, on the side, I am a lip reader, okay? Because I was trained by my students who just talk to each other without reciting, no? So I can read it. Anyway, nakikita ko yung processing. Importante yun eh. Okay, unang sabi niya, no? Walang prejudice to ah. O, tama sagot niya, no. Kasi kung ang dismissal niyan ay with prejudice, teka muna, pwede ko itong i-appeal. Diba? Pag revised rules on summary procedure. Okay, now, imagine yourself now, you are going to prepare a complaint which is governed under by the rules of summary procedure. Okay. The names of the affiants, okay, the complaint shall state the following. Of course, just story, no? Okay, dapat may ultimate facts yan. Ano yung ultimate facts? Ultimate facts are those facts or factual allegations that you cannot strike off. Otherwise, you will have no cause. If you strike it off, you will have no cause of action. It has to be there because otherwise, without which, walang cause of action. Example, okay, sorry, I'm just going to be very basic, okay? Kasi my form. On February 14, 2019, the plaintiff, while wearing her black suit, okay, borrowed money from the defendant while he was wearing his red shorts, period. Sa sentence na yan, kailangan ko ba sabihin ko ng kulay ng damit nila? Hindi. May kaugnayan ba yan sa cause of action ko? Hindi. So take it out because that's not an ultimate fact. Pero kung sinabi ko, on February 14, 2021, while the defendant was wearing black suit and the defendant is wearing red shorts, period. Meron ba akong cause of action? Wala kang kwento. Palagay ko sa fashion show ang gusto mong puntahan, no? So clear ha kung ano yung ultimate facts. Always remember this because you have that part in the exam that you might be asked to prepare a pleading. Okay? Number 2, okay, you have to attach your judicial affidavits. Okay, which shall form part of an integral part thereof. The judicial affidavits not attached to the complaint shall not be considered. Compare that requirement, you cannot attach the judicial affidavit. Kung original civil action yan, yung ordinary civil action, di ba may period, pwede ka pa nga mag-reserve pag pre-trial. Di ba? Pwede ka mag-reserve. You just have to state the name, the gist, and the purpose. Okay? Of course, may rason kung bakit, di ba? Now, pero pag summary procedure, walang reservation allowed. In fact, judicial affidavits not attached to the complaint shall not be considered. Then the summary of the statements in the judicial affidavits, the documentary and other object evidence in support of the allegations of the complaint, okay, which means from A to C, you have to comply, you have to show your ultimate facts and your evidentiary facts. So, kwento, statement, no? Your facts. And then, of course, your JAs, and then a list of the summary of the statements in the JAs, and then, of course, the documentary and other object evidence in support of the allegations of the complaint. And then you have to have a statement there that you consent, whether the plaintiff consents to service by electronic means or facsimile, and if so, the plaintiff's email addresses or facsimile numbers of such purpose. Okay, now, after the complaint is filed, the court is given a 5-day period from receipt of the new civil case, okay, and if it falls within the rules of summary procedure, it shall direct the court to issue summons stating that the procedure, sa summons talaga nakalagay doon, stating that the case shall be governed by the rules on summary procedure. Ano yung 5-day period na yon? Kasi doon titignan ng court kung pwede ba i-dismiss niya motu proprio yung case. Okay, now, and this is what I want to discuss section 4. Look, however, if from an examination of the allegations in the initiatory pleading and such evidence as may be attached thereto, a ground for the outright dismissal of the case is apparent, the court may dismiss the case on its own initiative. These grounds include lack of subject matter jurisdiction, improper venue, lack of legal capacity to sue, litis pendentia, res judicata prescription, failure to state a cause of action, non-submission of a certification against forum shopping, lack of compliance with the condition precedent, such as absence of barangay conciliation, among others. Okay. Now, pag nakita yung court, no jurisdiction over the subject matter. Okay, over the subject matter. Dalawa ang posibleng mangyari dyan. The defendant can file a motion to dismiss. Correct? The defendant, okay, or the court may dismiss the case motu proprio. Okay, second. The court, okay, notice okay, yung pangalawa is a situation wherein there is no allegation as to the prior referral to barangay conciliation when it should be. Okay. Nakita ng court, the court may dismiss the case motu proprio or the defendant may file a motion to dismiss. Okay. Let's assume, okay, ang kaso, let's say, is plaintiff lives in Manila, defendant lives in Quezon City, okay, but plaintiff filed it in Antique because he wants to swim in Boracay after the hearing. No? So sa Antique, gusto niya may staycation siya doon. Nakita ngayon ng Antique Court. Can the defendant file a motion to dismiss? The answer is no. But can the court dismiss the case motu proprio on the ground of improper venue? The answer is yes. Because of section so be very careful. While the defendant cannot file a motion to dismiss. In other words, if he wants to raise improper venue, he has to file an answer and raise it by way of affirmative defense. Be that as it may, under the rules on summary procedure, the court can dismiss it motu proprio. Ano yung mga grounds na yun? Ulitin lang natin. Improper venue, lack of legal capacity to sue, litispendentia, res judicata, prescription, failure to state a cause of action, non-submission of a certification against forum shopping, and lack of compliance with the condition precedent, such as absence of barangay conciliation, among others. Okay. I'm sorry, but let me just compare it to ordinary civil action. As I said, for example, it's improper venue. Pag rules on summary procedure, the defendant cannot file a motion to dismiss on the ground of improper venue. But the court on its own can dismiss it. Clear. Compare that with your 2019 rules on ordinary civil action. Improper venue. Defendant cannot file a motion to dismiss. Correct? The defendant has no other choice but to file an answer and raise it, okay, by way of affirmative defense. But under the ordinary rules on ordinary civil action, the court cannot on its own dismiss the case on the ground of improper venue, because there is only 4 grounds where the court can dismiss a case under ordinary civil action, and that is lack of jurisdiction over the subject matter, litispendentia, res judicata, and prescription, which I always lovingly call as apat na sikat. Yung apat na sikat, yan lang yung motu proprio dismissal under or pursuant to Section 1 of Rule 9. Clear? Clear yan, ha? Clear. Okay. Now, filing and service, same as Rule 14. Answer now is 30 days from service of summons. And the answer shall state, again, the name of the affiants whose judicial affidavits will be presented to prove the defendant's allegations. The judicial affidavit shall be attached to the answer and form part of the answer. And the judicial affidavits attached to the answer the judicial affidavits not attached to the answer shall not be considered at all. The summary statements of the JAs, the documentary and other object evidence in support thereon, and whether the defendant consents to the service by electronic means or facsimile, and if so, the defendant's email addresses or facsimile numbers for that purpose. Affirmative answers not pleaded in the answer shall be deemed waived, except lack of jurisdiction over the subject matter, litispendentia, res judicata, and prescription. Cross claims and compulsory claims not asserted in the answer shall be barred. Okay, now let me discuss counterclaims with respect to the rules on summary procedure. Okay. If at the time the action is commenced, the defendant possesses a claim against the plaintiff that is within the coverage of the rule, exclusive of interest and cost. Ang utak, sige, basahin ko muna yung rules as magbibigay tayo ng example. Arises out of the transaction or event that is subject matter of the plaintiff's claim, does not require for its adjudication the joinder of third parties, and is not subject of another pending action, the claim shall be filed as a counterclaim in the answer. Otherwise, the defendant shall be barred from suing on such claim. Okay. I filed a case against him for, let's say, 1.5 million collection case, these rules on summary procedure. Sabi niya, hindi, bayad ko na yan. Because of the filing of this unfounded suit, I suffered sleepless nights, mental anguish, and besmirched reputation, for which I should be held liable for 2 million. Okay, sobra naman ang mahal ng kanyang besmirched reputation. Anyway, basta niraise niya 2 million. Pwede ba yun? Okay. Ay, hindi pala, 2.5 million. Okay. Notice that the amount should not exceed, okay, the amount covered by the rules. So hindi pwede siyang in excess of 2 million. Now, did the counterclaim arise from the same transaction or series of transactions? The answer is yes, because precisely it is because of the claim I filed against him. It does not require for its adjudication the joinder of other parties, and it's not the subject of another pending action. Clearly, it is a compulsory counterclaim. If he does not raise it, barred. Okay, now, can you file a permissive counterclaim? Same, second paragraph. The defendant may also elect to file a counterclaim against a plaintiff that does not arise out of the same transaction or occurrence, provided that the amount and nature thereof are within the coverage of this rule and the prescribed docket fee and other legal fees. Any amount pleaded in a counterclaim in excess of 2 million, excluding interest and cost, shall be deemed waived. So I filed a case against him for 1.5. Okay. And then sabi niya, okay, so that's promissory note 1. He raised by way of answer, hindi, may utang ka sa akin worth 3 million pesos based on promissory note number 2, which he attached to his answer. Okay. Then his prayer was, dismiss the complaint and pay me, order daw me to pay him 1.5. Kasi 3 million, 1.5, di ba? 3 million, 1.5. So sabi niya, i-dismiss, i-set off yung 1.5 do sa 3 million at yung excess na 1.5 million, bayaran ko ba daw siya? Okay. Is that allowed? The answer is this. Okay. Based on the rules. Remember, should be covered by the claim. So dapat hanggang 2 million. Right? Dapat yun, i-dismiss lang niya yung complaint. But he cannot ask that I pay him 1.5 because the claim will be in excess already of the 2 million. So dapat yun, i-raise mo yung counterclaim, the permissive counterclaim, and just ask for a dismissal because of the setting off. And that's it. You cannot insist and ask the court to order me to pay you 1.5 because if I be ordered the setting off of the 1.5 and the plus 1.5 I have to pay, that's 3 million. That's already in excess of the court's jurisdiction when it comes to summary procedure. Cannot be. So your prayer should be dismissed. Ma'am, anong mangyari sa 1.5 ko? Di mag-file ka ng sarili mong complaint to recover the 1.5. Clear. Because the rule is, this is what the rule says. The defendant may also elect to file a counterclaim against the plaintiff that does not arise of the same transaction or occurrence, permissive counterclaim, provided that the amount and nature thereof are within the coverage of the rule. So dapat yung counterclaim mo, hindi, miski yan permissive, hindi lalagpas ng 2 million. And the prescribed docket and other legal fees are paid. Any amount pleaded in a counterclaim, whether permissive or, okay, or compulsory, in excess of 2 million, excluding interest and cost, shall be deemed waived. Clear? Okay, now, reply. All new matters alleged in the answer shall be deemed controverted. So pag may complaint answer, pinaglalabanan na yan, di mo na kailangan mag-file ng reply kasi deemed controverted. However, the plaintiff may file a reply to a counterclaim only when an actionable document is attached to the answer. The reply shall be filed within 10 calendar days from receipt of the answer. So you have a complaint, you have an answer. And the answer does not contain a counterclaim. Okay, does not. Huwag ka na mag-file na reply, miski sabihin mo lahat na sinabi nitong defendant ay sinungalingan. Anyway, it's deemed controverted. Okay. Complaint. Answer. Yung answer may permissive counterclaim based on a promissory note. Promissory note number 2, for example. You want to deny the due execution and authenticity of that promissory note number 2, okay? Then you can file a reply. But that actionable document must be attached to the answer. So even if, let's say, there's promissory note number 2, but it was not attached to the answer, that is not an actionable document, which means you cannot file, you should not file a reply. Still deemed controverted. Clear? Okay. And the reply shall be filed within 10 calendar days from receipt of the answer. Now, what is the failure to file an answer? Okay. Kung ordinary civil action yan, kung ordinary civil action, okay, di ba magpa-file ka ng motion to declare defendant in default? Pero dahil ito ay rules on summary procedure, prohibited pleading ang motion to declare defendant in default. So anong gagawin mo pag ikaw ay nakakita na pag walang answer? Okay. Should the defendant fail to file an answer to the complaint within the period provided, the court on its own, without you filing anything, can order that the case be submitted for decision and can render judgment based on the allegation statement stated in the complaint and its attachment, but the judgment shall be limited to what is prayed for therein. Hindi pag which means kung 100,000 pesos ang let's say 1.5 million pesos ang hiningi mong bayad sa'yo, pero binigay naman ng court sa'yo 1.8. Swerte mo, pero mali yung court. Kasi it should be limited to what is prayed for. Okay. Or, walang ginagawa yung court. What will you do? Kunwari yung court, sa dami ng trabaho, nakakalimutan lang i-submit for judgment yung complaint. What you can do is you file a motion. No, I'm sorry. I take it back. I take it back. You file a manifestation. You file a manifestation stating that the complaint, the summons was served on the defendant on this date, together with a copy of the complaint, as based on the sheriff's return. And therefore, the deadline is this, and the deadline, let's say, to file an answer is this date. And to date, no answer has been filed despite the lapse of the reglementary period. Respectfully submitted. Period. Pirma, copy furnish kabila, submit in court. Just a mere manifestation. You don't even have to file a motion. Kasi it says here in section 9, on its own initiative or upon manifestation by the plaintiff that the period for filing an answer has already lapsed, shall render judgment as may be warranted by the facts alleged in the complaint and its attachments, limited to what is prayed for. Okay. But even if, no answer has been filed, the court may reduce the amount of damages and attorney's fees for being excessive or otherwise unconscionable. Clear. Please do not file a motion to render judgment based on the complaint. That is the rule of the old. Na-amend na yan. All you have to do is file a manifestation saying that the period for filing an answer has already lapsed. But kaya kailangan pakita yung date of receipt ng summons, yung deadline, at saka yung fact na hanggang ngayon hindi pa nakaka-file despite the lapse of the deadline. Clear. The rules on preliminary conference as stated in Rule 18 of the 2019 rules may be applied, suppletorily unless it is inconsistent. And when you get your notice of preliminary conference, the date of the preliminary conference will be stated, the date when the court annex mediation will be held, and the JDR in the court's discretion. No? Now, non-appearance either in the preliminary conference, the JDR, and the court annex mediation shall be deemed as non-appearance during the preliminary conference. And that is the same rule even with respect to the pre-trial conference which is being held under the ordinary rules of civil procedure. Okay. Ang schedule ng preliminary conference, August 5. Count 3 days before. That will be August 2. You have to submit your pre-trial brief. Same rule, with respect to ordinary civil actions, The party shall file with the court and serve on the other party in such a way to ensure receipt. So wag ka mag-file ng by registered mail on August 2 kasi the other party will not be able to receive it. at least 3 calendar days before the scheduled preliminary conference, which pre-trial brief will contain, preliminary conference brief will contain the following. A summary of the admitted facts. Okay, before I go into it, seryosohin nyo yung pre-trial brief nyo, especially kung magiging abogado na kayo. Why? Because it will make your life very easy. Why? Because the pre-trial brief will contain the following: the summary of admitted facts. When you say summary of admitted facts, those are the facts which were admitted by the defendant in the answer. And based on the rules of evidence, if it has already been admitted, no need to present evidence. Diba? Hindi ka na, because it is already an admitted fact. And then part 2 will be a summary of the disputed facts, okay? And proposal for stipulations, okay? Gusto mong ipastipulate. Ngayon, kung in-stipulate yan, wala na naman tayong presentation of evidence required. Okay, so it's a proposal. A statement of the factual and legal issues, a list of testimonial, object, and other documentary evidence offered in support of the parties' claims or defenses. And failure to submit your preliminary conference brief will have the same, okay, sanction as non-appearance. Same rule when it comes to pre-trial brief submitted, non-submission of pre-trial briefs and cases of ordinary civil action. Okay, now, it shall be the duty of the party and the counsel to appear at the preliminary conference, court annex mediation, and the JDR. The JDR only if it is ordered by the court. The non-appearance of a party and or counsel may be excused only for acts of God, force majeure, or duly substantiated physical inability. Okay. The client may appear through an agent or an agent. Now, if it is kunwari, Jollibee, okay? Hindi si Jollibee the mascot ang pwedeng umapir, no? Cannot be. Tao basta may dala-dala siyang special power of attorney, okay? Pero kung ako yung judge, baka payagan ko. Type ko si Jollibee. Joke lang, okay. So a representative may appear on behalf of a party but must be duly authorized through a special power of attorney or a board resolution. Pero yung SPA at saka yung SPA or yung SECSER or yung board res must specifically contain these three. Has the power to enter into an amicable settlement, has the power to submit to alternative modes of dispute resolution, has the power to enter in stipulations or admissions of facts and documents. It has to be stated. Why? Because it's very clear from the law, an authority which fails to include any of the three shall be ineffective and the party represented shall be deemed absent. Okay? Importanteng nakapaloob yan sa SPA o sa SECSER. The failure despite notice of the plaintiff or his counsel to appear at a preliminary conference shall be a cause for the dismissal of the complaint. Okay? As I said, nag-file ka ng kaso, hindi ka makapunta, o sige, si attorney binigyan mo ng SPA. Pero yung SPA, wala kang binigay na authority for him to appear before court annex mediation. Sinabi ng kapila, Your Honor, okay, the SPA does not contain the power to appear before the court annex mediator. Anong mangyayari? The court will consider the plaintiff absent and will now cause the dismissal of and the other party can move for the dismissal of the complaint. So the defendant who appears in the absence of the plaintiff shall be entitled to the judgment on the counterclaim in accordance with Section 9 of this rule. All cross claims shall be dismissed. Okay. Now, if a sole defendant, isang defendant fail or his counsel, okay, kasi dapat defendant and counsel, isa lang sa kanilang dalawa absent, okay, it shall what? Cause the plaintiff to be entitled to the judgment in accordance with Section 9, which means submitted for decision, court can render a decision based on the allegations of the complaint, but limited to what was prayed for. But this rule will not apply if you have more than two or more defendants. Now, this rule will not apply where one of the two or more defendants sued under a common cause of action and who had pleaded a common defense shall appear at the preliminary conference. Why? Because the answer that was filed by the defendant who was sued on the same common cause of action and who pleaded the common defense, okay, will inure to the benefit of the absentee defendant. Pero kung iisa lang, pag hindi umapir, ay patay. Okay? Then the plaintiff will be entitled to a judgment. Okay, now, after the preliminary conference, okay, you will receive a preliminary, okay. So preliminary conference, pwede na kayong i-refer sa court annex mediation or kung hindi, and you're given only a period of 30 days within which to what you call this, to have the preliminary conference mediation. And if it failed, you can be referred to, based upon the discretion of the court, okay, to a judicial mediation. If both failed, okay, if it both failed, then, okay, the court shall issue a preliminary conference order, okay? Now, this preliminary conference order, you will receive it. And upon receipt, you're given a period of 10 days within which to submit your respective position papers. Please take note that no other judicial affidavits or evidence will be admitted if that said judicial affidavit was not filed together with the complaint or the answer. Hindi nyo pwedeng, sasabit ko na lang to sa position paper. It will not be considered. Clear? Okay. Any questions so far? Okay. Now. Okay. And then the court has the right to hold a clarificatory hearing or require the parties to submit additional judicial affidavits. Okay. Now, what will happen after that? Okay. Okay. Appeals in summary procedure. Can I now refer you to C, section 1 and 2? And this is very important. If there's one question, I think it will be asked, this will be it. Kasi bagong-bago eh. Okay. Ordinary appeal. Any judgment, final order, or final resolution in a summary procedure may be appealed to the appropriate RTC, exercising jurisdiction under Rule 40 for civil cases. Notice, I'm not talking about civil cases kasi ordinary civil procedure lang ako. Under Rule 40. Okay? So Rule 40 of the Rules of Court will apply. The appeal shall be taken by filing a notice of appeal, of course, with proof of payment of the appeal fees. And where do you file it? With the court that rendered the judgment, the originating court, within 15 calendar days from receipt of the same. Okay. Now, section 2 is very important. What is the remedy from judgment on appeal? The judgment of the RTC, acting as an appellate court this time, on appeal shall be final, executory, and unappealable. Therefore, you cannot appeal it under Rule 42. Example, since unlawful detainer and forcible entry cases are cases governed by the rules of summary procedure, the decision of the MTC, you appeal it to the RTC. But once the decision of the RTC has been received by you and by the other party, it becomes final and executory. You cannot appeal the RTC decision as an appellate court to the CA because of this provision. Clear? Okay. Now, before I go to small claims, let me just clarify something. Plaintiff received the judgment July 1. Okay. Therefore, it has until July 16 to appeal it. Right? Okay. Defendant received the judgment July 5. Therefore, it has until July 15 to appeal. Question. When will the judgment become final and executory when no appeal was made? When? July 17? July 20? Or July 21? Who says 21? Who says 20? July 21. Because itong period na to, pwede pang mag-appeal yung defendant eh. So kung hindi ito nag-appeal, the decision becomes final and executory. And because it is final and executory, then that will automatically be your entry of judgment. Okay, which means, kung nag-file, let's say, parang hindi kayo malito. Okay. Defendant's spirit to appeal, no? Okay. Nag-appeal ang... Okay, nag-file ng appeal ang plaintiff July 13. Appeal ha? Appeal July 13. Ang defendant file 20. 17, defendant filed a motion for reconsideration. You follow? The plaintiff within the period of appeal filed a notice of appeal July 13. Remember, he has until the 15th, the 16th within which to appeal. 13 nag-file siya. Si defendant received the judgment July 5, therefore he has a period of until July 20 within which to appeal. Correct. Instead, he filed on July 15, okay, which is obviously after the 13, a motion for reconsideration. Does the trial court have jurisdiction? Okay, does the trial court have jurisdiction to still hear his motion for reconsideration, even if the plaintiff already filed an appeal? In the example, okay, plaintiff received the judgment July 1. Therefore, he has until July 16 within which to file an appeal. But he filed his appeal July 13 within the period to appeal. The defendant, on the other hand, received the decision July 5. Therefore, he has a period until July 20 to file his notice of appeal. But instead of appealing, on July 17, he filed a motion for recon. Okay. Naunang nag-file si plaintiff ng notice of appeal. Si defendant nag-file ng MR. Okay. Within the period to appeal. Ang tanong, can the court still hear and decide the MR that was filed by the defendant, considering that the plaintiff has already filed a notice of appeal? Why? Ang tanong nung madaling tumango you know? Miski yung aso nakalagay doon sa ganon, tumatango yun, pero kausapin mo walang sagot, diba? Okay. Now, ang tanong, bakit? Why? Because the appeal has not been perfect. Your answer is right. I could hear from this side. Yes, the trial court still has jurisdiction to decide and hear and decide the motion for recall because the appeal has not been perfected as to both of the parties and as to the court. Na-perfect lang siya doon sa plaintiff kasi siya yung nag-file ng notice of appeal. But not as to the court and as to the other party because the party has until the 20th. Yes. Okay, to file or to avail of the post-judgment remedies. Clear? Kaya ko yan lang pinag-uusapan kasi nga, kailan ba nagiging final and executory and unappealable? Pag in this particular case, sa rules and summary procedure, walang period. Pagtanggap mo lang kasi hindi na nga siya appealable Pagtanggap mo pa lang. Pagtanggap ng kabila, pagtanggap ko, that's it, pansit, walang appeal. Okay? Nagiging final and executory na kagad siya. Clear? Okay. Okay, now let's discuss lang the procedures sa small claims. Okay, the rule on small claims is therefore applicable before the first level courts. Walang small claims sa second level courts. I will deny you to the highest heavens if you say talaga na may small claims, you know. Anyway, and the value, okay, and when you speak of small claims, it is for the payment or reimbursement of a sum of money where the value of the claim does not exceed 1 million pesos. Okay, now, okay, what you file is not a complaint. What you file is a statement of claims with verification and certification against foreign shopping, against splitting a single cause of action, and multiplicity of suits. Okay? And you have to attach to that statement of claims certified through copies of the actionable documents subject of the claim, the affidavits of witnesses. Notice, it's not JA, it's just affidavits of witnesses and other evidence to support the claim, with as many copies thereof as their defendants. No evidence shall be allowed during the hearing which was not attached or submitted with the statement of claims unless there is a good cause is shown for the submission of additional evidence. Hindi katulad sa rules and summary procedure, talaga you cannot attach any judicial affidavit. Pag hindi mo present any judicial affidavit and attach it on the position paper kung hindi mo inattach dun sa complaint or sa answer. Here, the rule is, okay, your statement of claims, you attach the affidavits, and it will not be considered if you fail to attach it unless there is good cause shown for the admission of the additional evidence. And the plaintiff must state in the statement of claim that he or she is engaged in the business of lending, banking, and similar activities, and the number of small claims filed within the calendar year, regardless of judicial station. Why? Because it will have it has an effect on venue. For juridical entities, board resolution or SEC cert authorizing the person to file the claim must also be attached in the statement of claims. No formal pleading other than the statement of claims described in the rule is necessary to initiate small claims. Venue. Okay. General rule, follow Rule 4. If it is obviously personal, no, kasi claim place where the defendant or the plaintiff or the defendant resides at the option of the plaintiff, right? Okay. However, and this is the reason why you have to allege that the plaintiff is engaged in the business of lending, banking, or similar activities. There is a specific venue rule. If the plaintiff is engaged in the business of lending, banking, and similar activities and has a branch within the municipality or city where the defendant resides or is holding business, the statement of claims shall be filed in the court of the city or municipality where the defendant resides or is holding business. If there are two or more defendants, it shall be filed in the court of the city or municipality where any of them resides or is holding business at the option of the plaintiff. Kunwari, okay, ang lending company, ABC Lending Company, but the main office is in Mandaluyong. Pero yung lending company na yun may branch in Marikina. Okay, in Marikina. Nagpautang sa isang defendant na nakatira sa Taytay, Rizal. Okay, sa Taytay, Rizal. Ay, hindi. Masyadong palayo na tayo ng palayo. Bumalik tayo sa Marikina muna, okay? Ulit, okay? May, what you call this, mayroong main office is in, let's say, Quezon City. May branch office in Marikina na ang nangutang sa kanya sa taga Marikina. Okay? And it is engaged in the business of lending, okay? ABC Lending Corporation. Okay, where will you file the small claims case? It is going to be in Marikina, okay, where it shall be filed in the city of the court or municipality where any of them resides or is holding business at the option of the plaintiff. Now, can you have a joinder of claims? We all know that you can, di ba? But it should not exceed 1 million pesos. But can you join this? Okay, kunwari nangutang sa akin si Adrian. Okay? My favorite estafador. Anyway, okay. Defendant, basta ikaw lagi defendant, ako lagi bida. Okay. Nangutang siya sa akin 500,000 pesos. Okay. And then, okay, nangutang siya sa akin 500,000 pesos, promissory note. Pero he's also my lessee. Nangupahan siya sa akin. And he pays me, let's say, 500,000 pesos. And then you lease the property to me, let's say, for about, let's say, 20,000 pesos a month. You did not pay. May accrued ka, okay, may accrued na unpaid, let's say, 300,000 pesos. Okay. Can I file a small claims against you? I will repeat. Okay. Adrian borrowed money. Adrian is my lessee. And under our lease agreement, okay, under our lease agreement, he should pay me, how much did I say? 20,000 pesos a month. Okay. And then, so he has been paying 20,000 pesos a month. And then he borrowed money from me, 500,000 pesos. At the time he borrowed money from me, I gave him 1 month within which to pay the 500,000. And despite the due date that was given to him, okay, he did not pay. So he owes me 500,000 pesos. Despite demand, he did not pay. And on the day he did not pay, he has already been in arrears for 3 months already. Okay? So 20 times 3 months, 60,000 pesos. So I sent him a letter. Okay, I said, Adrian, pay me my 500,000 pesos. And because of your failure to pay 3 months, okay, you pay me the 60,000 and vacate the premises. Then, hindi siya nagbayad. Inad ko, 500 plus 60, 560. I filed a small claim case against him. Now, is that the right action I filed? Okay. Depende yan eh. Kung to collect lang the payment, 560, okay, small claims. Pero kung gusto ko siyang paalisin, okay, at kasi gusto kong kunin na yung property, 500 small claims, tapos yung isa, unlawful detainer. Tapos doon ko habulin yung 60. Hindi ko sila pwedeng i-join. Kasi iba yung rules eh. Yung isa covered man small claims, isa covered by the rules on summary procedure. Pero kung gusto ko lang kolektahin, hindi ko siya paalisin. Dahil crush ko nga siya, di ba? Miski siya estapador, okay? Gusto ko lang bayaran niya ako ng 560. Sige, pwede small claims. But I cannot make him go out. Clear? Okay, so affidavits must be, the affidavits required under this rule must be facts based on facts of direct personal knowledge or based on authentic records which are admissible in evidence. So cannot be hearsay, okay? In fact, it's going to be inadmissible and may therefore be expunged from the records. Okay, okay. Okay. Dismissal of the claim after the court determines that the case falls under the rules on small claims. It may, from the examination of the allegations, okay, can dismiss the statement of claims outright on the following grounds. Court has no jurisdiction over the subject matter. There's another pending action between the parties. Res judicata, statute of limitation. Court has no jurisdiction over the defendant. Venue improperly laid, plaintiff has no legal capacity to sue, prescription, no cause of action. That the condition precedent for the filing of the claim has not been complied with and plaintiff failed to submit the required affidavits. And the order of dismissal shall state whether it's the dismissal is with or without prejudice, okay? Now, if during the hearing the court is able to determine that there exists a ground for the dismissal of the statement of claims, the court may on its own dismiss the case even if such ground is not pleaded in the defendant's response. If the plaintiff misrepresents that it is not engaged in the business of lending, banking, or similar activities, tapos yung pala he is so engaged, the statement of claims will be dismissed with prejudice and plaintiff shall be meted the appropriate sanction, including citation for direct contempt. Notice, direct contempt yan ha, hindi indirect contempt. However, if the case does not fall under the rules on summary procedure, under the rules on small claims, but falls under summary or regular, or if the case is filed under summary or regular procedure, but falls under small claims, the case shall not be dismissed. Final, okay, 500,000 pesos. Okay, pero final at ang ano pa doon, nilagay pa niya under the rules of summary procedure, it will not be dismissed. The case will just be redacted under appropriate procedure and returned to the court where it was assigned, and then that court will apply the proper rule. Okay. Now the summons will be served and the documents, the summons will be served and shall be accompanied by the statement of the claim submitted by the plaintiff and a blank response form. Kasi nakaano na yan may forms na yan. Yung response form, i-check lang yan, fill up ano yan, pati yun ibibigay. And the court shall issue a notice of hearing to both parties directing them to appear before a specific date and time with a warning that no unjustified postponement shall be allowed, and also a blank special power of attorney shall be attached to the notice of the hearing. If you will notice, okay, all these documents to submitted in court are actually form documents already. Okay, naka-prepared na yung form documents. Okay. Pwede ang electronic filing. Okay, service of summons. The summons and notice of hearing must be issued within 24 hours from receipt of the statement of the claims. Hindi katulad sa ordinary civil action and the rules on summary procedure, may 5 days pa bago i-order na court na i-issue yung summons. Itong summons pag or small claims, within 24 hours dapat na issue na yung summons. The summons together with the notice of hearing shall be served by the sheriff or his deputy or other proper court officer within 10 calendar days from the issuance. Within 5 calendar days from service, the officer's return should be filed. No? If summons is returned and without being served on any or all of the defendants, the court shall order the plaintiff or his representative to serve or cause the service of summons. In cases where the summons is to be served outside the judicial region of the court where the case is pending, National Capital Judicial Region, MTC of Makati, pero yung defendant pala nasa First Judicial Region, for example, First Judicial Region, nasa may Ilocos, okay, what will happen? The court may order the plaintiff or his or her representative to cause or serve the service of summons. If the plaintiff is a juridical entity, it shall notify in writing and name the authorized representative, again attaching the board resolution or the pertinent sex cert. Okay. So sinabi ng plaintiff, okay, the court said, okay, plaintiff served the summons. Plaintiff did not serve the summons, okay, but misrepresented to the court that it served the summons to the defendant. Forged niya. What will happen? If plaintiff misrepresents that the defendant was served with summons and later on it was proved that no summons was served, the case shall be dismissed with prejudice, which is also the rule under ordinary civil action. And the proceedings, the judgment will all be what you call this, nullified. And the plaintiff, okay, can be cited in indirect contempt with a penalty or be meted a fine in the amount of 5,000 pesos. Indirect contempt. Huh? Okay. Now, and in both instances where the plaintiff is authorized to serve summons, he or she shall inform the court within 30 calendar days from notice if said summons was served. Otherwise, if there is no notice, case can be dismissed without prejudice as to those who were not served with summons. And this case will not be archived, talagang i-dismiss. And the case, however, may be refiled within 1 year from notice of dismissal, subject to the payment of reduced filing fees. You can only refile the case, okay, within a period of 1 year. Okay. And the response, you file it within 10 calendar days from receipt of summons. And if there is no response filed, what will happen? Okay. The defendant or the respondent will not be declared in default. Okay. Should the defendant fail to file his response within the required period and likewise fail to appear on the date set for hearing, then the court shall render judgment within 24 hours from the termination of the hearing. Okay? Based on the facts as warranted in the statement of claims and its attachments. Now, kung ang defendant, second scenario, the defendant failed to file a response, but he appeared during that one-day hearing, then what will happen? It will proceed the court will proceed to hear the case as if a response was filed. So pwede pa siya magsabi ng kanyang defense. And thereafter render judgment within 24 hours from the termination thereof. Now, if the defendant relies on documentary evidence to support his defense, okay, then the court shall order that defendant to submit copies of the documents, original copies of the document, within 3 calendar days from the termination of the hearing, and upon receipt thereof or expiration of the period to appeal, the court shall render judgment. Counterclaims, pwede ba? The answer is yes. Again, provided it is within the coverage of the rule. Permissive counterclaim, pwede ba? Yes, as long as it is within the coverage of the rule. Any amount pleaded in a counterclaim in excess of 1 million, excluding interest and cost, shall be deemed waived. Okay? And of course, hindi pwede ang lawyers, di ba? Sa small claims. Okay. Pero paano kung yung lawyer siya yung plaintiff or yung lawyer siya yung defendant? Pwede ba siyang umapil? Siyempre, ikaw na dinimanda, ikaw nagdemanda, di ba? Pwede yun. Okay, but lawyers not allowed. Kikita ka ba dito as a lawyer? Hindi ka gumawa ng affidavit, di ba? Hindi ka naman, pwede ka naman gumawa ng affidavit, basta wag ka lang a-appear, okay? Now, okay, what is important is this, okay? Video conferencing, sorry, I have to, okay. When you speak of decisions rendered in small claims cases, it is immediately final and executory, cannot be subject to appeal. And the remedy, according to the case of AL Nang Network, okay, is Rule 65. If you can make out a case for, you know, can make it a case of grave abuse of discretion amounting to lack or in excess of jurisdiction. Clear? Okay. Any questions on small claims and rules on summary procedure? So jurisdiction. Okay. Okay, when there's a question of jurisdiction, you don't immediately answer, okay, no jurisdiction, complaint, the court has no jurisdiction. Tignan nyo muna, is it a jurisdiction over the plaintiff? Is it jurisdiction? Does it talk about jurisdiction over the subject matter? They talk about jurisdiction over the defendant. You talk about jurisdiction over the issues. Kasi iba-iba yung effect niya. If you say, did the court acquire jurisdiction over the plaintiff? Okay, over the plaintiff. When can the court acquire jurisdiction over the plaintiff? Diba, when the plaintiff submits the initiatory pleading and of course pays the appropriate filing fees. Now, if there is a deliberate and wanton refusal or failure, deliberate, intentional refusal to pay the prescribed filing fee, then you apply the case of the ruling in the case of, shoot, how did I forget it? Okay, it starts with that Manchester. Okay, Manchester. I was about to say letter M. Okay, Manchester ruling. Court will not be able to acquire jurisdiction over the initiatory pleading or the complaint because precisely there was a deliberate and intentional refusal to pay the prescribed filing fee. However, if there's no deliberate intention, and for example, there was just a miscalculation, then apply the ruling in the case of Sun Insurance versus Asuncion. The court, in fact, will not dismiss the complaint. The court will give the plaintiff an opportunity to pay the prescribed filing fee within the reglementary period. Okay. If you're talking about jurisdiction over the defendant, and when will the court be able to acquire jurisdiction over the defendant? Proper service of summons, or when the defendant voluntarily submits to the jurisdiction of the court. Now, what if the defendant, there was failure to serve the summons properly? Ang nag-serve sa defendant yung kaluguyo ni sheriff. Pwede yun, di ba? Anong gagawin? You don't file a motion to dismiss, you file an answer and raise by way of affirmative defense that the court failed to acquire jurisdiction over the person of the defendant because of improper service of summons. Now, if you don't raise it by way of affirmative defense, you submit an answer without even raising the said improper service of summons, the court now will be able to acquire jurisdiction over the defendant. Why? Because it can be waived. Voluntary submission to the jurisdiction of the court. When we speak of jurisdiction over the subject matter, and what is subject matter? It's the thing, the event, the contract that is the subject of the controversy. Okay, let's say the court, okay, was let's say recovery of real property, action invindicatoria. You filed it with the RTC, okay? Or the action publicana nila, action publicana, you filed it with the RTC. But the assessed value of the property is worth only 100,000 pesos. The court will not be able to acquire jurisdiction over the subject matter, and the court on its own can dismiss the complaint. Or the other party can file, if it's under the rules, under ordinary rules of civil action, can file a motion to dismiss pursuant to Rule 9, Section 1 on the ground that the court does not have jurisdiction over the subject matter of the case. So, ang subject matter, pansinin nyo, hindi nyo pwede sabihin, court may file a motion to dismiss on the ground that the court does not have jurisdiction, period. Ano bang pinag-uusapan natin? Subject matter ba or jurisdiction over the defendant? Because jurisdiction over the defendant, waivable yan, at saka iba yung remedy. Now, jurisdiction over the subject matter, iba rin yung remedy, iba rin yung consequences. Because if you did not raise it, even by way of motion to dismiss or affirmative allegations, even if you failed to raise the issue of jurisdiction over the subject matter, and the judge rendered judgment, we all know this, that even on appeal, the court can reverse it. Why? Because if the court below does not have jurisdiction over the subject matter, the proceedings and the judgment will all be void. That's the general rule, because your exception will be Tiham versus Sibang Hanoi. Okay, now, jurisdiction over the issue. Okay, again, I go back to unlawful detainer case. Okay, when jurisdiction is based on the allegations of the complaint and never on the allegations of the answer. Now, if the answer raises the issue of ownership, okay, and the inferior court, in order to resolve the issue of possession, has to traverse the issue of ownership, okay, the ruling of the inferior court in an unlawful detainer case or forcible entry case on the quote-unquote issue of ownership is not final, because it was only traversed to determine possession. And therefore, the defendant, miski sabihin niya, okay, he should be ousted because he was found to be guilty of, let's say, unlawful entry or forcible entry or unlawful detainer, okay, the defendant can still file what? An action for action reinvindicatoria. Because the issue of ownership cannot be decided with finality in an unlawful detainer or forcible entry cases. Ngayon, kung lahat yan present, okay, then it may give rise to the application of res judicata. Okay, because the decision is valid. Is that clear? So that is the, what you call this, that is the introduction to jurisdiction. So what is jurisdiction? Jurisdiction, therefore, is the power of the court to hear, try, and decide a case. It includes the power to determine whether it has authority to hear and determine the controversy presented, and the right to decide whether the statement of facts that confer jurisdiction exists, as well as other matters that may arise in the case legitimately. So it also includes the power to execute its decision. It includes the power to control the execution of the decision of the court, which is essential part of the jurisdiction, and that the most important part of litigation, okay, is the process of execution. Okay. So what are the different aspects of jurisdiction? Jurisdiction over the subject matter, jurisdiction over the parties, which would refer to jurisdiction over the plaintiff, jurisdiction over the defendant, jurisdiction over the issues, and jurisdiction over the rest or the thing involved. Okay. And when can the court acquire jurisdiction over the plaintiff? Acquired by the filing of the complaint, over the petitioner by filing of the petition, or the initiatory pleading before the court by the plaintiff or petitioner. And of course, you have to pay the filing fee as a rule. Jurisdiction over the defendant, okay, summons, proper service of summons, or voluntary, okay, submission to the court. Now, in petitions, let's say for petitions for review on certiorari under Rule 45. When will the court acquire jurisdiction over the person of the respondent upon receipt of the order to comment? Okay. Now, jurisdiction over the issues of the case. It is determined and conferred by the pleadings filed in the case or by agreement of the parties during the pre-trial stage, okay, or by their implied consent to try a specific issues if that issue was not stated in the pre-trial order. And jurisdiction over the rest is acquired by the actual or constructive seizure by the court of the thing and placing it under custodia legis. Example, when the writ of preliminary attachment was implemented. Okay. Now, when we say jurisdiction over the subject matter, it is a power of a particular court to hear the type of case that is then before it. It refers to the jurisdiction of the court over the class of cases to which a particular case belongs. Okay. Now, it is the duty of the court to dismiss the case if the court does not have jurisdiction over the subject matter. Now, even if the question over the subject matter, jurisdiction of the subject matter was not raised by the other parties, was not even ruled upon by the court. As I said, even on appeal, the court, the appellate court can dismiss the case if the trial court did not really have jurisdiction over the subject matter. So what is the effect of lack of jurisdiction over the subject matter? The general rule is that the proceedings conducted, the decisions rendered by the court will all be void. Okay. Where there is lack of jurisdiction over the subject matter, it appears on record, an appellate court may on its own initiative dismiss the action. And when the court dismisses the complaint for lack of jurisdiction, what is the remedy? Ang layo, no? Jurisdiction, what is the remedy? Para lang magising kayo, okay? The court dismisses the action, okay? Because the court has no jurisdiction over the subject matter. What is the remedy? And let's assume it is really correct. He is very right. You just refile it. You don't appeal it. In the first place, it's a dismissal without prejudice. And assuming it's wrong, the proper remedy is Rule 65. Look at your Section 1, Rule 41. Please memorize Section 1, Rule 41. Okay. It's a dismissal without prejudice, you can refile. Clear. And if it's wrong, remedy really is 65. It's not appealable. Okay? Okay. It is settled that jurisdiction over the subject matter is determined by the law in force at the time of the commencement of the action. And why is it the law that it is the law at the time the action is commenced? Because when you speak of jurisdiction over the subject matter, it is based on substantive law. Okay, BP 129, for example. Okay, BP 129, it is substantive law. Kaya yun yung batas na mag-iiral pag nag-file. Now, the court's jurisdiction will be dependent on the time when the petitioner files his complaint. Once a complaint has been filed with the court that has proper jurisdiction, it latches on to that and it will not be ousted by subsequent events. So the general rule, for example, let's just assume, okay, the jurisdiction, let's say in 2015, is that when you talk about, let's say, a collection suit, let's say for 2 million at the time, 2015, okay, let's say 2 million, it's with the RTC, okay? But now it is with the MTC because it does not exceed 2 million. So even if the case was filed, okay, 2015, and it was raffled off to the RTC because that was the law that had jurisdiction over the subject matter at the time, and the case is still pending now, okay, pending. There's this new law bringing the jurisdiction over that amount to the MTC. Still, it will be retained by the RTC because jurisdiction attaches once a complaint is filed and it cannot be ousted by subsequent events. Okay. Now, jurisdiction over the subject matter is determined by the allegations of the complaint or the initiatory pleading. So it is very, very important that when you do your forms, tandaan nyo kung ano yung allegations na dapat nahandon. Why? Because jurisdiction is conferred by law. Okay? It is determined by the allegations in the complaint as well as the character of the relief sought. Now, example, you want to file a petition, a complaint for unlawful detainer or forcible entry. Okay. Para mas complaint for unlawful detainer. What will vest the MTC the jurisdiction, of course, will be what? Will be the fact that there was a demand letter, okay, and the demand letter is to pay and vacate. That's jurisdictional. Number two, that the complaint must be filed within 1 year from the date of demand, right? So it must be stated in the complaint. Pag hindi mo sinabi yon, hindi yun unlawful detainer. Therefore, the MTC does not have jurisdiction. Okay. What if the case is action publicana? What is important is that you have to allege the assessed value of the property. Because without the assessed value of the property being alleged in the complaint, then you have no basis to determine whether it falls within the jurisdiction of the MTC or the RTC. Is that clear? Okay. So basic is the rule in this jurisdiction that the subject matter is determined by the allegations in the complaint. It is determined exclusively by the Constitution and the law and cannot be conferred by voluntary act or agreement of the parties or acquired. It cannot be waived. It cannot be enlarged. It cannot be diminished by their act or omission. Now, in determining whether the court has jurisdiction over the complaint, the court should not inquire into the truth of such allegations. Kung ano lang yung nakasulat dun sa complaint. Kaya totoo yan, kaya hindi, that's not material for the purpose of determining whether the court has jurisdiction or not. Okay. Notice that under the current rules, the allegations of the complaint will not only be based on ultimate facts. It must also contain your evidentiary facts. Now, we have discussed this last time, no? With respect to the jurisdiction of the RTC. Let's say, you're asked the question whether the court has jurisdiction, whether the RTC has jurisdiction, or whether it is the MTC. Always remember the criterion. If it is primarily for the recovery of sum of money, the claim is therefore considered as a claim capable of pecuniary estimation, and whether the jurisdiction is in a first level courts or the second level courts would therefore depend on the amount of the claim. And that's the case of Pajares versus Remarkable Laundry. Remember, the RTC has jurisdiction if the value, claim, or demand exceeds 2 million pesos. The MTC has jurisdiction if the value or the claim does not exceed 2 million pesos, of course, exclusive of cost and interest. Okay, now. Okay. However, if the basic issue is something other than the right to recover a sum of money, which means the money claim is purely incidental or a consequence of the relief sought, then the Supreme Court has considered such actions as actions, okay, which cannot be estimated in terms of money and therefore is cognizable by the RTC. Okay. Question lang. Hindi ko napapasulat sa inyo yung sagot. Okay, tayo ng apat. Magbulahan na lang tayong apat. Okay. Just listen. So these are the allegations in the complaint. Pedro bought a land from Juan amounting to 5 million pesos. So binili niya yung land from Pedro kay Juan. Pedro bought land, a piece of land from Juan in the amount of 5 million pesos. Now, despite the demands, okay, from the seller, from the buyer, for the seller to turn over the TCT, the seller refused to surrender the TCT to the buyer kahit na bayad na yung consideration. Now, so what happened was, okay, in the event that the TCT will not be surrendered, sabi ngayon ng buyer, okay, that the deed of absolute sale should be rescinded because you're not turning over me the TCT, and that the 5 million and all other costs be returned to the buyer. Now, the assessed value of the property is only what? 15,000 pesos. What court has jurisdiction? Notice if we apply the test, the principal purpose is to rescind. Okay, to rescind. And as a consequence of rescission is to return the amount. The assessed value of the property is 15 million. Even if the assessed value of the property is only 15 million pesos, but the principal relief is rescission, then we know that it is incapable of pecuniary estimation. Therefore, the RTC has jurisdiction. Based on the allegations of the story, okay, what was the primary motive, okay, of the plaintiff is to get the TCT. Okay, that specific performance, diba? To get the TCT. So regardless of the assessed value, the TCE, kung yun ang kanyang primary motive to get the TCT, then we know it is incapable of pecuniary estimation. But based on the example, it is to rescind. Okay, that is the primary motive, and therefore, again, it is an action incapable of pecuniary estimation. Now, again, we discussed this last time. Regardless of the assessed value of the property, the MTC has exclusive original jurisdiction over unlawful detainer cases. And an action for unlawful detainer is one the purpose of which is to recover possession of real property from one who illegally withholds possession after the expiration of the right to hold possession under any contract, express or implied. Okay. As I said, okay, regardless of the assessed value of the property. Now, when the action is purely on damages, moral damages, exemplary damages, lahat puros damages, it is the RTC that shall exercise exclusive original jurisdiction over actions in which the subject of litigation is incapable of pecuniary estimation. Okay. And other cases where the demand exclusive of interest, damages, attorney's fees, litigation expenses, and costs, okay, which exceeds how much? 400,000, the RTC has jurisdiction. Now, when we speak of the term damages of whatever kind, the exclusion of the term damages of whatever kind in determining the jurisdictional amount applies to cases where the damages are merely incidental to or a consequence of the main action, main cause of action. However, in cases where the claim for damages is the main cause of action or one of the causes of action, the amount of such claim shall be considered as determining the jurisdiction of the court. That's Sante versus Claraval. Okay, anong ibig sabihin nun? Kunwari, si Maria, no? She was slapped. She was slapped by Petra, okay? And then she was and Petra hurled invectives against Maria. Napahiya siya sa maraming tao. So Maria, okay, filed a complaint for damages to recover moral damages, exemplary damages, etc. And the amount she claimed is 1 million, 1 million, okay? The value 1 million plus 1 million under the current law, okay, is still to be filed with the MTC because that is the total amount of damages. Okay, now, however, if it's rescission of contract, and then the amount of damages, let's say, is what? 500,000 pesos. Notice that the 500 is only a consequence of, okay, of the, the main cause of action, which is rescission. Then it will have to be filed with the RTC because that is an action incapable of pecuniary estimation. Is that clear? Now, so in another example, okay, an action purely for damages was filed. Now, here, the plaintiff prayed for the following: 50,000 moral damages, 300,000 pesos more, 1.5 million, okay, by way of moral damages, 500,000 by way of exemplary damages. So 2 million na yon. Plus 50,000 attorney's fees, plus another 50,000 litigation expenses, okay? And then cost of suit, let's say, is another 50,000. So that's about 2.150, correct? Okay. What court has jurisdiction? This time it will have to be the RTC. Why? Because you add all the damages in the computation if the action is primarily one for damages. Is that clear? And it's 41250. It's clearly within the jurisdiction already of 2,150,000 pala, not 4 million. 2,150,000. It exceeds 2 million. Is that clear? Okay. Now, any questions so far? Okay. Let's say a complaint was filed, okay? And then the complaint, let's say, was filed. It's for specific performance, and the amount of consequential damages in relation to the specific performance is just, let's say, 1 million pesos. Now, the defendant says, okay, no, the court has no jurisdiction because the damages does not exceed 2 million pesos. Remember that the defenses raised in the answer do not determine jurisdiction. It is only based on the allegations of the complaint. Okay, it's the allegations of the complaint that would determine the jurisdiction. It is never dependent on the defenses raised in the answer. So the settled rule in this jurisdiction is based on the allegations stated in the initiatory pleading. Jurisdiction of a court cannot be made to depend upon the defenses made by a defendant in his answer or in a motion to dismiss. So you file, let's say, a complaint, let's say, for unlawful detainer before the MTC. The defendant says, no, I am a tenant, okay, and therefore, okay, this one is a tenant, it's an agrarian case. Still, the MTC has jurisdiction because the allegations will depend on the allegations of the complaint, not on the allegations or defenses raised in the answer. Okay, general rule. The general rule is the defense of lack of jurisdiction over the subject matter. By the way, just to be more precise, pag sinabi niyong lack of jurisdiction, sabihin niyo kung lack of jurisdiction over the subject matter or lack of jurisdiction over the defendant. Huwag niyo sasabihin lack of jurisdiction lamang. Kasi iba yung consequences nun eh. Lack of jurisdiction over the subject matter may be raised at any stage of the proceedings, even for first time, okay, on appeal. And in fact, the court may on its own dismiss the complaint at any time when it appears, okay, from the pleadings or the evidence adduced that the court does not have jurisdiction over the subject matter. And that's a case of Hulao versus Spouses de Jesus. So in other words, even if the parties did not raise the issue of jurisdiction, the reviewing court on appeal is not barred, okay, from ruling that the lower court does not have jurisdiction over the subject matter. Now, of course, that's the general rule. What is the exception to the general rule? Of course, the famous case of Tiham versus Sibang Hanoi. Now, the SC barred a belated objection to jurisdiction that was raised by the party only when an adverse decision was rendered by the lower court against it and because it raised the issue only after 15 years, okay? And after seeking affirmative relief from the court and actively participating in all stages of the proceedings. 15 years. In a very recent case, okay, the Tiham case was likewise cited, but this time it involved 21 years, if I'm not mistaken, more than 20 years, no? When it raised first time on appeal the issue of lack of jurisdiction over the subject matter. I think the threshold period, will have to be 15 years. No? Now, let's talk about assessed value again, assessed value. What determines jurisdiction, as I said, is the allegations in the complaint and the reliefs prayed for. Now, if it is a complaint for reconveyance of a parcel of land, which involves the title to or possession of or ownership over the said real property, you have to state the assessed value of the property. Okay, you have to state. Absent any allegation in the complaint of the assessed value of the property, the court cannot determine which between the first level court or the second level court has original and exclusive jurisdiction over respondent's action. And that's the case of heirs of the late spouses Ramiro versus spouses Macaron. So, ano ba yung real action? Real action is defined under Section 1 of Rule 4. It involves, the ownership, possession of, or any interest in relation thereto. Now, in real action, therefore, the assessed value of the property, or if there's none, the estimated value thereof shall be alleged in the claimant and shall be the basis in computing the filing fees. Now, jurisdiction of courts based on the assessed value is very important. Okay, if it's a real action. But please take note, while that is the general rule, the exception to the general rule is with respect to unlawful detainer or forcible entry cases. Why? Because even if it's a real action, the law clearly provides that the court that has exclusive and original jurisdiction to hear and decide unlawful detainer cases and forcible entry cases will be the MTC. Okay, now, generally, the court should not look into the facts alleged in the complaint to determine whether a suit is within its jurisdiction. Okay. Now, that is the general rule. Of course, the exception is when the rigid application of the rule may result in defeating substantial justice or in prejudice to a party's substantial right. Okay. Kanina sinabi natin, pag real action yan, kailangan i-allege mo yung assessed value. But there is one case. This is the case of Tumpag versus Tumpag. The SC, okay, in that particular case, no, the assessed value was not stated. However, the SC considered the facts contained in the declaration of real property, which was attached to the complaint, okay, in determining whether the RTC has jurisdiction over the petitioner's case. Okay. Hindi naka-allege pero naka-attach naman by way of annex. So sabi ng Supreme Court, okay, to apply the rule rigidly will defeat substantial justice. So anong ginawa? O sige, tignan natin kung anong naka-attach. And based on the attachment, nakita na ang assessed value is still within the jurisdiction of the second level court. Okay, now, any questions so far? Okay. Let me just go over my notes. Okay. There is one case, and this is the case of Berbano versus heirs of Tapulao. Okay. This is a 2019 case. Yung first case na final, okay. Let's assume, basically what I'm going to discuss will be the principle, no? The first complaint that was filed, okay, the assessed value of which is, let's say, worth 2 million pesos. 2 million. Assessed value. So nung nag-assess value siya ng 2 million pesos, let's say it covers, let's say, 1 hectare. Okay. It was filed before the RTC, but the case was dismissed. Okay. It was dismissed, let's assume for res judicata. Okay. Now, ang ginawa, di namatay, no? Namatay na yung plaintiff. Years after, the heirs of the plaintiff filed another case. Okay. This time, okay, remember that's 1 hectare and the assessed value, as I mentioned, is 2 million. Ang ginawa niya, kinukuha na lang niya yung 200 square meters of the 1 hectare. Okay, of the 1 hectare. Okay. And because ang claim niya, okay, 2 million yan. Okay, dahil it's one title, it's one title. Because I'm only claiming 200 square meters. Therefore, based on the assessed value, okay, then it should be a portion only of 2 million. In other words, inano niya, prinorata niya, prorated. And the assessed value is within now the jurisdiction of the MTC. Now, can the court still entertain the complaint? Sabi ng Supreme Court, no, okay? Why? Because the court has repeatedly held that jurisdiction over the subject matter is determined by examining the material allegations of the complaint and the relief sought. And based on the allegations of the complaint, it clearly alleged that the assessed value of the entire lot, okay, is 2 million. You do not prorate it just because you are trying to get only 200. Is that clear? Ginawa niya kasi 200 lang ang kinukuha na lang niya. Okay, now. Okay, let me just discuss certain case. Okay, another. Jurisdiction is conferred by law and not by the agreement of the parties. The Supreme Court, okay, said that when we speak of jurisdiction over the subject matter, it is conferred by law. It cannot be waived by through the agreement of the parties. It cannot. That is the general rule. Is that clear? Okay. Now, another principle is, just give me a minute. Okay. When we speak about jurisdiction over the parties, that is different from jurisdiction over the subject matter. When we say jurisdiction over the subject matter, it is one conferred upon by law and determined by the allegations in the complaint and the character of the relief sought. Whereas if it's jurisdiction over the parties, it is acquired by the filing of the petition in case of the plaintiff, or by valid service of summons, or voluntary submission to the court's authority in case of the defendant. Okay. When you speak of jurisdiction over the subject matter, it cannot be conferred by the agreement of the parties, by contract, or by the party's silence or acquiescence. Hindi pwedeng ilagay sa kontrata o miskin na yan, recovery of reconveyance of real property, basta may kaso ganyan, sige, agree tayo, MTC. Cannot be. Because the law is very clear what court will have jurisdiction. It will depend upon the assessed value of the property. But when you speak of jurisdiction over the person, yan, it can be subject to the will of the parties. Now, jurisdiction over the subject matter, I repeat, cannot be raised first time on appeal. Okay? Can be raised rather first time on appeal. Can, jurisdiction over the subject matter. But jurisdiction over the person cannot be raised first time on appeal, which means when you speak of jurisdiction over the subject matter, it cannot be waived. Okay? Whereas jurisdiction over the parties is waivable. And jurisdiction over the parties refers to the power of the court to make decisions that are binding on persons. It is the legal power of the court to render a personal judgment against a party in action or proceeding. And how is jurisdiction over the parties acquired? Let's start with the plaintiff first. It is acquired as soon as he files his complaint or petition, because the mere filing of the complaint, the plaintiff in a civil action voluntarily submits himself to the jurisdiction of the court. How about jurisdiction over the defendant? It is acquired by his voluntary appearance in court and his submission to its authority, or by proper service of summons. Now, what do you talk when you say voluntary appearance of the defendant? Yan ba ay dumaan lang yan sa korte, mayroon ng jurisdiction ng court? Nag-wave pa siya kay judge. Hi, judge. No, that's not the concept of voluntary submission. Okay? Voluntary submission is you submit something in court and then what? You ask for affirmative relief. You just file a motion for extension of time to file an answer. Kahit improper service na yan, anong mangyayari? You are deemed to have voluntarily submitted to the jurisdiction of the court. Okay. So what is the general rule? If a defendant has not been properly summoned, okay, the court acquires no jurisdiction over its persons, and a judgment rendered against the defendant is null and void. Okay. Exception, even if there was improper service of summons. If the defendant voluntarily appears in the action, that will be equivalent to service of summons, and the court would have acquired jurisdiction over the person of the defendant. Okay. Now, okay, can you look at your section, Rule 14, Section 23? Let me just clarify that, no? Kasi medyo nakakaliti siya eh. Rule 14, Section 23. Okay? Okay. Girl power tayong lahat, ah. All girls. The lady there is also a girl. Okay. Now, can you please read it? Read it carefully lang, ha? Yes, out loud.
Section 23, voluntary appearance. The defendant's voluntary appearance to the action shall be equivalent to the service of summons. The inclusion in the motion to dismiss of other grounds aside from lack of jurisdiction over the person of the defendant shall be deemed a voluntary appearance.
Okay, let me clarify that provision because that is very confusing. In the first place, okay, there are only 4 grounds which you can raise in a motion to dismiss. Okay. And what are these 4 grounds? Lack of jurisdiction over the subject matter, litis pendentia, res judicata, and prescription, correct? If you look at your Rule 15, yan ang nakalagay. Tapos, here comes Rule 14, Section 23 that says the inclusion in a motion to dismiss of other grounds aside from lack of jurisdiction over the person of the defendant shall be deemed a voluntary appearance. Okay. Now, in the first place, as I said, if you want to file, okay, or raise the issue of lack of jurisdiction over the person of the defendant, you cannot raise it in a motion to dismiss. You can raise it by way of affirmative defense. Okay, you can raise it by way of affirmative defense in your answer. 4 lang ang grounds, ha, in a motion to dismiss. Okay. Now, okay, question. Okay. Plaintiff filed the case against the defendant. The defendant was served, okay, properly, was served summons. Summons was served upon the defendant. After service of summons, the defendant died. Did the court acquire jurisdiction over the defendant? The answer is yes. Because he was properly summoned before his death. And what will be the effect of the death? Will it cause the dismissal of the complaint? It depends. If it is a personal action, meaning to say it's personal, no? Like he's supposed to deliver, he's supposed to do something na siya lang pwedeng gumawa, or let's say it's an action for support, personal in nature, of course the case will be dismissed. But if it is an action that survives death, notwithstanding the fact that the defendant who was properly summoned, okay, died, okay, while the case is pending, it will not result to the dismissal of the complaint. What are the actions that survive death? Di ba red? Red, recovery of real property or for personal property. E, enforcement of lien thereon. D, damages. And don't forget your money claims, express or implied. So hindi madidismiss. Ano mangyayari? The defendant, lawyer will have to inform the court that his client died and will tell the court who are the heirs or the executor or the administrator of the deceased. For what purpose? So that there will be an order requiring those compulsory heirs or the executor or administrator, okay, to substitute the deceased. And there will be an order of substitution. Clear? Now, ang tanong, paano naman kung na-serve yung summons? Okay, so na-serve yung summons, no? Hindi alam ni plaintiff na namatay na pala si defendant and summons was served. Okay, may tumanggap. May tumanggap. Pero sinabi ng tumanggap, patay na ho yung defendant. Now, did the court acquire jurisdiction over the person of the dead, the deceased? Hello, sir. I remember you. You were my student. Hello. Okay. The answer is no. In the first place, unless ang defendant is si Casper the Friendly Ghost, yan, baka sakali, baka sumagot. But the point is, it's no, it's not. Okay? That the trial court did not acquire jurisdiction over the person of the defendant. Why? Because jurisdiction over the person of a defendant is acquired only through valid service of summons. And you cannot validly serve summons if the person who is, if the defendant is already dead, even before the filing of the complaint. Kaya hindi pwede dyan mag-substitution kaagad. You will have to refile it. Substitution, okay, substitution of parties, it's in this, when we talk about death, presupposes that the defendant was alive and was validly served summons. Ngayon, kung at the time summons was served, patay na talaga yung si defendant, walang substitution na mangyayari dyan. You will have to amend your complaint talaga. Okay? At tapos magsuserve talaga ng summons ulit. Clear? Okay. Now, let's discuss these three sometimes very confusing notion. Huh? Okay. Jurisdiction, okay. When you talk about jurisdiction over the defendant, action in personam, action in rem, and action quasi in rem. Ano ba yung mga yan? Action in personam is an action against a person on the basis of his personal liability. So I sued, let's say, Pedro for sum of money. So I'm holding Pedro liable personally. So it is an action in personam. But it is a personal action. Okay. Action in personam is not the same as personal action. When we speak of action in personam, as I said, it is an action that is based on the personal liability of the defendant. It is also a personal action in the sense that for purposes of venue, okay, the case will have to be filed, okay, based on Rule 4, either on the basis of a strict venue stipulation, let's say on the promissory note we prepared, or in the absence thereof, it will be filed in my residence or at the residence of the defendant at my election. Okay. Now, quasi action in rem. It is an action against the thing itself instead against the person. Okay. Now, action quasi in rem is one wherein an individual is named, so may defendant ka, as defendant, and the purpose of the proceeding is to subject his interest therein to the obligation or lien burdening the property. Example, will you be your foreclosure? May defendant, pero talagang gusto mong hindi personal liability, but you want that liability to be passed on to that property. Is that clear? Okay, now, other concept. Okay, jurisdiction over the subject matter is not the same as exercise of jurisdiction. I will repeat. Jurisdiction over the subject matter is not the same as exercise of jurisdiction. When we say jurisdiction of the subject matter, okay, what is jurisdiction? Jurisdiction is the authority of the court to hear and decide the case. That is jurisdiction. Okay, ang kapangyarihan niyang digin at desisyonan yung kaso. Okay. Whereas exercise of jurisdiction, when the court has jurisdiction over the person and over the subject matter, the resolution of all other questions arising in that case is but an exercise of jurisdiction. So when the court has jurisdiction over the person and over the subject matter, the decision, okay, on all question arising from that case is just but an exercise of jurisdiction. May jurisdiction ng RTC, okay, sa complaint over, let's say, specific performance. It's an action incapable of pecuniary estimation. The RTC has jurisdiction over the plaintiff and over the defendant, especially since the defendant, there was proper service of summons. Okay. Nag-decide ang RTC. Sabi ng RTC, anong decision? Petition, a complaint dismissed. Hindi pwede daw ang specific performance. Okay. Yung decision is but an exercise of jurisdiction. Which means, kung mali yung decision ng court, if it's wrong, then the proper remedy is appeal. Okay. It's not a question of no jurisdiction or in excess of jurisdiction or there was grave abuse of discretion just because the decision is wrong. The question is not jurisdictional. And therefore, the proper remedy would be appeal. Is that clear? Okay, now. Okay. Jurisdiction versus venue. Okay. Jurisdiction, to repeat, refers to the authority of the court to hear and decide the case. Venue refers to the place where the case is to be heard or to be tried. Jurisdiction over the subject matter is a matter of substantive law, whereas venue is a matter of procedural law. Jurisdiction over the subject matter cannot be waived by the parties, but venue may be waived by the parties. Jurisdiction over the subject matter is fixed by law and cannot be conferred by the parties. Hindi pwedeng pag-agrihan lang nila yan. But venue may be conferred by the act or the agreement of the parties. If the court does not have jurisdiction over the subject matter, the court may dismiss the case motu proprio, correct? Okay. Pero ang venue as a general, I would say as a general rule, if the court, if there is a case of improper venue, the court cannot on its own dismiss the complaint on the ground of improper venue, except, ito yung exception, except when you talk about cases covered by rules on summary procedure. Di ba pinag-aralan natin yun last week? The court on its own, if it's clear from the complaint, you know, that it's a case of improper venue, can dismiss the complaint on its own. Okay, expedited rules. Now, lack of jurisdiction over the subject matter may be raised at any stage of the proceedings because precisely it is conferred by law. Now, objection to improper venue must be raised by way of affirmative defense in the answer. Please do not raise it in a motion to dismiss. It will only show how old you are if you raise it in a motion to dismiss. 19 kopong-kopong pa yun. Okay? Clear? Okay, now, there's this case, Nocum versus Tan. The venue in civil actions from libel may be waived since it does not involve a question of venue. Yung libel, pag final mo yan as a criminal case, venue is jurisdictional. Pero kung nag-file ka ng action for damages because of a libelous, okay, a libelous report or something or narrative in a newspaper, okay, the venue in civil actions may be waived because it does not involve jurisdiction. But again, in criminal actions, it is fundamental that venue is jurisdictional, it being an essential element of jurisdiction. And that's the case of Nocum versus Tan. Okay. Any questions? Okay. Now. Okay. Question lang. You don't have to write the answer, huh? Plaintiff filed a case against the defendant before the RTC of Muntinlupa. Okay. Plaintiff lives in Manila. Defendant lives in Makati. The case is a personal action. First question, proper venue or improper venue? Sumagot kayo ng wag venue lang, no? Ang sagot natin, improper venue, di ba? Now, bakit siya improper venue? Remember, it is a personal action. Therefore, it is the place where the plaintiff lives or the defendant lives at the election of the plaintiff. Case was filed in Muntinlupa. Plaintiff live in Manila. Okay, and defendant lives in Makati, improper venue. So what will now be the remedy of the defendant? Okay, because it is a case of improper venue, then the defendant must file an answer and must raise by way of affirmative defense improper venue. Is that clear? The court cannot on its own, this is RTC, the court cannot on its own dismiss the case. Okay. Ibig mo sabihin, pag MTC, pwedeng i-dismiss agad. Okay? No. Kasi yun, covered by rules on summary procedure. Ang MTC can also hear actions involving ordinary civil action. Okay? Kaya I will repeat what I mentioned. Pag ang tanong MTC, talagang pag nilayan yung mabuti. Kasi ang MTC, merong small claims. Pwedeng ang rule on summary procedure. May rule on ordinary civil action. So, iba-ibang rules yan. So, yun ang sinasabi ko. Yun. And then pag-appeal, binasa nyo yung RTC, tingnan nyo, ito bang tanong, ang decision ba ng RTC was rendered in the exercise of its original jurisdiction or in its appellate jurisdiction? Ngayon pag sabi nyo, okay, appellate decision. Tingnan nyo muna. Ang next question na tanungin, ito ba was it rendered in relation to a case that was governed by the rules on summary procedure or not? Kung governed, that's it, pansit. That the decision becomes final and executory, one-step appeal under the expedited rules. You don't go Rule 42. Pero, okay, kung governed siya ng ordinary rules of civil action, pwede ka pang mag-appeal, but that will have to be Rule 42. Okay? So if I were you, you try to make your rules, no, yung if ganito, matatandaan nyo talaga lahat yan. Let me now discuss again filing fee, docket fees. The rule in this jurisdiction is that when an action is filed, the filing must be accompanied by the payment of the requisite docket and filing fees. And the fees must be paid. Okay, because the court acquires jurisdiction over the case only upon the payment of the prescribed filing fees. Now, so payment of the full amount of docket fees is mandatory. When the complaint is filed and the prescribed fees are commenced, the action is deemed commenced. The court acquires jurisdiction over the plaintiff and the running of the prescriptive period for the action is interrupted. Okay, that is the rule, okay, in the case of Manchester versus Court of Appeals. The rule was, however, relaxed again by the Supreme Court in some cases. The first one is the case of Sun Insurance, Asuncion, di ba? Sun Insurance versus Asuncion, in which payment of the fee within a reasonable time but not beyond the prescriptive period was permitted. Okay. Now, so in the case of Proton Pilipinas Corporation versus Banque Nacional de Paris, okay, while payment of the prescribed docket fees is a jurisdictional requirement, even its non-payment at the time of filing fees does not automatically cause the dismissal of the case as long as the fee is paid within the applicable prescriptive or reglementary period, more so when the party involved demonstrate its willingness to abide by the rules prescribing such payment. Okay. Pag nagtanong, did the court acquire jurisdiction given that the filing fee was not fully paid? Okay, the first thing you will ask, okay, is, was this intentional? Was it deliberate? Was it willful? Was there really an intent to evade the payment of the prescribed filing fee? Pag ang answer mo dyan, yes, apply Manchester. Court failed to acquire jurisdiction. Okay. However, if the reason for you not being able to pay the prescribed filing fee was because of, let's say, a mathematical error in the computation of the filing fee by the person who received it, yung mismo sa Office of the Clerk of Court, nagkamali. Hindi intentional yan. Di anong then you apply Sun Insurance. The court will give you a period of time, okay, within which to pay the said difference. Is that clear? Now, even on appeal, the general rule is that payment of the docket fees within the prescribed period is mandatory for the perfection of the appeal. As discussed last time, saan mo ba yan binabayaran? Okay. If you're appealing from a decision rendered by the MTC to the RTC, okay, you pay it with the court of origin, MTC. If the filing fee, no? If the RTC is acting in its original jurisdiction and now you want to appeal it to the CA, ordinary appeal, you pay it with the court of origin, the RTC. However, if you're talking about Rule 42 or Rule 45, you pay the filing fee with the appellate court. Okay, with the appellate court. Now, so even on appeal, the general rule is that payment of docket fees within the prescribed period is mandatory for the perfection of the appeal. Okay. Now, it is not simply therefore the filing of the complaint or appropriate initiatory pleading that will give the court the power and authority to hear and decide the case, but the payment of the prescribed docket fee that vests a trial court with jurisdiction over the subject matter or nature of the complaint. In resolving the issue of whether the correct filing fee was paid, okay, it is necessary to determine, of course, the nature of the action. So just to summarize the rule on filing fee, any defect in the original pleading resulting in underpayment of the docket fees cannot be cured by amendment, such as the reduction of the claim. For all legal purposes, there is no original complaint over which the court has acquired jurisdiction. And as I said, in the case of Manchester versus Court of Appeals, the reason why the Supreme Court said that the court did not acquire jurisdiction over the said complaint is because there was really a deliberate, intentional, okay, effort on the part of the plaintiff not to pay the prescribed filing fee. Now, the Sun Insurance rule is while the payment of the prescribed docket fee is still jurisdictional, even its non-payment at the time of the filing does not automatically cause the dismissal of the complaint as long as the fee is paid within the prescriptive or reglementary period, more so when the party involved demonstrate a willingness to abide by the rules prescribing such payment. So the insufficiency of the filing fees, okay, which were initially paid by the plaintiff, okay, and there was really no intention to defraud, yun na lang. Yung word na defraud, no intention to defraud the government, apply Sun Insurance, do not apply Manchester. Now, the same rule applies to permissive counterclaims. Notice ha, ang compulsory counterclaims hindi nagbabayad dyan ng filing fee. Pero ang permissive counterclaims, kailangan magbayad ng filing fee. Kailangan magbayad ng filing fee sa third-party complaints, okay, and similar pleadings, which shall not be considered filed until and unless the filing fee prescribed therefore is paid. And the court may allow the payment of said fee within a reasonable period, but in no case beyond its applicable prescriptive or reglementary period. Is that clear? Okay, now. Okay. Okay, let me just, okay. Okay, there was one case, and this is the case of Broadcasting Corporation versus Legasto. So in the case of Intercontinental Broadcasting Corp, the respondent relied on the assessment made by the docket clerk, which turned out to be incorrect. So mali, yung nabayad, mali, kulang. Ano sabi ng court? The payment of the assessed docket fee as assessed negates any imputation of bad faith or intent to defraud the government by the respondent. And so therefore, you apply the case of Sun Insurance. Okay. Now. Okay. Case of Cristal versus Son. Okay. Okay. In this case, the respondent failed to allege in her complaint the assessed value of the subject property. Rather, what she included was an allegation of its market value only. Okay. And in the course, okay, and this is the old law, huh? This is, I will repeat, this is the old law on assessed value to determine the jurisdiction of the court. But I'm citing this case only because of the principle. Okay, so forget about the numbers, huh? Forget about the numbers. In this case, the respondent failed to allege in her complaint the assessed value of the subject property. What she included was an allegation of its market value amounting to 200,000 pesos. So in the course of the trial, the petitioner asserted that the assessed value of the property as stated in the tax declaration was merely 1,030 pesos, and therefore the RTC lacked jurisdiction. To repeat, forget about the figures because this was decided under the old law. So the question is whether the RTC should have dismissed the complaint on the ground of lack of jurisdiction, considering, okay, that the defendant was able to prove, okay, in the course of the trial that the assessed value is not within the jurisdiction of the RTC. Okay, now, anong sabi ng Supreme Court? Okay. The phrase, in a real action, the assessed value of the property, or if there is none, the estimated value thereof shall be alleged by the claimant and shall be the basis in computing the fees, okay, basically refers to the computation of the fees, not the purpose of jurisdiction, not for purposes of jurisdiction, okay. And therefore, when we speak about Rule 141, of the rules of court, it concerns the amount of the prescribed filing and docket fees, the payment of which bestows upon the courts the jurisdiction to entertain the pleadings to be filed. And second, the latest iteration of the same provision already deleted the phrase estimated value thereof. So the fair market value of the real property in litigation stated in the current tax deck or current zonal valuation of the BIR and the stated value of the real or personal property in litigation shall now be the basis for determining the amount of the filing fee to be paid. Clearly, 141 does not talk about jurisdiction. It talks about how much you're going to pay, how much the filing fee should be paid. Okay. Okay, now, so according to this case, it is clear that it is the MTC and not the RTC that has jurisdiction. Why? Because the the assessed value of the property is within the jurisdiction of the MTC, according to the Supreme Court. Okay. Any questions so far? Okay. Another basic principle, adherence of jurisdiction. Once jurisdiction has attached, it cannot be ousted by subsequent happenings or events, although of a character which would have prevented jurisdiction from attaching in the first instance. So even the finality of a judgment does not totally deprive the court of jurisdiction over the case. What the court loses is the power to amend, modify, or alter the judgment. Even after the judgment has already attained finality, the court retains jurisdiction to enforce and execute the judgment. Okay, anong example nitong? Okay. Before the law on administrative adoption became effective, di ba the jurisdiction to hear and determine and decide adoption petitions is with the RTC? Correct? Always with the RTC. Then came this law administrative adoption where you have to file it with the NACO, right? And with the RAC, okay? Or with the DSWD, okay? Now, so it's administrative adoption. So let's assume that the case was filed under the old law. It was filed before the RTC because the RTC has jurisdiction to hear and decide petitions for adoption. While the case is pending, ito na yung bagong administrative adoption. Will it now deprive the RTC from proceeding and deciding that petition for adoption? The answer is no. Why? Because of the general rule. And what is the general rule? The general rule being, once jurisdiction has attached, it latches on. And it cannot be ousted by subsequent happenings or events. So that is the general rule. Pero syempre may mga exceptions din yan. Anong exception? When the subsequent statute expressly prohibits the continued exercise of jurisdiction. Okay. Or where the law penalizing an act which is punishable is repealed by a subsequent law. Okay? Clear. In cases of curative statute or in cases of when appeal has been perfected. Okay. Now, what is the effect of lack of jurisdiction? Example, ang example natin, final 500,000 pesos. It was filed before the RTC. You and I know that the RTC does not have jurisdiction to hear and decide, collection case amounting to 500,000 pesos. And yet the RTC, I do not know what possessed it, continued hearing it. Nag-decide pa siya. Now, what is the effect of lack of jurisdiction? Okay. Of course, we know that it is a void judgment. Okay, the proceedings and the judgment void. And a void judgment or order has no legal and binding effect, force, or efficacy for any purpose in contemplation of law. It is therefore non-existent, and such judgment or order may even be resisted in any action or proceeding. It is not even necessary to take steps to vacate or avoid a void judgment or final order. It may simply be ignored. And that's the case of Land Bank versus Spouses Placido. Okay? So pag walang jurisdiction ang court, ang proceedings yan void, jurisdiction over the subject matter, I have to be very clear. I have to correct myself. If the court rendered judgment, notwithstanding the fact that it has no jurisdiction over the subject matter, then it will result to a void judgment, and a void judgment is no judgment at all. It cannot be source of any right nor creator of any obligation. And all acts pursuant to it and all claims emanating from it will have no legal effect. Is that clear? Okay. Now, okay. Concept of residual. Last principle, ha? Hindi, tapusin ko na yung principle para pag ano natin, rule 1 na tayo. Okay? Now, two concepts, residual jurisdiction and the doctrine of hierarchy of courts. Can you please read, can somebody please read Rule 41, Section 9? Section, yeah. Can somebody read it, please? The concept of residual jurisdiction. Rule 41. What is Section 9 or Section 8 or Section 9?
Perfection of appeal.
Yes, yes. Can you please read it?
Section 9, perfection of appeal effect thereof. A party's appeal by notice of appeal is deemed perfected as to him upon the filing of the notice of appeal in due time. A party's appeal by record of appeal is deemed perfected as to him with respect to the subject matter thereof upon the approval of the record on appeal filed in due time. In appeals by notice of appeal, the court loses jurisdiction over the case upon the perfection of the appeal filed in due time and expiration of the time to appeal of the other parties. In appeals by record of appeal, the court uses jurisdiction only over the subject matter thereof upon the approval of the records on appeal filed in due time and the expiration of the time to appeal of the other parties. In either case, prior to the transmittal of the original record or the record of appeal, the court may issue orders for the protection and preservation of the rights of the parties which do not involve any matter litigated by the appeal, approve compromises, permit appeals of indigent litigants, order execution, send pending appeal in accordance with Section 2 of Rule 39, and allow withdrawal of it.
Okay, let's discuss the paragraphs. Okay. In the first paragraph, it says, okay, that the appeal is perfected insofar as the plaintiff is concerned. Okay, when he files his appeal in due time, which means if the plaintiff files an appeal, let's say June 10, that appeal is perfected as to him. Only. Okay. Which means because it is perfected only as to him, the defendant can still file, he received it June 5, therefore he has until June 20. Okay. He can still file on, let's say, on June 18, a motion for recall. Why? Because the appeal is perfected only as to the plaintiff, not as to both of the parties, mas lalo not also as to the court. Okay, now, so and that's the reason why the court can hear and decide still on the MR, because the court still has jurisdiction when the defendant filed his MR, because the period of the defendant is up to June 20. Clear? Now, let's assume hindi nag-file ang defendant. No filing. So as far as June 21 is concerned, walang nag-file. Defendant did not file. It is only the plaintiff who filed a notice of appeal. Then it is now perfected, okay, amongst the parties and the court. The court cannot change the decision anymore. Kasi perfected na yung appeal sa lahat sa kanila. Hindi na rin niya pwedeng baguhin, hindi niya pwedeng mag-entertain ng MR, wala na, hindi na pwede. Kasi perfected na yung appeal. Okay. Now, can you read again the last paragraph? Just the last paragraph.
In either case, prior to the transmittal of the original record of the record on appeal, the court may issue orders for the protection and preservation of the rights of the parties which do not involve any matter litigated by the appeal, approve compromises, permit appeals of indigent litigants, order execution pending appeal in accordance with Section 2 of Rule 39, and allow withdrawal of the appeal.
Okay. Remember that when, let's say this is RTC to the CA, if it's ordinary appeal, you elevate the records, right? So, para hindi nyo ito makalimutan, ano to? Bus, jeep, okay? Isasakay dyan yung records. Which means in-elevate na sa CA, natanggap na ng CA. wala nang pwedeng gawin ang Court of Appeals. Pero hanggang hindi pa yan na-elevate, hindi pa na-transmit, prior to the transmittal of the records, the court can what? Issue an order, okay? Acting on the motion filed, discretionary execution, Rule 39, Section 2, right? Approve compromise, withdrawal of appeal, etc. Correct? It says there. Yan ang konsepto ng residual jurisdiction. Clear? Ang operative phrase, prior to the transmittal. Notice, perfected na yung appeal as to the parties and to the court. But the records are still with the RTC. Can the RTC still do something? The answer is yes. And this is the concept of residual jurisdiction. So, defendant, okay, siya nanalo defendant can file for motion for execution pending appeal. Hanggang nahandun pa yung record sa RTC. Can the court act on it? Yes, because the records are still with the RTC. So that last paragraph, okay, of Section 9 of Rule 41 is the concept of residual jurisdiction. Clear? Okay. Now, so residual jurisdiction of the trial court is available at a stage in which the court is normally deemed to have lost jurisdiction over the case or over the subject matter involved in the appeal. This stage, therefore, is reached, okay, upon the perfection of the appeals by the parties or upon approval of the records on appeal, but prior to the transmittal of the original records or the records on appeal. And in either instance, the trial court still retains its so-called residual jurisdiction to what? Issue protection or protective orders, approve compromises, permit appeals of indigent litigants, order execution pending appeal, and allow withdrawal of appeal. So kung iuugnay natin yan sa Section 2, Rule 39, discretionary execution, you look at it please para maian natin. Rule 39, Section 2, yung di ba execution as a matter of right, then the discretionary execution. I-file mo yung motion for execution, okay, bago ma-transmit yung records. Kasi pag na-transmit niyan, wala nang residual jurisdiction yung court, hindi na yung maaktuan. Why? Because wala na sa kanya yung records. Anong titignan niya? Wala na sa kanya yung records. Clear? Okay, now. So before the trial court can be said to have residual jurisdiction over a case, there must be a trial on the merits. Kasi may decision, there must be a trial on the merits, it must be conducted, the court rendered judgment, and the aggrieved party appealed therefrom. Okay, question. Listen carefully, ha? Kasi, okay. Plaintiff filed a case against defendant. Okay, plaintiff filed a case against the defendant. And plaintiff filed, okay, before the defendant filed an answer, an application for the issuance of a writ of replevin. Okay, granted. So yung personal property ni defendant na kay plaintiff. Clear? Okay. Now, meanwhile, defendant filed a motion to dismiss. Motion to dismiss. On the ground of, let's say, prescription. Granted. Okay. No appeal was made by either of the parties. Now, plaintiff now asked for the return, okay, after the period to appeal ng both of the parties. Plaintiff asked for the return the defendant rather asked for the return of the personal properties which were all given to the plaintiff by way of writ replevin. Sabi ng plaintiff, no, court has no jurisdiction to order the return. Sabi ni defendant, no, it can be returned. Okay, it can be returned because of the concept of residual jurisdiction. Who between the two is correct? The concept of residual jurisdiction will apply kung may nag-appeal. And during the prior to the transmittal of the records, may final na motion. Ito wala eh. Walang appeal. What do you think? Di ba hindi pwede? So, ma'am, wala nang remedy. Hindi mag-file ka ng panibagong kaso to recover it. Yan ang pinaka-remedy mo. Okay. Clear. So residual jurisdiction would refer to the following powers of the court, no, that may be exercised, okay, prior to the transmittal of the records. Issue orders for the protection and preservation of the parties which do not involve any matter litigated by appeal. Approve compromise agreements by the parties after the judgment has been rendered. Allow appeals by indigent litigants, order execution pending appeal in accordance with Section 2 of Rule 39, and allow withdrawal of the appeal. And this must be done, I repeat, prior to the transmittal of the original record to the appellate court in case of ordinary appeal and until the CA gives due course to the petition in case of a petition for review. And why is it important that the records of the case are still with the trial court to be able to exercise residual jurisdiction? Because the trial court cannot make a ruling if the records are not with it in its possession. Okay, and last doctrine before I call a break, okay, doctrine of hierarchy of courts. Under the doctrine of hierarchy of courts, where courts have concurrent jurisdiction over a subject matter. Example, the CA, the Supreme Court, the CA, and the RTC have concurrent jurisdiction to hear and decide petitions for certiorari, prohibition, mandamus, okay? Such concurrence of jurisdiction does not give any party seeking relief the absolute freedom, okay, to file a petition in any court of his choice, okay? Pursuant to this doctrine, a case must be filed first before the lowest court, possible having the appropriate jurisdiction, except if one has a very compelling reason which will allow, the party to a direct resort to a higher court. So the rule on hierarchy of courts determines the venue, therefore, of appeals. Such rule is necessary to prevent inordinate demands upon the Supreme Court's time. Okay? Gusto mo mag-file ng petition for certiorari, hindi ibig sabihin file mo kaagad sa Supreme Court. Baka pwede namang i-issue ng lower court. Wala namang compelling reason. Hindi sa RTC mo na muna i-file. Okay? Any questions? Okay, now, as I said, that is the general rule. In the case of Rama versus Moises, okay, this doctrine, okay, of hierarchy of court is the general rule. The exceptions are as follows according to Rama versus Moises. One, when there are special and important reasons clearly stated in the petition. Two, when it's dictated by public welfare and advancement of public policy, demanded by broader interests of justice, when the challenge orders are patent nullities, analogous and exceptional or compelling circumstances that would justify the immediate resort, okay, let's say to the Supreme Court, or when there are genuine issues of constitutionality, or of course the phrase when it involves transcendental importance. I will no longer differentiate civil action, criminal action, and special proceedings. Huh? Okay, but let me just differentiate again basic concepts, real and personal action. So the distinction between real action and personal action is important, most especially for purposes of determining the venue of the action. questions involving the propriety or impropriety of a particular venue are resolved initially by determining the nature of the action. So it's very important for the court to know what is the jurisdiction, whether the court has jurisdiction over the complaint. Okay. Pag real action, look at your Rule 4, Section 1. It involves what? Diba? The ownership, possession, or any incident in relation thereto. That is real action. All other actions will be personal. Okay. So pag may nagtanong, is the question, okay. Pag ang tanong is, was a case filed before the proper venue, please do not. Kaya alam ko kaagad mali. Yung discussion, it is an action in personam, utang na loob. Talagang wag nyo yan ilalagay. Pagka venue, ang dapat makita mo lang dyan, personal action, real action. Okay. Pagka pinag-uusapan, for example, is judgment. Okay, yung judgment, yung tawag dito, yung judgment, no? Diyan, pwede nyo nang ilagay yung in rem, in personam, quasi in rem. Wag naman yung ilalagay yung real action or personal action. Para lang tayo mas madaling makaintindi. Now, kailan pa natin gagamitin yung real action for purposes of determining the jurisdiction of the court? Why? Because for purposes of determining whether if it's a real action, you have to take into account the assessed value. Kaya pwede yung konsepto ng real action kung ang tanong ay jurisdiction din. Huwag niyong gagamitin yung in rem, quasi in rem, in personam. So ginagamit mo ang in rem, quasi in rem, in personam sa dalawang konsepto eh. In relation to Rule 39, okay, which is the binding effect of judgment, or sometimes in Rule 14, summons, how summons will be served. Kaya madaling ma-spot kung hindi naiintindihan ng estudyante yung konsepto eh. Notice I use the word estudyante, which means you're no longer student. So by now, there is a disputable presumption that you understand the concept, di ba? Do not worry, it's still disputable. Okay, anyway, joking lang. Okay. Now, so when we speak of in rem, in personam, quasi in rem, if you will not be able to understand this, please read the case of Frias versus Rolando Alcaide. Okay, Frias versus Alcaide. That case really explained it in a very clear manner, these three concepts. Okay, now, judgment action in rem, judgment rendered in this case would be binding against the whole world. Meaning to say, miski hindi mo siya inimplead, binding sa kanya yan. Example, cadastral. Okay, a decision rendered in a cadastral case, even if, let's say, you know, one neighbor is not a party to the case, that is binding, that has a binding effect as to him. Action in personam refers to the personal liabilities of the parties. It is binding against the parties, their privies, their assignees, their heirs, and their successors in interest, but not against the whole world. Okay. Its main purpose is to establish a case against a particular person or a person or property related to him. Okay. Example, action for damages. Okay. If meaning the plaintiff, if the plaintiff files a case purely for damages against the defendant, the judgment is binding only as to the two of them, not against the whole world. Okay. How about quasi in rem? There is a judgment rendered between the parties, but it relates with real properties. So A versus B. And the action is brought against this B, particular defendant, but the real motive is to yield a real property or subject property to certain things. Example, foreclosure of property. Okay. So A and B entered into a promissory note and then a contract na real estate mortgage. To cut the long story short, B did not pay, so A filed a complaint for judicial foreclosure of mortgage. Notice, okay, that the judgment, okay, is between A and B, sum of money. But because B will not be, let's assume B will just not able to pay, okay, within the period, equity redemption period, it now subjects the property of B, okay, to liability. So in an action quasi in rem, because it involves the liabilities of parties that would affect, okay, and relate with the personal or real property, okay, of the defendant. There is first a determination of a liability to pay, and such is only between the parties. Yan yung, kaya nga quasi, halong personal and rem. So may liability, may utang daw. Now, if the defendant is not able to pay, the court will allow the plaintiff to foreclose on the property, which will ultimately serve as payment. In this sense, okay, it is a real action too because it involves transfer of ownership and possession. Clear? Now, question. Tell me if it is, if the answer is wrong, is it true or false? Okay, tignan natin. Kung naiintindihan natin lahat ito, okay. Okay. An unlawful detainer case is a real action and an action quasi in rem. Again, an unlawful detainer is a real action and an action quasi in rem. It is a real action because it is an action that involves possession. That part is correct. But is it an action quasi in rem? The answer is no. Why? It's a personal liability of the defendant only. Does not bind the whole world. Okay? And the liability is person, ikaw yung umalis. It does not subject the property to answer for the liability of the plaintiff. Clear? Okay. Ito. Nullity of marriage. There's a decision that was rendered, okay, and then declaring the marriage null and void. It's a personal action, and it's a personal action and an action in rem. True or false? Who says correct? The decision declaring the marriage null and void is a personal action, and what did I say? And an action in rem. Who says it's correct? Who says it's wrong? It's wrong. It is, what did I say? It is a real action. It's a personal action, no? Because miski amoy lupa na yung asawa mo, hindi yan ownership property, di ba? Yan ay others, okay, personal action siya, okay? Pero action in rem siya kasi it binds the whole world. Even if, okay, bakit siya binds the whole world? Pag na-declare mo na yung marriage null and void, di ba? Narehistro mo na yan, pwede ka na magpakasal eh. Hindi mo naman kailangan lahat ng tao isama mo dyan, di ba? At gawin mong defend. It's binding against the whole world. And that's the reason why you can marry. Clear? Okay. So as I said, if you really want to study more on that, to read the case of Frias versus Alcaide. Okay. Okay. Let me go over this muna, kasi, okay, let me go on cause of action. I'll go to rule 2. Okay. Okay, what is a cause of action? Every ordinary civil action must be based on a cause of action. Pag sinabing cause of action, ordinary civil action, pagbasa mo, that's a complaint, that's the complaint, assert a cause of action. Ang hahanapin mo tatlo. First, the legal right of the plaintiff. Second, the correlative obligation of the defendant to honor plaintiff's right. Pangatlo, the act or omission of the defendant in violation of the plaintiff's right. Yang tatlong yan, dapat present yan sa ordinary civil action. Okay. For example, Pedro lent money to Juan. Okay. Okay. Now, and the defendant is supposed to pay the amount due, let's say December 25, 2023. Okay. Ngayon ang utang. It's January, it's what day is today? July 1. Okay. But based on the promissory note, sa December pa magbabayad. Okay. So clearly from the promissory note, the defendant has the right to be paid. And the defendant has the correlative obligation to pay because he borrowed money. Okay. Kung final ng plaintiff yung complaint August 1, the complaint fails to state a cause of action. Why? Because no breach has yet been committed because the payment is supposed to be made in December of this year. So the complaint fails to state a cause of action. Or what is your remedy if the complaint fails to state a cause of action? Do you pray to God? Yes, so that the God will tell you what's the right answer, di ba? You file an answer and you raise by way of affirmative defense that the complaint fails to state a cause of action. Clear. Now, a single act or omission can be violative of various rights at the same time, but there is only one delict or wrong, but there is therefore only one single cause of action, regardless of the number of rights violated. Question. I lent, Miss, what's your name? I'll use it. I have to have an estafadore. What's your name?
Kim.
Kim. Okay, madaling tandaan. Okay. Kim borrowed money from me. Okay, Kim borrowed money from me. I lent her, let's say 10 million pesos. Okay, lent her. She did not pay. Okay, so I filed a complaint, okay, from against her. I asked that I be paid 10 million by way of actual damages and then interests, okay, and then because I suffered mental anguish and sleepless nights because she did not pay me my hard-earned money, so I asked 1 million by way of moral damages, and to show to the and by way of example and to teach similarly situated persons, you know, to always honor his or her obligation, I want her to pay 1 million by way of exemplary damages. So that's 4, no? And then the 5th, of course, is my attorney's fees, which is what? Worth 20 million pesos. Mas malaki pa. Unconscionable. Okay, anyway. Ilan ako merong cause of action? I asked that I be paid actual damages. I asked to be paid the interest, exemplary damages, moral damages, and of course, attorney's fees. How many causes of action do I have? Just one. Kaya lang, because isa lang siya, marami akong pwedeng hinging reliefs. Kasi ang dami niyang dapat bayaran sa akin because of that one single breach. So please do not confuse it. Huh? Okay, now. Okay, so how will you know whether the complaint states a cause of action? Read the complaint and look for the 3 elements of a cause of action. So cause of action is a formal statement of the operative facts that give right, okay, to such remedial relief. Whereas right of action is a remedial right or relief granted by law to some persons, that is the plaintiff, whose rights have been violated by the defendant. The cause of action, therefore, is the very reason for the action or the delict or wrong committed by the defendant in violation of the plaintiff's right. Whereas right of action is the right to commence and maintain an action for the remedy or means afforded for the consequent relief. When you say cause of action, it is a matter of statement and is governed by the rules of procedure. Whereas your right of action is a matter of right which depends on substantive law. Okay? Now, relief. Relief is not the same as cause of action. Relief is the redress, the protection, the award or coercive measure which the plaintiff prays to the court. Yung prayer dun, hindi yan ang cause of action. Yan yung hinihingi mong relief. Okay? Now, rule number 1, when we speak of cause of action, Do not split a cause of action. It is, when you say splitting a cause of action, it is the act of instituting two or more suits on the basis of the same cause of action. And what is the effect when you split causes of action? Okay. The effect is you can file an answer. I'm sorry, I take it back. Yes, okay. Ulitin ko, ha? Let's assume it's a case of splitting of causes of action, which means that there are two pending cases that were filed on the same cause of action. Okay, two pending cases. What are your possible remedies? The defendant may choose either of the two. First, he can file a motion to dismiss on the ground of litis pendentia. Or the defendant may file an answer and raise an affirmative defense of litis pendentia. Okay. Gusto ko sana i-discuss ito pagdating na natin sa Rule 8, pero ngayon pa lang i-discuss ko na para mas malinaw pagdating sa 8. Okay. Notice the consequences. Huh? If the defendant files a motion to dismiss on the ground of litis pendentia, that is allowed, right? Under Rule 15. Okay, allowed yan. Denied, pwede ka mag-MR. Denied, pwede ka mag-certiorari. Correct? Walang bawal sa rules eh. Pero, if you filed instead an affirmative relief, an answer and then file and raise by way of affirmative relief, the ground of litis pendentia. Okay? You file it, it's denied. Number one, you cannot file a motion for reconsideration on the denial because of Rule 15. Prohibited pleading. Okay, on any action of the court on affirmative relief. And by Rule 8, Section 12, you cannot even raise it by way of certiorari. Remedy, you go to trial. Ulitin natin. Pag humingiti ka, I will follow your lead. Okay. Okay. Ulitin lang natin, ha? Kasi ano to eh, parang basta maraming ano. Anyway, ulitin. Okay. Meron kang splitting of causes of action. May dalawang kaso na final. Okay, may dalawang kaso final. Anong remedy ng defendant? Okay. Okay. Ang remedy ng defendant, dalawa. Mamili siya pwede. Ang consequences, however, iba. He can file a motion to dismiss. Okay? Pursuant to Section 1, Rule 9. Pursuant to Rule 15, Section 12. Okay? He can file a motion to dismiss on the ground of litis pendentia. Now, if the court denies the motion to dismiss, the defendant can still file a motion for reconsideration because that is not a prohibited pleading. And if it's denied, okay, and assuming there's grave abuse of discretion amounting to lack or in excess of jurisdiction, anong mangyayari? Pwede niyang icertiorari, Rule 65. Clear? Okay. What is the other remedy? The other remedy is you file an answer and you raise by way of affirmative defense, litis pendentia. Correct? Okay. Denied ang affirmative defense. Can you file a motion for reconsideration? The answer is no. Because of Rule 15, Section 12. Any action, you cannot file a motion for reconsideration on the court's action on your affirmative defense. And by express provision of law, okay, you cannot even subject the denial to a petition for certiorari prohibition. Basis, Rule 8, Section 12. What then is your remedy? Go to trial. Clear? Okay. Clear? Okay. Okay. Now, you cannot split causes of action. Okay, tell me if this is splitting. I filed a judicial foreclosure of real property against defendant. Okay. At the same time, I filed a collection case against the defendant, which is based on the same promissory note subject of the first case. Meron ba diyang splitting involved? O sige, ganito na lang. Mas madali. Okay, Kim, our favorite estafadora, ha? Okay. Okay, si Kim. So, Kim borrowed money from me. She also executed a real estate mortgage to serve as a collateral for the money she borrowed from me. So she executed 2 documents, promissory note and the real estate mortgage. Clear. Okay. She did not pay. Okay. Now, I filed a case against Kim. Okay. For foreclosure suit involving the property that was mortgaged. Denied, dismissed yung complaint ko. Talo ako. Talo. On the ground, nabayad na daw ako. Okay. So I filed another case. Okay. After the judgment, after I lost and the judgment became final and executory, I filed another case. This time, it is only based on the promissory note, which she executed, collection case. If you were the lawyer of Kim, what will you do? A, file an answer. B, file a motion to dismiss. And C, drink Starbucks coffee. Wala na akong maisip na iba. Will you file an answer or will you file a motion to dismiss? And go to trial. File an answer, go to trial. What will you do? No affirmative defense. What will you do? File an answer, go to trial, or file a motion to dismiss? File a motion to dismiss on the ground of res judicata. Because you split causes of action already. Why? Remember, in the foreclosure case, bago naman i-foreclose, di ba may ruling yung court, kaya sinabi ko bayad na eh. On your liability, on the promissory note. The first judgment in a foreclosure case is your liability on the promissory note. Yung utang, may utang ka ba? Wala. Sinabi ng court, wala ka ng utang, therefore hindi ka maka-foreclose. Bayad eh. And therefore, the same promissory note, gawin mo siyang subject, okay, ng collection case, hindi pwede. Kasi may ruling na yung court eh. Bayad ka na eh. You're splitting causes of action. And therefore, you can now invoke res judicata in a motion to dismiss. Clear? Okay. Now, okay, general rule, you cannot split, but you can join causes of action. So it is the assertion, when you say joinder of causes of action, it is the assertion of as many causes of action a party may have against another in one pleading. Okay, so but before you can join, you must comply with the following requisites. First, the party shall comply with the rules on joinder of parties, which is referred to in Rule 3, Section 6, which means the right or relief arises from one transaction or series of transactions. And number 2, question of fact and law to all the plaintiffs or defendants may arise from that action. That's very important. Huh? It must arise from one transaction or same transaction or series of transactions. Number 2, the joinder shall not include special civil actions governed by special rules. And third, where the causes of action are between the same parties but pertain to different venues or jurisdiction, the joinder may be allowed in the RTC provided one of the causes of action falls within the jurisdiction of said court and venue lies therein. And finally, the totality test, where claims in all causes of action are principally for recovery of money, the aggregate amount shall be the test of jurisdiction. Okay. Tell me if this is a proper joinder of parties or not. Okay. By the way, misjoinder of parties is not a ground to have the case dismissed, di ba? Okay. Okay. I filed again, Kim, rented, let's say, my apartment. Okay. So she started renting the apartment, let's say, from January to June. in July, okay, she borrowed money from me. Let's say in the amount of 3 million pesos. Okay. Starting August, she did not pay the rent. And the worst part is she did not pay the loan, which, by the way, we agreed must be paid within 1 month from the time I gave it to her. So she did not. So I sent her a demand letter to pay and vacate the premises being rented out and to pay the loan. Okay. So I filed now a case. Remember, the loan is 3 million. Okay. So I filed a case before the MTC. Okay, for unlawful detainer and payment of 3 million. And sige, 3 million. Does the MTC have jurisdiction to hear and decide those two cases? Was there a proper joinder of causes of action? What do you think? None, di ba? Kasi unang-una, yung unlawful detainer, original special civil action yan eh. Ibang rules. Yung 3 million, okay, ordinary civil action yan. And the worst part is, iba yung jurisdiction ng court. Yung unlawful detainer MTC, yung 3 million, RTC, hindi mo pwedeng isama yun. Okay. Now, for example, okay, silang tatlo. Okay, your name, A, B, C. Okay, kasi hindi ko alam names mo. Okay, A, B, C. Trabaho ko is I sell tires, gulong, no? Now, she bought tires for me, let's say, in the amount of 500,000 pesos. Then B bought tires for me on credit, 1 million pesos. Pag nagsastop ako, nag-a-add ako, ha? Kasi matalino ako masyado sa addition, kaya nag-iisip ako. Okay. And then Kim here bought from me, also on credit, tires worth 1 million. So 500, 1 million, 1 million. Okay. And all three of them did not pay. Okay. So I filed a complaint against the three of them in one complaint. And that's 2.5 million. So I filed it with the RTC. The RTC dismissed the case motu proprio on the ground that it has no jurisdiction over the subject matter. Is the RTC correct? Is the RTC correct in dismissing the complaint? Yes, yes, yes. The answer is yes. Bakit? Okay. Di ba kanina sinabi ko, do not forget Section 3 Rule 3, Section 6. Yung it must arise from the same transaction or series of transactions. These transactions are independent from one another. So you cannot join them. Diba? Utang niya, utang niya. It's a common question of fact and law, none. Utang niya, utang niya. Utang niya to, utang niya to. Bakit ko ipagsasama-sama sa iisang complaint? Eh, hindi naman sila related with one another. So, nagkaroon ng talagang no jurisdiction. It's not a case of misjoinder of causes of action. Hindi. Hindi naman iisang defendant, marami siyang causes of action. Iba-ibang defendant, iba-iba pa yung causes of action nila. So hindi mo yan pwedeng ipagsama. RTC does not have jurisdiction. In fact, hers is 500,000. That's small claims. Yours is 1.5. That's revised rules on summary procedure because it's more than 1 million, right? Sa'yo is eksaktong 1 million. Saan yun? Governed by what rule? Eksaktong 1 million. Sige, konti pang isip. Okay. Eksaktong 1 million. Rules on summary procedure, hindi naman in excess. So, hindi mo pwede siyang isama-sama. Clear? Okay. Now, so, When there is a misjoinder of causes of action, the erroneously joined cause of action can be severed and proceeded with separately upon motion by a party or upon the court's own initiative. Therefore, it is clear that misjoinder is not a ground for the dismissal of the action. So unlawful detainer may not be joined, let's say, for collection of sum of money, especially if the amount of money you're trying to collect is within the jurisdiction of the RTC. Okay? Now, splitting causes of action, joinder of causes of action, misjoinder of causes of action, non-joinder of causes of action. Okay. There is a single cause of action, and then you split it. You file different cases. Okay. You file different cases based on the same cause of action. That is prohibited. Why? Because it results in multiplicity of suits and it may be dismissed on the ground of litis pendentia or res judicata. Joinder of causes of action. There are several causes of action. Example, it's a petition to claim illegitimate filiation and at the same time support. Pinagsama, pwede yun. Okay, that is encouraged because it minimizes multiplicity of suits. Misjoinder, wrongfully joined causes of action. Okay, not a ground to have the case dismissed. Remedy, you file a motion to drop or sever. Non-joinder, a cause of action is not included. Okay, not a ground for dismissal. Okay, question. Kim borrowed money from me, one in July. Okay, so covered by promissory note 1. And another promissory note 2, she executed in my farm. She borrowed money again, let's say in November. Okay. Come January, neither one of the promissory notes, okay, neither of the promissory notes were paid by Kim. The first promissory note amounted to 1.5 million. The second promissory note amounted to 2 million. Okay. 2 separate promissory notes executed on 2 different occasions. I filed the case before the RTC. Okay. Question number 1, how many causes of action do I have? Question number 2, does the RTC have jurisdiction over the complaint I filed, which included the 2 promissory notes? How many causes of action do I have? Okay, 2. Okay, 2. Promissory note 1, promissory note 2. What court has jurisdiction? I mean, does the RTC have jurisdiction to hear the case? 1.5 million and how much was the other one? 2 million, di ba? So 3.5. Does the RTC have jurisdiction? The answer is yes. And what is the basis for saying that the answer is yes? The application of the totality rule. Okay. Where there are several causes of action between the same or different parties embodied in the same complaint, and the amount of the demand shall be the totality of the claims in all causes of action, irrespective of whether the causes of action arose out of the same or different transaction. So clearly, a joinder of causes of action is not mandatory. It is only permissive. Hence, a party may desire to file one case, okay, for that 1.5 M and another case for the 2 million, but the 1.5 will be governed by the rules on summary procedure. The 2 million, which is not in excess, will be governed again by the rules on summary procedure. Pero pag pinagsama mo sila, hindi na yan MTC. RTC na yan because of the totality test. Clear? Okay. There's a whale of a difference between failure of cause of action versus lack of cause of action. When you, this is the case of Lourdes Sweets versus Binaro. Okay. Failure to state a cause of action and lack of cause of action are 2 different concepts. No? Failure to state of cause of action refers to the insufficiency of the pleading. May complaint, binasa mo. Wala, may plaintiff's right, check. Defendant's obligation to honor plaintiff's right, check. Wala pang breach. So the complaint fails to state a cause of action. And what is the remedy? You file an answer and you raise by way of affirmative defense that the complaint fails, okay, to assert a cause of action. Okay, now, how about lack of cause of action? Lack of cause of action refers to a situation where the evidence that was adduced by the plaintiff failed to prove the cause of action as alleged in the pleading. So hindi na patunayan yung cause of action ng plaintiff. What will be your remedy? Your remedy will now be demurrer to evidence. Okay? Okay. You know, some examiners are very precise, no? They require precision. So please, there's a difference between failure to state and lack of cause of action. Kasi iba kasi yung remedies dyan. Okay. The case of Flores versus Malyari Phillips. Okay. I will just discuss the principle, no, as held in the case. One plaintiff versus one defendant. Okay. Plaintiff sues the defendant on two or more causes of action. In such case, the amount of the demand, if it's the two causes of action refer to money, shall be the totality of the claims in all causes of action, irrespective of whether the cause of action arose out of the same or different transaction. You have second situation. One plaintiff, two or more defendants, or two plaintiffs, one defendant. When there are two or more plaintiffs having separate causes of action against a defendant, join them in one single complaint, as well as to cases where there's a plaintiff who has several or separate causes of action against two or more defendants, okay, in a single complaint. The causes of action in favor of the two or more plaintiffs or against the two or more defendants should arise out of the same transaction or series of transactions, and there should be a common question of fact and law. Yun yung example na si A, si B, C, bumili sila sa akin ng tires, iba-ibang transaction did not arise from the same transaction. So different defendants, different causes of action, and then arising from different transactions do not apply the totality rule, because they did not arise from the same transaction or series of transactions. Clear? Okay. Parties to a civil action. You know, how would I put it? Okay, if you look at the rules of court, maayos naman ang pagkaayos niya, di ba? Una, jurisdiction, BP 129, tapos yung cause of action. Pag binasa mo, pag nagdemanda ka civil action, that may cause of action ka. Okay? Then, sino si A and B? For example, you're asked to prepare a complaint for damages. Okay. Lahat nito, yung caption, may rason yan eh. Lalagay mo Republic of the Philippines. Bakit? Kasi wala tayo sa Nicaragua, di ba? Nasa Republic of the Philippines tayo. Ganun lang kasimple. Okay? Then Regional Trial Court, BP 129. And it's a mandatory loss. Okay? Now, nakita mo damages. Ibig sabihin, kung nasa RTC yan, dapat ang damages niya must exceed 2 million pesos. Right? So pag binasa mo yung complaint, tapos nakita mo sa prayer mo, pay the defendant, for defendant to pay the plaintiff the amount of 500,000 pesos. Dismissible. Okay? Kasi nakita mo na damages, dapat siya, ng allegation mo dyan, 2 million. In excess of 2 million. Okay. Branch 1 to 3. Makati City. Rule 4. Okay? Rule 4. Kung Rule 4 yan, tapos may promissory note of damages, kunwari, simple damage, tort, no? Damages. So you know it's a personal action. So the venue, isa dyan, dapat nakatira sa Makati. Kasi kung tort yan, tapos in excess of 3 million, ito'y nakatira sa Zamboanga, ito'y nakatira sa Cagayan de Oro, tapos final mo sa Makati, gusto mo lang mag-shopping sa Glorieta. Kaya dismiss yung complaint dyan. Okay? So dapat makikita mo yan sa complaint. Okay. Now you have rule 3. Who are the parties? Who should sue? Who can be sued? Okay? Obviously, B should be sued. Okay. Siya yung injured. Okay? Siya yung nag-injure. Okay? Cause of the injury. You don't sue C if he's not the one who caused the injury. Because otherwise, a complaint will fail to state a cause of action. And it's going to be dismissible. Why? Because C is not a real party in interest. Clear. So when you do your complaint, okay, when you review your REM law, especially this one, also have in mind how to prepare a complaint for the forms. Okay, now, let's talk about parties to an action. The plaintiff, of course, is the claiming party, okay, and the original party, and the one who files a complaint. But please take note, the term plaintiff does not exclusively apply to the original plaintiff. It can also apply to the defendant. Am I right? It can apply to the defendant if the defendant files a counterclaim. Okay, and or then of course your third party plaintiff. Okay, now, who can be parties to a civil action? Natural persons, juridical persons, and entities authorized by law. Okay. Now, who are the juridical persons? Let's not forget civil code. Okay, Article 44, the state and its political subdivisions. Other corporations, institutions, and entities for public interest or purpose created by law, and corporations, partnerships, and associations for private interest or purpose to which the law grants a juridical personality, separate and distinct from each shareholder, partner, or member. Now, one need not be a natural or juridical person to be a party to a civil action. As long as an entity is authorized by law to a party, such entity may be sued, or both. Okay. Can a dissolved corporation be a party to a case? Can a dissolved? The answer is yes. A dissolved corporation, remember, may prosecute and defend suits by or against it, provided that the suits occur within 3 years after its dissolution, winding up period. Okay? Now, 2, the estate of the deceased person is considered and accorded recognition as a juridical entity that has a personality of its own. And a corporation by estoppel is precluded from denying its existence, and the members thereof can be sued and be held liable as general partners. Now, let's talk about real parties in interest. Ang real parties in interest, yan ay indispensable party or necessary parties, correct? Okay. So sa lahat sila, real parties in interest. Okay. So a real party in interest is the party who stands to be benefited or injured by the judgment in the suit, or the party entitled to the avails of the suit. And when we say real parties in interest, the interest must therefore be real, which is substantial, okay? And therefore, it is not based on mere expectancy or a future contingent, subordinate, or consequential. It is an interest that is material and direct, as distinguished from a mere incidental interest. So only parties who are natural or juridical persons are allowed to be real parties in interest, or those authorized by law. Okay? So unincorporated persons, or those who represent themselves as a corporation, cannot sue because they do not have the capacity to sue, okay, and to act. However, they can be sued. because they can be stopped from saying that I'm not an incorporated entity. And that's a ruling in the case of Chiang Kai-shek versus Court of Appeals. Okay, now, an information was filed, okay, with Golanco as a private complainant, okay, and it was filed against Fung. Now, the respondent, okay, the prosecution was able only to present 2 witnesses after almost 6 years. And on those 2 occasions, the prosecution failed to present pa its witness. Okay. So consequently, the RTC issued an order terminating the presentation of petitioner's evidence. So the petitioner alone, by his lonesome self, okay, and that was Golanco, filed a petition for certiorari assailing the Court of Appeals decision, claiming that the RTC judge committed grave abuse of discretion for not issuing a subpoena to require the witness to attend. Okay. Now, so CA dismissed the petition. The RTC now committed grave abuse of discretion when it dismissed the action. No? So the issue is whether there was a need to join the people of the Philippines in the case. Ang nag-file si private complainant lamang. The criminal case was dismissed. Okay, ulitin ko lang yung facts. The criminal case was filed. So a criminal case was filed against Fung. Okay. And the people of the Philippines failed to present its evidence. So the court dismissed the criminal complaint. The private complainant was the one who only filed the petition, okay, for certiorari before the Court of Appeals. So the Court of Appeals dismissed it. So the issue pertinent to our, okay, discussion is whether there was a need to join the people of the Philippines as a party in the petition that was filed before the Court of Appeals. Okay. In this case, so the petitioner, private complainant, did not join the people of the Philippines as a party in his action for certiorari before the CA. He ignored that the people of the Philippines is an indispensable party. Okay? Now, in fact, the petitioner did not even obtain the consent of the OSG to his petition for certiorari. At the very least, he should have furnished a copy of the petition for certiorari to the OSG prior to the filing thereof, but even that he did not. Now, please take note that the private petitioner, okay, violated the provisions of the Administrative Code of 1987, which provides that the OSG is supposed to represent the government in the Supreme Court and the CA in all criminal actions, okay? And this was not done. So tama lang na i-dismiss. Okay, now, any questions? Okay, now, let me just, okay, really, okay, let me go to the provisions. Just give me a minute, please. Okay. Section, just 1 minute, huh? Okay, there. Section 3, representatives as parties. Some actions may be allowed to be prosecuted or defended by a representative or someone acting in a fiduciary capacity like a trustee of an express trust, guardian, or an executor. Okay. Notice that an agent acting in his own name, okay, an agent, if, for example, again, Kim, so sabi ko kay Kim, pakibenta mo nga itong aking diamond ring. So si Kim, binenta niya kay K. Kim and K. Easy to memorize. Okay, K. Okay. Tapos hindi nagbayad si K. Hindi nagbayad si K. Nagdemanda sa kanya kasi hindi ko naman siya kilala, no? Ang ginawa ni Kim, she filed a case. Kim versus K for collection of sum of money. Okay. And in the petition and in her complaint, she said that she is my agent, that I am the principal and I constituted her as an agent to sell the ring, okay, to K, and K bought it and K was not able to pay it. If you were the lawyer of K, what is the proper procedural recourse? file an answer and go to trial without raising any affirmative defense, file an answer with an affirmative relief that the complaint fails to state a cause of action, or file a motion to dismiss. What's a proper remedy? What will be your recourse? The proper recourse is you file an answer and raise the affirmative defense that the complaint fails to state a cause of action. Why? Because the action was not brought in the name of the real party in interest. Sino ba ang real party? Di ba ako, hindi naman si Kim? Ako yung may karapatang bayaran. At si Kim hindi nagbayad sa akin and therefore nag-violate siya ang breach na commit. Hindi naman si Kim ang dapat bayaran dahil ahente ko lang siya eh. Ako ang dapat bayaran. Now, note however, if an agent is acting in his own name and for the benefit of an undisclosed principal, may sue or be sued without joining the principal except for the contract involves things belonging to the principal. So therefore, an agent may sue, okay, solely in his name and without joining the principal when the following elements are present. Number one, the agent acted in his own name during the transaction. The agent acted for the benefit of an undisclosed principal. And third, the transaction did not involve the property of the principal. Now, when the elements are present, then the agent becomes bound as if the transaction were its own. Clear? Okay, question. Okay. Let's say I live in the United States, okay? But I came back and then I met my townmate, Kay, okay? Kay lives in Manila, okay? Kay lives in Manila. And then Kim, okay, is let's say my niece who lives in Quezon City. Because I was about to go home, so I executed a special power of attorney in favor of Kim who lives in Quezon City. And I gave her the authority to sue Kim, Kay, the debtor who lives in Manila, in the event she fails to pay. Okay, she did not pay. So despite what you call this, despite despite the demand letter having been served and received, Kay did not pay. Okay. So Kim sued. Okay, Kim sued. No, it has to be, sorry. Pareho pala silang I repeat ha. Both of them live in Manila. Again, my agent and my debtor both live in Manila. So I live in the United States. Okay. So Kay did not pay. Kim sued in Manila. Okay. Now, kasi both of them live in Manila, so Kim sued in Manila, collection case. Now, what she did was she raised by way of affirmative defense, okay, in her answer, that the complaint should be dismissed because there was failure to comply with the condition precedent. And what was the condition precedent? She did not first avail of the Katarungang Pambarangay law, considering that both of them live in Manila. Okay. If you were the judge, would you grant or deny the same? Grant? Who says grant? Kasi, okay, because the real party in interest is not Kim. It's not Kim. The real party in interest is me. It's Sol Mawis as represented by Kim versus Kay. I do not live in Manila. I live in the States. And since I'm the real party in interest and I live in the States, There's no way that it can be said that we live in the same city or municipality, which will bring into operation the provisions of Katarungang Barangay. And therefore, okay, the affirmative defense should be denied. Clear. Okay. Okay, imagine ha, real party in interest pag-uusapan, hinaluan bigla ng Katarungang Pambarangay, ang layo, di ba? But that's the case. Okay. Okay. Any questions so far? Okay, so let's discuss the case of. Okay. Okay. Okay, let's talk about spouses. Husband and wife shall sue or be sued jointly. And what are the exceptions to the rule where the one spouse can just sue? A spouse without just cause abandons the other or fails to comply with his or her marital obligations with respect to marital, parental, or property relations. That will be Articles 101 and 108 of the Family Code. Or a spouse may mortgage, encumber, alienate, or dispose of his or her exclusive property and appear alone in court to litigate. Article 111 of the Family Code. In cases of separation of property, okay, Article 145, and in any actions referred to Articles 25 to 35 of the Civil Code. If you will notice, these 4 exceptions to the rule that husband and wife shall sue or be sued jointly. The reason why the husband can sue all by himself is because, number one, it concerns his exclusive property. Or the wife, his or her, it concerns only her paraphernalia property. Or there was an injury committed, okay, na ikaw lamang yung na-injure, okay? Anong ibig sabihin nun? Okay, kunwari, nasagasaan yung asawa mo, hindi naman namatay, no? Naputo lang yung daliri. Pwede bang husband and wife yan ang mag-sue? Hindi. It's the wife only who could sue. Because the injury is personal to her. Okay, clear. Now, how about minor or incompetent persons? A minor or incompetent may sue or be sued with the assistance of the father, the mother, or the guardian ad litem. So the suit can be brought by or against him personally, but with the assistance of his parents and guardians. Which brings us now to, just if you recall your persons, no? Persons and family relations. If it's let's say, a petition to claim legitimate filiation, and the child who sues, let's say, is a minor, di ba? Minor child represented by his biological mother, Petra, whatever. Okay? Versus ganun. Kasi wala siyang capacity to act. Kasi minor pa siya. Kaya meron in as represented by. Okay? Clear. Now, permissive joinder of parties. Okay, what are the requisites of permissive joinder of parties, which is actually one we discussed earlier, no? In relation to joinder of causes of action. Permissive joinder of parties, the right to relief arises out of the same transaction or series of transactions. There is a question of law or fact common to all the plaintiffs and the defendants, and such joinder is not otherwise prescribed by the provisions of the rules on jurisdiction. What do you mean by series of transaction? Series of transaction means separate dealings with the parties, but all of each dealings are connected with the same type of the subject matter of the suit. Okay. Now, okay. Okay. Let me just go to the doctrine of non-suability. Again, I will leave it to your consti, ha? I will not discuss it anymore. Okay. Okay, let's go now to compulsory. Okay. Joinder of indispensable parties. Okay. Okay, remember that indispensable parties is an indispensable party is a kind of real party in interest. Ang indispensable are those with such an interest in the controversy that a final decree would necessarily affect their rights so that the courts cannot proceed without their presence. Okay. So let's distinguish first indispensable party and necessary party. Indispensable, the action cannot proceed unless they are joined. Dapat lagi siyang kasama. Okay. Necessary, action can proceed even in the absence of some necessary parties. Okay. Indispensable party, hindi mo sinama. Then the judgment will be without effect if indispensable parties are not impleaded. If it's a necessary party, the case may be determined in court, but the judgment therein will not resolve the controversy if a necessary party is not joined. Indispensable party are those with such interest in the controversy that the final decree would necessarily affect the right so that the court cannot proceed without their presence. Necessary party, their presence, okay, are necessary only to adjudicate the whole controversy. But their interests are separate and distinct that a final decree can be made even without them being present. Okay. Tell me if this person is indispensable or necessary. The three of you are co-owners to a property. I am the lessee. I did not pay. Okay. So you filed a case against me after, of course, complying with all the requirements. No, you filed a case against me. Co-owner, one co-owner filed a case against me for unlawful detainer. Okay. Now, I filed a motion to implead the two because they are indispensable parties. Am I right? Am I right? The answer is, of course, I'm very wrong. No, I'm very wrong. Why? Okay, because based on law, one of the co-owners can bring a suit for the others. Okay, now, reverse. The three of them are co-owners. But si Kim, consistent with her estafadora outlook in life, sabi niya, hindi, akin to. Okay, hindi lang pala siya estafadora. Greedy pa siya, okay? Sabi niya, this property is mine and mine only. And she asserted it, okay? And now, she wants to recover possession of that property kasi itong dalawa, nandun sa co-owned property. Sabi niya, alis kayo dyan. Okay, kasi akin to. This is my property. So she's asserting ownership with it. She sued only Kay. Kasi hindi niya alam ang pangalan ng isa co-owner. What's her name?
Diana.
Si Diana. Hindi niya sinama si Diana. File ngayon si Kay. Motion to implead indispensable party Diana. Is she right or is she wrong? This time she is right. Okay, because it will affect her. So any judgment that will be rendered by the court without Diana being pleaded will be void. Okay. Joint debtors. Are they indispensable parties or not? Joint debtors. I lent them 1 million pesos. Sige, para RTC, 10 million pesos. Okay. Do I have, and they are joint ang obligation nila, do I have to sue them both? Okay. Joint, joint. They're indispensable as to his share, to her share. Indispensable as to the 500. Indispensable as to the 500. But I cannot sue you for the entire 10 million, no? I 500, 5 million. Why? Because it's joint eh. Diba? So you're indispensable as to your share, but necessary with respect to the share of the other. Okay. Solidarity debtors, kayong dalawa. I sued you. So I'm a motion to implead because she's an indispensable party. This time the answer is no. Because I can sue you. That's complete, no? You can sue now. But can you file a third-party complaint? Okay, against her to recover the amount of money that I am recovering from? Yes, then she becomes a necessary party. Clear? Okay. Now, what is the failure of joining an indispensable party? Okay. The judgment, the proceedings void, even against the persons who are participants in that case. The judgment of the court cannot attain finality. Okay. The absence of an indispensable party renders all subsequent actions of the court null and void for want of authority to act, not only as with respect to the absent party, but even as to those who are present. Okay. Now, please take note, huh? What is the remedy if, okay, if you failed to implead an indispensable party? You cannot file a motion to dismiss. Why? Because a non-inclusion of a party is not a ground to have the case dismissed. You cannot. What therefore is your remedy? You file a motion to implead indispensable party. Okay. And if the court grants it, then the plaintiff must implead the indispensable party. And how will the plaintiff implead? File an amended complaint, this time impleading the indispensable party. Now, if despite the order of the court directing you, defendant, to implead the indispensable party, you did not, talagang hindi mo sinunod si court, okay? Then the defendant now may file a motion to dismiss on the ground of Rule 17, Section 3. The plaintiff is a disobedient party. And the court will dismiss it because he did not comply with the order of the court. And that is under Section 3, Rule 17, a dismissal with prejudice. Kasi hindi ka sumunod. Okay. Okay. Any questions? Okay. Now, kung hindi kayo sigurado kung indispensable or necessary, ilagay nyo lang yung test. Again, at least may 1 point kayo, no? Hindi 0. Hindi 2. Sayang tinta. By the case of Republic versus Sandigan Bayan, the test to determine whether a party is an indispensable party, number 1, first question, can the relief be afforded to the plaintiff without the presence of the other party? I repeat, can the relief be afforded to the plaintiff without the presence of the other party? Number 2, can the case be decided on its merits without prejudicing the rights of the other party? Okay, these 2 questions. Now, again, if you are ordered to implead, how do you implead? You have to file an amended complaint. But you just don't add. You must be able to show that there is a cause of action against that new impleaded defendant. Okay, clear. Okay. So in the case of Aaron versus Rialon, the presence of all indispensable parties is a condition sine qua non for the exercise of judicial power. It is precisely when an indispensable power is not before the court that the action should be dismissed. And the plaintiff is mandated to implead all indispensable parties, and the absence of one renders all subsequent actions, including the judgment, as null and void. Okay? And therefore, one who is not a party to a case is not bound by any decision of the court. Otherwise, he will be deprived of his right to due process. Okay. There's one case, Domingo versus Kerr. Okay. This is where the Supreme Court said the following. Okay. The non-joinder, rather, of an indispensable party is not a ground for the dismissal of the action. Okay, why? Because the proper remedy is you just file first a motion to implead. Because non-joinder or misjoinder of parties is not, okay, is not a ground to have the case dismissed. Okay. Now, pag nag-file ka ng motion to dismiss, okay, nag-file ka ng motion to dismiss, you were, and it was you file a motion to implead, and the motion was granted, you better be sure that you comply with the order of the court. Because if you don't comply, then then the defendant can file a motion to dismiss on the ground of Section 3, Rule 17. And if it's dismissed, that is a dismissal with prejudice. Okay, now. Okay. Okay. Question. Listen to the question, ha? Okay. This is a case. So Christine Chua filed a complaint for damages against, against the defendant. Okay. Now, together with her, she pleaded as a party plaintiff her brother Jonathan. So the title of the case is Christine versus Jonathan, then against the defendants. Okay, ano ba ang pinagmulan? Based on the allegations of the complaint, the following were alleged. Jonathan issued a check in favor of the defendant. Okay. The check was dishonored. Okay. Now, ang nangyari, so a BP22 case was filed. Okay. And when the BP22 case was filed, a warrant was issued. And the warrant of arrest was implemented on Christine. Si Christine, ang nag-issue ng cheque, yung kapatid niya si Jonathan. Pero yung warrant of arrest, okay, na-issue against Christine, in-implement kay Christine. Eh di syempre napahiya itong si Christine because she's a medical student, okay? Now, so yun yung basic facts. And then, when Christine and Jonathan filed the complaint, it was only Christine who executed, okay, the certificate against non-forum shopping, against forum shopping. Okay, so the defendant now filed a motion to dismiss because Jonathan did not execute at the certification on non-forum shopping. If you were the judge, would you grant or deny the motion to dismiss? Galing yung kaso, no? Yung tapos non-forum shopping pero ang pinag-uusapan natin real party in interest. Note the facts, ha? It was Jonathan who issued, okay? And the subsequent criminal case was filed. The warrant of arrest was erroneously served on Christine. And when it was served, of course, her reputation was besmirched. So she filed a case for damages. And she filed the case together with the brother. Okay? And the brother did not execute the certification of non-forum shopping. Okay, must the case be dismissed? The question is why? You just know it, diba? The answer is the case, okay, should not be dismissed. Why? Because in the first place, Jonathan is neither an indispensable or necessary party. Okay? He's not. Nasama lang siya sa kwento. Sino ba yung may right? Di ba si Christine? Sino yung nag-violate ng rights? Si defendant. Okay. Bakit ano bang right ni Christine na hindi siya aresto dahil hindi siya kasama sa kwento eh? And yet, her reputation was besmirched because the warrant of arrest was implemented against her. And therefore, the story about Jonathan is just part of the narrative. His right was never violated. The defendant had no correlative obligation to honor the right because to begin with, there was no right to be protected based on the complaint. And what therefore is the moral lesson of the story? It is the indispensable or necessary party who are required, okay, to execute the certificate of non-forum shopping. Clear? Okay. 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 Misjoinder, and this is the case of Republic versus Campos, misjoinder and non-joinder parties is not a ground for the dismissal of an action. Parties may be dropped Parties may be added by order of the court on motion of any party or on the court's own initiative at any stage of the action. Okay. Now, however, the non-joinder or misjoinder of parties rule does not comprehend whimsical and irrational dropping or adding of parties. Okay. No one is just free to join, okay, anybody in the complaint. So the rule on non-joinder, misjoinder presupposes that the original inclusion was made in an honest conviction that it was proper and that the subsequent dropping is requested because it turned out that a mistake was committed. Okay? Okay. The case of Plasavas versus Court of Appeals, Article 487 of the Civil Code provides that any one of the co-owners may bring an action for ejectment. The article covers all actions for the recovery of possession, including action publicana and action reivindicatoria. So a co-owner may file a suit without necessarily joining all the other co-owners as co-plaintiffs because the suit was instituted precisely to benefit all the co-owners. Okay, so the basis will be your Article 487. Let's focus on necessary parties. Okay, Section 8. So a necessary party is a party who is not indispensable. What kind of definition is that, no? A necessary party is a party who is not indispensable, but ought to be joined as a party if complete relief is to be accorded as to those already parties or for a complete determination or settlement of the claims subject of the action. Now, is the inclusion of the necessary party mandatory? Okay. Technically, the answer is not mandatory because the case can proceed. However, the inclusion of the necessary may only be excused on meritorious ground, absent which the court shall order them to be impleaded if the jurisdiction over this person can be obtained. You don't implead, it will not result to the dismissal of the complaint. It will only result as a waiver of right to go against the necessary party. So Section 3, the Rule 17 does not apply when the party failed to implead an unnecessary party. Waiver lang yan. Kasi meron kang indispensable kaya dire-diretso yan. Okay, clear. Unwilling plaintiff. Basta sa unwilling plaintiff, ganito lang yan. Tatlo kayong plaintiffs dapat. Ayaw sumama ni plaintiff A, B, and C lang. Laban, kunwari co-owners, no? Kunwari tayo 4 co-owners. Favorite kita, Diana. So ang ginawa ko, ayaw ko sumama. They want to sue you. Sabi ko, no, she's my favorite eh. I don't want to sue her. Naawa ako sa kanya. Okay? Sa kanya na lang. Basta sa kanya lang. So, I have to be impleaded because we're trying to recover the property from her. Okay, kunwari. The 4 of us, okay, the 3 of you are my children. Okay, the 3 of you are my children. Now, I want to, what you call this? I want to refurbish our tattered house and lot. Okay? May maliit tayong bahay, gusto kong paayos, kaya lang wala akong pera. So, anong ginawa ko? Nag-usap tayo, okay, ipapalipat ko lang sa'yo, I'll make it appear that I donated the property to you. Okay? I donated the property to you. And then, so because you're the only one who's earning, now when the title has been transferred to you, you can now borrow so that we now have funds to renovate our property. And then I died. Okay? And when I died, sabi niya, akin na to. E di syempre itong dalawa, ayaw. Hindi, atin yan. But Kay doesn't want to sue her because naaawa siya. Now, it cannot only be Kim who will sue. It has to be the 2 of them. So you can be named as an unwilling co-plaintiff. Okay? So technically, it's going to be A versus Diane and then K as an unwilling co-plaintiff. Clear? Okay, now. Okay, so under Section 10, Rule 3, it may be, an unwilling plaintiff may be made a defendant, and the reason therefore shall be stated in the complaint. Okay. Now, Section 11, as I said, is very important because neither misjoinder or non-joinder of parties is a ground for the dismissal of an action. Parties may be dropped or added by the order of the court on motion or on its own initiative. Any claim against a misjoined party may be severed and proceeded with separately. Okay. Let me go over this. Okay. Section 12, class suit. Okay, elements ng class suit, ha? Elements. The subject matter of the controversy is one of common or general interest to many persons. Number 2, the parties affected are so numerous that it is impracticable to bring them all to court. And third, the parties bringing the class suit are sufficiently numerous or representative of the class and can fully protect the interests of all concerned, and the representatives sue or defend for the benefit of all. Now, a class suit does not require commonality of interest in the questions involved in the suit. What is required by the rules is a common or general interest in the subject matter of the litigation. And the subject matter of the action is meant the physical, the things real or personal, the money, the land, the chattels, and the like, in relation to the suit which is prosecuted and does not refer to the delicate or wrong committed by the defendant. So it is not also a common question of law that sustains a class suit, but a common interest, no, in the subject matter of the controversy. Now, if the class suit is not proper, the remedy of the parties is either to bring the suit individually or to join them under the rules on permissive joinder of parties. Okay. Okay. Alternative defendants. So example here is a person can sue a principal and an agent together, then you have then apply the provision on alternative defendants. Now, can you sue a defendant who is unknown to you? The answer is yes. You have a defendant, but the defendant is unknown. So you use a fictitious name. Okay. And the plaintiff can use a fictitious name. Okay. So plaintiff Pedro versus Jane Doe. Okay. Now, how will summons be served? Okay? If the defendant is unknown. Hindi mo nga kilala sa defendant. So how will summons be served? So if you are in Section 14, Rule 3, Section 14, Rule 3, ha? Isusulat ko sa katabi niyang Rule 14, Section 3, summons, how summons is served. Rule 14, Section 16. That is how summons will be served. Service upon defendant whose identity or whereabouts are unknown. Okay? The summons may be served through publication to acquire jurisdiction over the person of the unknown defendant. Once the unknown defendant now files an answer, okay, then file an answer. Then you now file, the plaintiff will file a motion to admit amended complaint. This time disclosing the name of the once unknown defendant. Okay, you have to amend it. Okay, you have to amend it para lumabas na yung totoong pangalan. Okay, now, how about can you sue a person without juridical personality? Look at your Section 15. Okay. Okay, sa title pa lang, a person therefore who is not a juridical entity can be sued, but they cannot sue. It cannot sue. Pwede siya maging defendant, pero hindi siya pwedeng maging plaintiff. Okay? So let's assume, okay, Pedro and Juan, again, not organized as a partnership, but doing business under the name of Pedro and Juan Partnership. Now, can they be sued under the name Pedro and Juan Partnership? How will summons be served? Okay, if they are not a juridical entity. Okay. Technically, technically, Pedro and one partnership cannot sue. Why? Because they are not a juridical entity, but they can be sued. Okay? They can be sued. Because Section 15 says, okay, that they can be sued. Now, how will summons be served? Service may be affected upon all the defendants serving upon any one of them or upon the person in charge of the office. So with respect to the judgment in this situation, please take note the provision on Section 6, Rule 36. And what is that? When a judgment is rendered against two or more persons, and it was sued as an entity without juridical personality, then the judgment shall set out the individual or proper names. So ang Section 15, Rule 3, Section 15, related with Rule 14, Section 7, and then judgment will be Section 6, Rule 36. Hindi pwedeng ilagay yung pangalan la as a corporation. Walang corporation, hindi mo ma-execute. Kaya ang judgment nakalagay sa pangalan nila individually para ma-execute. You get it? Huh? And that's the flow of things. Okay, now, death has always has an effect in a case. Katulad ng nabanggit ko kanina, for example, you filed a case, you did not know that the plaintiff is already dead at the time you filed the complaint. Okay, by reason of the case of Boston Equity, well, summons cannot be served on a dead person. Okay. Now, while the case is pending, may namatay, okay, hindi naman yan immediately na-dismiss. Ang tatanungin mo, ito ba ay personal, okay, in the sense that it's a personal action, it's a defendant lang ang magagawa, or this is an action that survives death. Okay. So we now go to Section 16. Death, therefore, always has an effect on the case. When death intervenes, intervenes while the case is pending, the first thing you will ask yourself, is this an action that survives death? And if the answer is yes, then the case will not be dismissed. And what are the actions that survive death? Okay, recovery of real and personal property, enforcement of a lien thereon, okay, damages, money claims expressed or implied. And so what is the test? Okay, again, kung hindi mo na alam kung magsisurvive ba to, hindi, ilagay mo yung test. The question as to whether the action survives or not depends on the nature of the action and the damages sued for. Okay. In a cause of action that survives, the wrong complained of primarily and principally affects property and property rights, the injuries to the defendant being merely incidental. Now, in a cause of action that does not survive, the injury complained of is to the person, the property and rights of the property affected being incidental. Okay. So, what are the actions that survive death? Example, actions that survive. Recovery of contractual money claims, whether it's oral or written. Recovery and protection of property rights, recovery of real or personal property, enforcement of a lien, recovery of damages, okay, for an injury to person and property and suits by reason of the alleged tortious act. What are the actions that do not survive death? Number one dyan, support. Pag namatay na yung hinihingan mo ng suporta, hindi ka na pwedeng hindi pa tuloy-tuloy yung kaso, namatay na yung nagbibigay sa iyo ng suporta. Okay? Or actions of performance on which cannot be delegated. Okay? Now, okay. I will discuss, okay, while the case is pending yan, the third, okay, what we discussed before action, the death, okay, happened before the filing of the case. Now we are discussing the death supervened while the case is pending. When we hit Rule 39, nakuha na niya yung judgment, talo siya, inatake sa puso, paano ngayon ang execution? We will discuss that sa Rule 39. Okay, now. Okay, what will happen? Okay. Okay, first case. Sir, what's your name? The one in blue? Sir, what is your name, sir? Roque? Okay. Roque, and what's your name, ma'am? Okay, yan. Bagay, R&R. Roque and Ron, husband and wife. Okay. Ron, kunwari lang to ha. It's all example lang ha. Okay. Wag example lang. Mas madali kasi mag-alive eh. Okay. Roque and Ron, husband and wife. And then Ron filed a petition for legal separation against Roque. Anong magandang ground? Ano ka na lang? Mamili ka, bigamy, sexual perversion. Both. Both na lang. Okay, yun yung ground, no? Now, Ron was able to present her evidence, okay, against you. Okay. But after she presented her evidence, the good Lord made her what? You know, anong tawag dito? The good Lord made her the assistant of the Virgin Mary. Okay? Okay. May tawag doon yung assistant ni Virgin Mary. I forgot. Okay, anyway. So, she passed on. The father of Ron filed a motion for substitution. Okay? If you were the judge, would you grant or deny the motion for substitution of parties? Why? Yeah, you're all right. No. Why? Well, it's personal, yes, because in the first place, this is a case for legal separation. And according to the Supreme Court in one case, you know, the case should be dismissed because to begin with, even if you have a decree of legal separation, remember what's the effect of legal separation? That you will be separated from bed and board. Kay siya separated 6 feet under the ground. Paano pa yung mai-implement, di ba? So it's really a personal case, no? So case dismissed. Now, will that be the same answer if, eto naman, okay? So nag-file. Then Ron, okay, filed, okay, she passed on. Okay, after the judgment for legal separation had already attained finality. Liquidation na ngayon. Doon nag-pass on siya. Handmaid of the Lord. She became the handmaid of the Lord. Okay? Nag-pass on. Now, so the father now filed a motion for substitution. And the husband now said, no, this is a purely personal case. Then the case should just be dismissed. Okay, the motion for substitution must be denied. Should it be denied? This time the answer is no, it should not be denied. It should be granted. Why? Because remember, in a petition for legal separation duly approved by the court, and remember the judgment is already final and executory. Technically speaking, the husband, okay, there will be a complete separation of property. The husband is no longer considered an heir, okay, and therefore who will be the heir? Kung wala silang anak, it will be the ascendant. So the ascendant now, okay, must be allowed to substitute because the substitute, okay, because in the first place, the case can no longer be dismissed because the judgment had already been rendered and the judgment had already attained finality. So you're just implementing the judgment. So those are the two different cases. Okay? So before I end, okay. So if somebody dies and there's a case, the first question you will ask, is this an action that survives death or not? If it's not, then case dismissed. It's purely personal. If your answer is this is an action that survives death, okay, what do? You file a note in both instances. You file in both instances, whether it survives or not, you file a notice of death. Okay, you have to inform the court. But if this is an action that survives death, you must also inform the court of the legal representatives or the executor or administrator of the estate of the deceased. And move for substitution of parties. There will now be an order of substitution of parties. Okay? Sila ang magsa-substitute dun sa namatay. Okay? And the case will proceed. Without that substitution of parties, the proceedings will be void and even the judgment. Why? Because there will be a violation of due process. However, in one case, despite the absence of an order to substitute, the heirs actively participated in the prosecution of the case. Sabi ng Supreme Court, the decision is valid. Why? Because there's no deprivation of due process because the heirs actively participated in the case. Clear. Now, so we go section 17. Okay, this is what we'll do. After rule 3, mabilis lang ako sa 4, mabilis lang ako sa 5. I will not discuss it because we've already discussed rules and summary procedure. Then we'll go with 6, 7, 8, it will be long. 9 will be short. Okay, 10 will be short. Then 11, I will just discuss it very briefly. Then the next long discussion will be summons. Okay, and then the next will be pre-trial. Modes of discovery, I will do that in less than 30 minutes. Highlights lang talaga. And then the next big discussion will be on Rule 39. Okay, because as I said, I cannot finish it all. Okay, how many of you took up civil procedure under the old rules when you took it in law school? Yung old rules pa, 1997. Okay, and then you took it, your review was old rules or new rules? Old rules pa rin, no? Na new rules na. Okay, okay. Okay, so let me proceed to just a minute. Okay. Section 17, the action may be continued and maintained by or against a successor in the public office if the following, okay, requisites are present. The public officer is a party to an action in his official capacity. Now, during the pendency of the action, he either dies, resigns, or ceases to hold office. Number 3, it is satisfactorily shown, okay, that to the court that within 30 days after the successor takes office, that there is a substantial need to continue and maintaining the action. 4, if the successor adopts or continues or threatens to adopt or continue the action of the predecessor. And finally, the party or officer affected has been given reasonable notice of the application, therefore, and accorded an opportunity to be heard. Okay. So in other words, when we talk about death or separation of a party who's a public officer, the action may be continued and maintained by or against a successor in the public office if all the requisites I mentioned are present. Okay, now. So when we speak therefore of death, always remember, okay, substitution of parties is applied only where the action survives death. If the action does not survive death, the case will have to be dismissed. Okay. In cases of incompetency or incapacity, okay, in cases of supervening incapacity or incompetency of a party, the action shall be prosecuted by or against him personally and not through his representative. Okay. For example, okay, Pedro, while the case is pending, okay, let's assume, for example, that the case involved is what you call this? It will involve, let's say, it's an action filed by a minor child. The title will still be in the minor's child's name. Why? Because he's the real party in interest. But because he does not have the capacity to act, he will have to be represented. Kaya magiging title yan, minor child X represented by his biological mother Y versus putative father. Okay? Now, and who are the incompetents referred to in section 18? Okay, the incompetents are those mentioned under section 2 of 92 of rule 92. They are the person suffering from the penalty of civil interdiction, hospitalized lepers, prodigal, deaf and dumb, who are unable to read and write. So if you are deaf, okay, and dumb, but you're able to read and write, technically you are not incompetent. Persons not having of sound mind but cannot without outside aid, okay, take care of themselves and manage their property because of age, disease, weak mind, or other similar causes. You know, in law school, by way of a joke, I always say incomplete yung listahan dyan ng Section 2, Rule 92. Ano ang hindi nasama? Students, law students while reciting, no? They are incompetent. But yun, joke lang yun. Okay, anyway. Pero minsan totoo. Okay, now. Okay, all of us were once incompetent, no, when we're reciting a case. Okay, incompetence, therefore, is not a cause of the dismissal of an action. Being an incompetent is not a ground to have the case dismissed. And the remedy is you just ask the court to appoint, okay, a person who can duly assist the incompetent. The incompetent party will be assisted by a legal guardian or a guardian ad litem. And when there is incompetence, okay, you don't need to file a separate case to get a person appointed. There is no need to file for another case for the appointment of a guardian ad litem. The court needs you to move that a guardian be appointed. Now, look at your Section 19. Transferi pendente lite. It's a transfer of interest while the case is pending. It occurs during the pendency. Now, is the transferee, okay, let's say purchaser of a land, pendente lite, no? Is he an indispensable person or a necessary party? Necessary party only. Why? Because the rule is very clear. May substitute. It's not even mandatory. So a transferee pendente lite is pendente lite, while the case is pending, is not an indispensable party, but is a necessary party to the case. So there are two kinds of substitution after discussing all these things under Rule 3. Death and transfer of interest. Now, if the action, okay, is when the intervening circumstance is death, always remember, ask yourself first, is this an action that survives death? Para alam nyo kung may substitution o wala. Pero in both instances, whether it's death, whether it is an action that survives death or not, you must inform the party. Okay? You must inform the court and the party, of course. And then transfer of interest. Okay. So with respect to death vis-a-vis transfer of interest, death substitution must be made because it is part of due process. Whereas transfer of interest, the word that is used is may. In the law, it reflects therefore discretion on whether a party may be substituted or not. In case of death, the court has no discretion to deny the substitution if the action survives death. Pero transfer of interest, the court is given a leeway to ascertain the propriety of substitution. Court may or may not allow substitution pendente lite. Death, the substitute, the executor, the administrator, or the legal heirs are indispensable parties to the case. Transferee pendente lite is not an indispensable party. He is a necessary party. And the death referred to in these provisions we discussed, death occurs either during the pendency of the action or after judgment has been rendered, not before the filing of the case. Because alam naman natin, no, Boston Equity yun. Transfer of interest, transfer occurs during the pendency of the action. So the transferee stands exactly in the shoes of the transferor or of the original party. The transferee is bound by the proceedings and the judgment in that case in such a way that they are no longer required to be impleaded. Clear? Okay. Section 20 is an action that survives death. This is action and contractual money claims. So what are the requisites for action and contractual money claims? The action is primarily for the recovery of money, debt, or interest thereon, and not where the subject is primarily for some other relief and the collection of sum of money is incidental. Second, the claim subject of the action arose from contract expressed or implied, which was entered into by the deceased during his lifetime, or the liability for which had been assumed by him or imputable to him. So, pagdating ng money claim, I sued debtor. Now, when I sued the debtor, he was very alive. When I presented my evidence, he was still very alive. And then when he was about to present his evidence, case dismissed. Ay, case dismissed. Case, ano pala, he died. Okay, namatay. Hindi case dismissed. Kasi kung case dismissed, paano na yan? No? Okay, mali ang kwento. He died. Okay, now, of course, the very first thing the lawyer of the, what you call this, of the deceased that will do is to inform, okay, the court na namatay yung kliyente niya. And then to also inform the court, ito yung mga legal heirs niya. Ito yung executor, ito yung administrator. Okay. And then the court now, after being notified of the legal or compulsory heirs or the executor or the administrator, will issue an order of substitution requiring these parties, these people, the legal heirs or the executor or the administrator, to what? To substitute the deceased. Okay. So nag-substitute. Okay. So pag nag-substitute na yan, the case will proceed. It's not dismissed. The case will proceed. It will go on. Okay. Kunwari natalo si defendant. Okay. Natalo yung defendant. The case will proceed up to that point in time when the decision attains finality. Okay? Hanggang naging final and executory siya. Okay? Hanggang dun. Once naging final and executory yan, you as plaintiff, winning party, as judgment creditor, cannot file a motion for the issuance of a writ of execution. You cannot. Okay? Why? Because you have now to what? File that claim with the proper intestate or testate proceedings. Yun ang pinaka-importante. Dire-diretso yan hanggang finality. But you cannot ask the court to issue a writ of execution. Is that clear? You file it as claim. Now, when you file it before the probate or intestate or testate court, you will not start from the very beginning as if you're going to prove your claim again. No, all you have to do, it has already been filed. It is already a claim that is recognized. Why? Because there's a final judgment. Hindi mo ka na kailangan i-prove yun. Is that clear? Now, okay. So if let's say, okay, question. Let's assume the judgment was made December 1. And the plaintiff received the judgment December 5. Now, the judgment became final and executory because there was no MR, there was no MR, no MNT or appeal that was filed. So, if there was no MR, MNT that was filed, after the lapse of all the periods, period of the defendant, period of the plaintiff, then the decision would now have attained finality. And as I mentioned before, when the decision has attained finality, that day is also the date of entry. Okay. Which means if it has already become final and executory, please don't ask again, as I said, for a motion for the issuance of a writ of execution. You filed the claim already with the proper intestate and testate court. Okay. Now, indigent. Okay. Pag tinawag niyo yung indigent party na pauper litigant, ibig sabihin nyo, nag-bar kayo siguro katulad ko mga 1988, no? Ang tawag pa namin noon, pauper litigant. Okay. Ngayon, hindi na indigent. Now, an indigent party, hindi naman kailangan maging para kang taong grasa. Hindi, okay? Hindi yun ang konsepto ng indigent under the law. An indigent party, okay, can file a case without the required docket fee. He is free from payment of all other lawful fees and stenographic notes. All of these shall be considered as a lien on any judgment rendered in a case favorable to the indigent unless the court provides otherwise. Now, so ibig sabihin, parang suspended lang yung pagbayad ng filing fee kasi magiging lien siya. So the amount of the docket fee and other lawful fees which the indigent was exempted from paying shall be considered a lien on any judgment rendered in a case that was rendered favorable to the indigent unless, as I said, the court provide otherwise. Now, when do you contest the grant of indigency? Well, the rule allows, okay, if you read the rules provide that you can now have an ex parte application and hearing to litigate as an indigent. At so, what you can do if you want to contest the grant of indigency, you can file a recon, okay? At any time before the judgment is rendered, any adverse party may contest the grant of the authority of a party to litigate as an indigent. Now, in the case of query of Roger Prioresci, okay, a juridical entity cannot be considered as an indigent, okay? A foundation cannot apply as an indigent party because only natural persons can apply for indigent, for being an indigent. Okay, now, if the applicant meets the two criteria for you to qualify as an indigent, then the court will declare you an indigent. And what is this criteria? The salary criterion and the property criterion. Okay. Now, that is the test of indigency, which means, okay, ano bang ibig sabihin? You and together with your family members should not be receiving, okay, the value, an amount equivalent to twice the value of the minimum wage, and your property, or you should own a property, the assessed value of which should not be more than 300,000 pesos. So that's the reason why earlier I said, ang indigent, hindi ibig sabihin dapat magmukhang taong grasa ka. No, because you can own a property, you can be working. Okay? But those will be the test. Okay? Now, okay. Notice the Soljan. Sorry ha, I have to make sure na madami ako matatapos. Let me just discuss venue, okay, in general terms. Okay. If there is a question on venue, the very first thing you do is read the document if it's based on a written document. Tignan nyo, first thing, meron bang restrictive venue stipulation? Okay. Kung may dapat ang venue, meron ng venue stipulation, but it has to be restrictive so that it will be mandatory. If it is not restrictive, then it's only permissive. What does that mean? Dapat ang nakalagay, kunwari, promissory note. Okay, plaintiff lives in Makati, defendant lives in Quezon City. Okay. But there is a venue stipulation that says case may be filed in Makati, but it was filed in Quezon City. Proper venue pa rin yan. Because it is permissive and because it's a personal action, the venue can be what? Chosen by the plaintiff depending upon the residence of the plaintiff or the defendant at the option of the plaintiff. Okay. So para maging mandatory yan, dapat may restrictive clauses. Shall be only exclusively, no other than but. Diba? Yung talagang siya lang. Okay. Now, kung walang venue stipulation, or kung may venue stipulation pero hindi restrictive, okay, then okay, simulan natin yung walang venue stipulation. The next thing you ask is this, okay, is this a real action or a personal action? Okay, if it is a real action, then the venue of the case should be filed in the place where any of the properties or a portion thereof is located. Okay? Now, if, for example, there are, let's say, real estate mortgage, the properties that were mortgaged and covered by the said one REM is all located in Quezon City, Makati, whatever, in Manila, etc. You filed it in Makati because one of the properties is in Makati, well, that will be to the exclusion of the rest because it's only covered by one real estate mortgage. Okay. Number two, if it is a personal action, okay, not a real action, remember our definition of real action kanina, di ba? Kung personal action siya, it is the place where the defendant or okay, to be more precise, where the principal plaintiff or the principal defendant resides at the election of the principal plaintiff. Which brings me now to the case of Araneta. No? In the case of Araneta, a case was filed before, this is the young Araneta, what's her name? Yung young sister, no? The youngest. She filed a case for recovery of shares of stocks, which she filed in Ilocos Norte. Okay. So the Benedicto group filed, at that time it was still allowed, a motion to dismiss on the ground of improper venue. Why? Because they claim that Araneta really does not live in Ilocos. In fact, she lives in Forbes Park. That is where their conjugal abode is. She lives with a husband. Okay. So anong ginawa ni Araneta? Because a motion to dismiss is not a responsive pleading, she amended her complaint as a matter of right. Okay. And she included 3 other persons. And based on the allegations of the complaint, these 3 persons, who are really all residents of Ilocos Norte, okay, are her trustees. Okay? Trustees daw niya yun. Pati yung trustees, kiniklaim yung mga shares. But they are her trustees. Now, is the complaint still dismissible on the ground of improper venue? Sabi ng Supreme Court, yes. Why? Because for purposes of venue, it should be the residence of the principal plaintiff or the principal defendant. So given that these 3 additional new plaintiffs are mere trustees, then the principal part plaintiff is Araneta, and therefore it was, kasi the defendants do not live in Ilocos. So, and Araneta does not live physically in Ilocos. So even if these 3 live in Ilocos, the problem is they are not the principal plaintiff. And so there was a case of improper venue. Clear? Huh? Okay, don't forget the phrase, what you call this? A principal plaintiff, okay? Now, just by way of recall, venue in civil cases may be waived as it is intended to accord convenience to the parties rather than to restrict their access to courts. Venue in criminal cases is not waivable because it is an essential element of jurisdiction. Therefore, venue in civil cases is procedural. Venue in criminal cases is jurisdictional. Okay. Now, okay, venue, if you want to raise venue, to have a case dismissed on the ground of improper venue, if it is covered by the rules of ordinary civil action, you can raise that in an answer by way of affirmative defense. Okay. If it is a case covered, okay, if it is a case covered by the rules on summary procedure, you raise it by way of affirmative defense in the answer. It's not a ground to have the case dismissed. But under the rules, under the expedited rules of summary procedure, please take note that the court on its own motu proprio can have the case dismissed on the ground of improper venue. Huh? But in ordinary civil action, the court cannot. There is no provision that would allow the court to dismiss the case motu proprio on the ground of improper venue if the case falls under ordinary rules or the rules on ordinary civil actions. So don't forget. Okay. Okay, let me go rule 6. Okay, kinds of pleadings. Okay, a motion to dismiss is not a pleading, right? It's an application to have a case dismissed, okay? Now, and it's not even a responsive pleading, okay? Okay, so what are the claims? Okay, pleadings allowed in this case in order under ordinary rules on civil action will be complaint, counterclaim, cross-claim, third-party complaint, etc., and the complaint in intervention. Okay, let's focus on an answer. An answer may be responded to by a reply only if the defending party attaches an actionable document to the answer. So you have a complaint, you have an answer, and the foundation of your defense in the answer is an actionable document. You want to deny the due execution and authenticity of the actionable document, file a reply. If a reply is founded on an actionable document and you want to deny the due execution and authenticity of that actionable document, which is the foundation of the reply, you can file a rejoinder. Now, What if you file an answer, okay, that is not based on an actionable document? Can you file a reply? The answer is no. But you want to controvert, it's deemed controverted. Ibig sabihin, yung talagang pinaglalabanan na, deemed controverted. But you still want to address the matters, the new allegations that were raised in the answer. Then the remedy is not to file a reply, but the remedy is to file an amended complaint or a supplemental complaint. But because an answer had already been filed, your amended complaint cannot be filed as a matter of right. You have to file a motion to admit the amended complaint, and you attach the amended complaint, your proposed amended complaint, to the motion. Well, a supplemental complaint will always be filed by way of motion. You get it, ha? Reply, pwede ka lang mag-file ng reply kung yung answer is based on an actionable document and you want to deny the due execution and authenticity of an actionable document. Now, the question is, okay, what makes a document actionable? Lahat ba ng ina-attach mo sa complaint mo or sa answer mo, actionable? Okay. Look at your Rule 8, Section 7. An actionable document is the document on which your claim or defense is based. So that's one. That's the foundation of your claim. That is the foundation of your defense. And a document becomes actionable if it sets forth in the pleading the pertinent provisions of such document. Okay, which means you copy the pertinent provisions in the pleading. And there's an end there. And the original or copy thereof shall be attached to the pleading as an exhibit, which shall form part of the pleading. So kinopya mo yung provision, hindi mo inattach, actionable document ba yan? Answer is no. Because you have to attach it, which means if you want to deny, if you fail to deny the due execution and authenticity thereof, you failed. It will not give rise to a technical objection. Correct? Kasi hindi siya, document nga siya based ng complaint, na based ng defense and claim. But you did not attach the document. Very clear from Rule 8, Section 7, to make a document actionable, you have to set forth in the pleading the pertinent provisions of the document, and the original or copy thereof shall be attached to the pleading as an exhibit, which shall form part of the pleading. Clear? Okay. Now, just give me a minute. Okay. Okay. Okay, let's focus on your complaint. The complaint is the pleading alleging the plaintiff's or claiming party's cause or causes of action. And the names and residence of the plaintiff and the defendant must be stated in the complaint. Why do you have to state the names and residences of the plaintiff or the defendant? Okay, especially for purposes of summons. Pag-serve ng summons, and of course for purposes of venue. Lalo, importante yan, lalo na kung personal action. Now, a complaint must make a direct statement of the ultimate facts. And when do you know, when can you say that a fact is an ultimate fact? It is when you cannot take it out, because if you take it out, you don't have a cause of action. Which means, okay, a collection suit, okay, on December 25, 2020, defendant borrowed money from the plaintiff. That's an ultimate fact. But if you say on December 20, 2022, for example, plaintiff wearing a white blouse, lent money to defendant wearing a black skirt. Tanggalin mo yung kulay ng mga damit at suot nila, you still have ultimate facts. Okay, so it means direct to the point. Okay, now. Okay. Answer. Okay. An answer is a pleading in which a defending party sets forth his or her defenses. Okay. Why did the law use the word, why does it use the word defending party? Because the plaintiff can be a defending party. And when can the plaintiff be a defending party? When the defendant raises a permissive counterclaim. Naku, very important yung permissive counterclaim na yan. We will discuss that later kasi iba yung consequences niya. So a plaintiff therefore, in fact, a plaintiff can be declared in default if the plaintiff fails to file an answer to a permissive counterclaim. Okay, now, what are your defenses? Yan, merong negative or affirmative defenses. So negative is a specific denial of the material fact or facts alleged in the pleading of the complaint, essential to his or her cause or causes of action. Okay. So, defendant specifically denies the allegations contained in paragraph 3 of the complaint, the truth of the matter being, you have to state the reason why. That's a specific denial. Or you have a disavowal on the basis of lack of information or belief sufficient to form as to the truth or validity thereof. Okay. Now, where was I? Okay, sorry. I saw, anyway. Example, defendant specifically denies the truth of the allegations contained in paragraph 3 of the complaint for lack of information sufficient to form a belief as to the truth or falsity thereof. In Tagalog, wa ako alam. Pero ginandahan natin ng English, di ba? Kasi kailangan abogado. In other words, sabi nila, ang ibig lang sabihin, wala akong alam. Okay? That's the second kind. Okay, and then of course you have partial and partial denial and partial admission. Okay, now, what do you mean by affirmative defenses? Affirmative defenses basically says, okay, is an allegation of a new matter which, while hypothetically admitting the material allegations in the pleading of the claimant, would nevertheless prevent or bar recovery from him. So what does that mean? Collection suit. Hypothetically, you admit you borrowed money, you did not pay, okay, you borrowed money, and then you did not pay the amount, okay? So technically, may cause of action eh. Pero, hindi makaka-recover si plaintiff kasi yung finailan ng court is what? Improper court. The court did not acquire, does not have jurisdiction over the subject matter. So kahit hypothetically inaamin ko yan, ang amount ng claim is 10 million, final mo sa small claims pa MTC, hindi ka talaga makaka-recover. So that is what is referred to as affirmative defense. So affirmative defenses may include grounds for the dismissal of the complaint, specifically that the court has no jurisdiction over the subject matter. There is a pending action, litispendentia, res judicata, or barred by prior judgment or prescription. Okay, now, as I mentioned earlier, and for the benefit of those who did not come in, okay, tignan mo yung motion to dismiss a lack of jurisdiction over the subject matter. So I filed a complaint, let's say for 5 million and I filed it with the MTC. Okay. Di ba talagang lack of jurisdiction over the subject? Oh, hindi. I filed it with the RTC na lang. Filed it with the RTC but the amount is 2 million or 1.9 million. Di ba the RTC really has no jurisdiction? So what are my choices as defendant? Okay, kung ako yung defendant. I will file a motion to dismiss. Okay. If the motion to dismiss is denied ng court, hindi, may jurisdiction ako. I can file a motion for reconsideration. Correct? Deny pa rin. I can file a Rule 65 petition. Because hindi bawal yan eh. Motion to dismiss yan eh. Okay. Compare that with the strategy. I can raise lack of jurisdiction over the subject matter as an affirmative defense. Correct? Oh, so I filed an answer. I raise it by way of affirmative defense, lack of jurisdiction over the subject matter. Denied. I cannot file a motion for recon. Look at your Rule 15. Any action on the court, any action of the court on the affirmative defenses cannot be subject to a motion for reconsideration. Rule 15, Section 12. Kung medyo nagpapakitang gilas ako, palagay ko letter C. Pero hindi ako sigurado. Basta dyan yan, okay? Meron yan, okay? Now, hindi ka makaka-MR. And also, correct? Is it letter C or D or G? Basta isang letra dyan, okay? Hindi ako makaka-MR. And by specific provision of Rule 8, Section 12, I cannot even file a certiorari case. All I have to do is proceed with the case, and my remedy is once there's a judgment, I appeal the judgment and I assign as one of the errors the wrong ruling on my affirmative defense. So please be very careful. Okay, please be very careful kasi baka mag-jumble-jumble yung mga provisions nyo. Clear, ha? Clear. Okay. Now, okay. So when you do your forms, okay, when you do your forms, sa complaint, number 1, di ba? The parties. Outline form lang, the parties. The facts, the ultimate facts. And the ultimate facts must show your cause of action, right of the plaintiff, the correlative obligation of the defendant to honor the right and the breach. And then after that will be, that's your ultimate facts, then your evidentiary facts, okay? Ilagay nyo doon lahat from the judicial affidavit, okay? The judicial affidavit, which will constitute your testimonial evidence, okay? And then of course, your documentary or object evidence, ilista nyo dun lahat. And in fact, under the rules now, you can state the law on which you base your cause of action. Okay, so yun. Tapos do not forget, 4 na taong ka nag-aral, nag-bar ka, kailangan merong pirma. Minsan nakakalimutan yung pirma. After the prayer, pirma. And then your MCLE, your IBP, what else? Your IBP, MCLE, at saka yung PTR, and then your email address. And because this is an initiatory pleading, certification on non-forum shopping. Pangalawa, kailangan bang verification? Depende. If the rules require it verified, then you file a verification too. Okay. Nag-answer ka. Outline form lang, answer. Pag-answer, admission, ano yung ina-admit mo? But please remember, when you admit, then that means it is already an established fact. No need to present evidence. Okay. Number 2, your denials, then your defenses, and then your counterclaims, and then your prayer. Now, if your counterclaim is compulsory, no need to execute a certificate of non-forum shopping. But if your counterclaim is permissive, please execute a certification on non-forum shopping. Otherwise, madidismissan kayo. Because certification on non-forum shopping, the absence or the defect cannot be cured by an amendment. Clear? Okay, now. Okay, so a denial, as I mentioned earlier, may be specific. Defendant specifically denies the allegations contained in paragraph 3, the truth of the matter being, and you have to state the reason why. If you just say defendant specifically denies the allegations contained in paragraph 3 of the complaint, period, that will tantamount to an admission. Okay? Kaya pag sa form yun, ganun lang kayo, naku, mali. Okay? Number 2, pwede yung defendant specifically denies the allegations contained in paragraph 3 of the complaint for lack of knowledge or information sufficient to form a belief as to the truth and falsity thereof. Then that you don't even have to state the reason why, simply because you don't know. Okay? And that's an effective denial. Okay. Now, meron bang then, of course, your affirmative defense. So I will go back, no? So sa answer, admission, denials, affirmative defense, if any, okay, affirmative defense, then your counterclaim, then the prayer, and then your signatures and the like. Okay. Now, when you say affirmative defense, walang special affirmative defense. I will deny you talaga to the, when you go to practice and then I see your name nakalagay special, affirmative and negative. Sa Siopaw lang may special, ha? Walang special. Talagang minsan iniisip ko, bakit nagkakaroon ng special? Ano ba yung ordinary na affirmative defense? Okay? So walang special. Okay, now. Tama, pansit lang yun. Okay, counterclaim. Okay, very important. What is a counterclaim? A counterclaim is any claim which a defending party may have against an opposing party. So, there are two kinds of counterclaim, permissive counterclaim and compulsory counterclaim. Nagtanong sa bar, is this a permissive counterclaim or a compulsory counterclaim? Eh, hindi ka nga Again, we go back to the test. Okay. To determine whether a counterclaim is permissive or compulsory, these are the questions that you will have to answer. The first question, are the issues of fact and law raised by the claim and by the counterclaim largely the same? The second, would res judicata bar a subsequent suit on defendant's claims absent the compulsory counterclaim rule? 3, will substantially the same evidence support or refute plaintiff's claim as well as the defendant's counterclaim? And the easiest of all the question is number 4. Is there a logical connection or relation between the claim and the compulsory counterclaim? Kung yung 4 na tanong na yan, ang sagot is yes, then the counterclaim is compulsory. Okay. Doon na lang sasabi kong pinakamadali, is there a logical connection between the claim and the counterclaim? I filed a case, okay, against this defendant. Defendant raised the issue by way of counterclaim. Because of this unfounded suit, I suffered sleepless nights, mental anguish, and so many pimples, okay? And therefore, okay, the plaintiff should be held liable, or don't put pimples sa exam, okay? Because of the unfounded suit, I suffered sleep in the amount of ganyan for which the plaintiff should pay again. Di ba may relasyon yung kanyang claim for moral damages dito sa suit na to? Kaya siya compulsory, yung ebidensya na yung ebidensyang i-represent niya is the very same evidence, di ba? Which this person will also adduce, okay, to negate the counterclaim. So kaya siya compulsory. May connection. There's a logical relationship between the two. There is a nexus. There's a logical connection. Anong example na permissive counterclaim? I sued B. I sued the debtor based on promissory note 1. Okay, based on promissory note 1. The debtor, in order to have my case dismissed, raised by way of defense that I owe him under promissory note 2. I sued him for 5 million and then the defendant now says, no, case should be dismissed because you owe me 10 million, which is based on a different promissory note. No relation whatsoever. The evidence to be presented by both of us on our complaint and the counterclaim, not the same. So it is permissive. Okay, now, bakit ba kailangang malaman kung ang counterclaim ay permissive, kung ang counterclaim ay compulsory? Number 1, okay. Pag compulsory counterclaim, as a rule, hindi ka nagbabayad ng fine. As a rule, talagang hindi ka nagbabayad ng filing fee. Because it's not considered an initiatory pleading. Okay. Pag permissive counterclaim, nagbabayad ka ng filing fee because it's an initiatory pleading. Number 2, pag compulsory counterclaim, you are not required to execute a certificate of non-forum shopping because it's not an initiatory pleading. Whereas if it is a permissive counterclaim, you are required to execute, okay, a certificate of non-forum shopping, okay, because it is considered an initiatory pleading. And the third, okay, pag compulsory counterclaim, you are not required to file an answer because it's deemed controverted. But if it's a permissive counterclaim, you better be sure that you file an answer, otherwise you can be declared in default. Okay? If it's an ordinary civil action, you can be declared in default if you fail to file an answer with respect to the permissive counterclaim. Clear? Okay, and of course, the fourth, I almost forgot. When a compulsory counterclaim is not raised in the answer, it is deemed barred. and it cannot be subject of another independent suit. Whereas if it's a permissive counterclaim, okay, because it's not mandatory, it can be subject of another complaint. It is actually based on a separate cause of action. Clear? Okay. Question. Okay. Okay. So there's this strip in the former, okay, before Fort Ilocanja. You know where Fort Ilocanja is, no? It's not in Honolulu, it is in Ilocos Sur, di ba? Okay, Fort Ilocanja. Bago nagkaroon ng Fort Ilocanja, meron yan na strip na ang pangalan The Stalls. Yung mga maliliit na stalls na may mga ganyan. So when Fort Ilocanja wanted to construct, they started talking to the owner of the stalls. To make the story short, okay, one of the stall owners allegedly, okay, so the stall owner sent his son. And then the son entered into a compromise agreement with the representative of Fort Ilocanja and said, okay, sige, we will leave and because you're going to leave and give the place up. Fort Ilocanja gave the person, by way of financial assistance, 400,000 pesos. Okay, 400,000 pesos. Turns out the father did not authorize the son, okay, to enter into a compromise agreement. So the father filed now a case. Okay, filed a case saying that, okay, he wants to rescind the compromise agreement. Okay. And then the judge decided. Ito lang. So, nag-file ng case for rescission. And then Fort Ilocanja said, no, there was authority to enter into the compromise. And in fact, we gave you 400,000. Okay. But based on the evidence presented, and then, okay, so nag-file ngayon ng counterclaim. Ang title lang counterclaim. Kasi minsan pagka yung in practice nilalagay counterclaim kasi hindi nga sigurado kung compulsory o hindi. Bahala si plaintiff, di ba? So nilagay lang counterclaim. Lumabas ngayon yung judgment. The counterclaim that was raised was, okay, sabi ng court, return. Okay, rescinded, no authority, return. Okay. Ang counterclaim pala ni-raise ni Fort Ilocanja, return, okay, return, and then given that this is, you know, you have no right whatsoever to occupy the premises, surrender the premises. Okay, vacate and surrender the premises. Now, after nag-trial, okay, pagkatapos mag-trial, sabi ng judge, rescinded, and then return, and then vacate. Sabi ng Supreme Court, okay, with respect to rescind and return the money, that is all right. The court has jurisdiction. But the court does not have jurisdiction to order the return and surrender of the premises because this was a permissive counterclaim. Walang kaugnayan yun doon sa rescission eh. It was a new matter that was raised by Fort Ilocanja, and worse, it did not pay filing fee. And therefore, the court does not have any jurisdiction to order the return of the premises. Kasi wala siyang kaugnayan dun sa rescission. Is that clear? Okay. Now, and that's a case of Bungkayaw. Okay. Now, okay. Okay, a compulsory counterclaim is one which, being cognizable by the regular courts of justice, arises out of or is connected with the transaction or occurrence constituting the subject matter of the opposing party's claim and does not require for the adjudication the presence of third parties whom the court cannot acquire jurisdiction. Now, such a counterclaim must be within the jurisdiction of the court, both as to the amount and to the nature thereof, except that in an original action before the RTC, the counterclaim may be considered compulsory regardless of the amount. And a compulsory counterclaim not raised in the same action is barred unless otherwise allowed by the court. Okay. If I filed, let's say, a counter before the RTC, case, no? For example, based on a vehicular accident, no? Okay, contract of carriage. And then the defendant raises by way of counterclaim, unfounded daw yung suit, so humihingi siya ng what? Attorney's fees. Clearly, this is a compulsory counterclaim because it arose out of the suit. Okay, now, What if RTC, I filed the case, the amount is, let's say, worth 7 million pesos, but the counterclaim being raised by the defendant is only what? 1 million pesos. Yun lang ang bayad sa abogado, 1 million. Wala siyang exemplary, wala, 1 million. Can the RTC rule on the counterclaim raised by the defendant? Yes, even if it's only 1 million pesos. Okay. Now, ang inferior courts, iba. Okay. I filed a complaint before the MTC, for example. 1.5 million collection suit. Okay. Nag-file ngayon yung defendant, okay, ng permissive counterclaim. Why? Because the amount is no, this complaint should be dismissed because you have a bigger credit. You owe me more. The defendant claims you owe me more, plaintiff, by 5 million. The plaintiff is not, the defendant is not authorized, okay, not authorized to claim the excess over and above the jurisdiction of the first level courts. The prayer should only be for the dismissal of the complaint. That is under the rules, no, of summary procedure. You should only ask for the dismissal of the complaint. You cannot insist that the excess be awarded to you because that would be already beyond the jurisdiction of the court. You insist, it will be tantamount to a waiver. You cannot file the case anymore, even for the difference. Is that clear? Okay. Now, cross-claim. Itong pinakagusto ko. Yung cross-claim, do you know that cross-claim? Siguro mga 2 years old, you know the concept of cross-claim. Do you know that? When you were 2, 3 years old, how? Di ba pag may kapatid kayo, di ba? Tapos pinagalitan kayo ng nanay niya, tapos may siya, hindi, siya, yun, no? Di ba? Yun ang cross-claim, no? Pareho kayong defendants in the eyes of your mom, and then sabi ng mama mo, okay, no, mom, siya may kasalanan. Yun ang cross-claim. Okay? So it's the defendants, no? Their point, it's a claim by one party against a co-party arising out of the transaction or occurrence that is the subject matter either of the original action or of a counterclaim therein. Okay, now counterclaims, reply. Okay, just by way of emphasis, all new matters, and this is section 10, all new matters alleged in the answer are deemed controverted. Pinag-aawayan na. If the plaintiff wishes to interpose any claims arising out of these new matters so alleged, such claims shall be set forth either in an amended or supplemental complaint, and both of which must be with leave of court. Kasi may answer na final, so hindi as a matter of right, di ba? However, the plaintiff may file a reply only if the defending party attaches an actionable document to his or her answer. And the only reason why you want to file a reply is because you want to deny the due execution and authenticity of that actionable document. Kung hindi mo naman dinideny, di wag ka na mag-file ng reply. Okay? Now, so a party may only file a reply if the action is based on an actionable document. So when a complaint and an answer are filed, the matters are deemed controverted. Hence, there is no need to file a reply. Okay? Okay, third-party complaint, etc. When the third-party complaint is filed, the third-party complaint must be necessarily connected with the original action. And you're filing a third-party complaint for this purpose. Okay, pag tinanong, is the third-party complaint proper? If you were the judge, we grant or deny the same. Then do not forget CISO. C-I-S-O. Okay. The third-party complaint is being filed because you want contribution. You want indemnification. It's a case of subrogation or any other relief with respect to the opposing party's claim. Other than that, hindi na pwedeng mag-file ng third-party complaint. Kundi lalawak ng lalawak, yung pinag-aawayan, wala nang kaugnayan sa original. Is that clear? Okay, and the filing of a third-party complaint must be always with leave of court. So you file a motion to admit the third-party complaint and you attach the proposed third-party complaint to the said motion. Okay, clear. Okay. Okay, Now, when you contribution, anong ibig sabihin ng contribution? Oh, contribution. Diba? Madali naman, hindi ko na, i-google nyo na lang yung contribution. Okay. Indemnification, you indemnify this person kasi lahat nakuha sa kanya. Okay. Or when you say with respect to opponent's claim, this ground, the third party complaint should have a relation to the original complaint. Okay. So according to the rules, a third party complaint will be denied if it introduces new and separate matters since it will only delay the proceeding. So yung third party complaint, again, must have some relation to the original complaint. Why? Because it cannot raise a new matter that has no relation whatsoever. Otherwise, it will just what? Delay the proceeding. And then, of course, subrogation. Okay, now, please take note that when a third-party defendant cannot be located, which means summons could not be served, the court may disallow the third-party complaint without prejudice to the third-party defendant filing a separate action. Okay. At this point, this is my personal opinion. You know, di ba, the third-party complaint, the motion to approve to allow third-party complaint would precede the service of summons. Correct? Would precede the... Nag-grant na eh. So kung nag-grant na yan, hindi ma-serve yung summons, baka pwede naman by publication. O assuming hindi ma-publish, babawiin ng court yung approval. Kasi na-approve na niya eh. But whatever it is, at the end of the day, the court, you can file, okay, a third-party complaint if your third-party complaint was denied because the third-party defendant could not be served with summons. The dismissal will be without prejudice. Okay. Other relief in respect of his or opponent's claim. So when you file the third-party complaint, the third-party complaint need not be based on the same theory as that in the main complaint. It can be a different theory altogether. Okay, now, any questions so far? Okay. Extraneous matters should not be introduced in a third-party complaint, which means it should really be focused on the original complaint. Otherwise, you know, you'll be introducing collateral matters which would only delay the proceedings. Okay. Okay, now we go to bringing new parties answer. Okay. You have to file an answer to the third-party complaint. Because if you don't file an answer, remember this is an initiatory pleading, which means it should contain the certification on non-forum shopping. If you don't file an answer, okay, then you can be declared in default. Okay. So parts and contents of a pleading, let me just focus on some. Okay, verification. Okay. Wait. Okay, caption, body, okay, signature and address. Okay, very important, section 3. Every pleading and other written submissions to the court must be signed by the party or counsel representing him or her. The signature of the lawyer constitutes a certificate by him that, number 1, he has read the contents of the document. Number 2, that to his best, okay, to the best of his knowledge or information and belief formed after an inquiry reasonable under the circumstances, it is not being presented for any improper purpose such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. When you affix your signature on the pleading, you are virtually confirming that the claims, defenses, and other legal contentions are warranted by existing law or jurisprudence, and it's non-frivolous, okay? And the factual contentions have evidentiary support, or if so specifically identified, will likely have evidentiary support after availment of the modes of discovery. So posible wala pa yung ebidensya mo pero sinasabi mo magkakaroon ng modes of discovery, magkaka-ebidensya ka. And the denials of factual contentions are warranted on the evidence or specifically so identified as are reasonable based on belief or lack of information. So clearly, okay, when you sign, your pleading, you're basically saying that you filed this for good cause and you have evidentiary value. Okay, that you have pieces of evidence to support your ultimate facts. Now, in case of violation, what will be the sanction? Okay. Non-monetary directive or sanction, an order to pay penalty in court, or if imposed on motion and warranted for effective deference, an order directing payment to the movant of part or all of reasonable attorney's fees. And the general rule is a law firm shall be jointly and severally liable for a violation committed by its partner, associate, or employee. Okay. Ang pumirma lang yung junior associate. Associate defined as aso na shit ka pa. Di ba? Kasi ikaw ang pinakadulo eh. Di ba? So pag nasa lawyer, ikaw ang pinakadulo, I always say, associate. Okay, anyway. So associate. Ang partner hindi pumirma. Hindi pumirma. Pero alam naman na ng associate na talagang wala talagang ebidensya. It was really filed, to harass, ganyan. The partner who did not sign cannot say, well, I did not sign it, therefore I'm not liable. The general rule is the entire law firm can be held liable. Okay, not just the person who affixes signature. So clearly, it is the duty of counsel to verify the truthfulness of the client's pleading and other written submissions. Otherwise, the counsel may even be held personally liable. Now, an unsigned pleading is deemed as a pleading that was not filed at all. Okay. An unsigned pleading, as a general rule, produces no legal effect. However, the court in its discretion, according to the case of Samir Overseas Placement Agency versus Santos, may allow the said deficiency to be remedied if it will appear that the same was due to a mere inadvertence. Okay. Now we go to verification and certificate against non-forum shopping. Okay. General rule, pleadings need not be verified under oath. Now, you only verify if the law requires that it be verified. But please take note, pag pinagawa kayo ng complaint for unlawful detainer, it must be verified because all pleadings submitted under the rules on summary procedure must be verified. Okay? Now, and how are pleadings verified? Please just memorize it. Okay? Verification. If it's verified by an affidavit or of an affiant duly authorized to sign the verification, and the affiant may either be the party pleader or the counsel. Okay. The authorization of the affiant to act on behalf of a party, whether in the form of a secretary's certificate, a special power of attorney, should be attached to the pleading and shall allege the following attestations. Number one, the allegations are true and correct based on his or personal knowledge or based on authentic documents. Number two, the pleading is not filed to harass, cause unnecessary delay, needlessly increase the cost of litigation. And number three, the factual contentions therein have evidentiary support, or if so specifically so identified, will likewise have evidentiary support after reasonable opportunity of discovery. Now, if the plaintiff, okay, that's who's supposed to file the case is Jollibee, okay, the verification will not be executed by the mascot. Huh? It is a person duly authorized, okay, by the board of directors who will be authorized to execute the verification. Now, paano kung hindi ka nakapag-verify? Okay, paano kung hindi ka nakapag-verify o mali yung verification mo? As to verification, non-compliance does not necessarily render the pleading fatally defective. The court may just order its submission or correct an act on the pleading if the attending circumstances are such that strict compliance with the rule may be dispensed with in order that the ends of justice may be served thereby. In fact, verification is deemed substantially complied with when one party has ample knowledge to swear to the truth of the allegations in the complaint or petition, signs the verification, and when the matters alleged in the petition have been made in good faith or are true and correct based on his personal knowledge. But that rule does not apply when we talk about certification against non-forum shopping. Okay, now, Section 5 yan, certification against forum shopping. Okay. Okay. When you speak of certification against forum shopping, yan talaga yan, required na required yan. Walang exception dyan. Now, okay. When you talk about forum shopping, what is forum shopping? It is an act of a party in which he repeatedly avails himself of several judicial remedies in different courts simultaneously or successively, all substantially founded on the same transaction and the same essential facts and circumstances, and all raising substantially the same issues either pending in or already resolved by another court. So what are the elements of forum shopping? Number one, identity of parties or at least such parties representing the same interest in both actions. Hindi kailangang identical, hindi pwede, hindi ano na si A versus B, susunod na kaso, si A versus B. No. It can be A versus B, natapos ang kaso, tapos namatay si A, tapos nag-institute na naman, same case, reconveyance, for example, property, this time, heirs of A versus B. Yan, substantial pa rin yan. Okay? Substantial interest, no? The second one, identity of rights asserted and reliefs paid for, the reliefs being founded on the same facts. And of course, third, the identity of the two preceding particulars such that any judgment rendered in the first action will, if successful, amount to res judicata. Now, who executes the certificate, okay, on forum, non-forum shopping? The indispensable party. The necessary party must execute, and based on our discussions earlier, the misjoined party need not execute. Naisama pero misjoined siya. Hindi siya naka-execute, okay lang. Kasi he's not a real party in interest. Okay, general rule. Who executes? The general rule, it must be executed by the party pleader, not the counsel. Okay, and the party pleader shall be the one who shall execute the certificate of non-forum shopping. Now, exception. If, however, for reasonable or justifiable reasons, the party pleader is unable to sign, then the party pleader must execute a special power of attorney designating his counsel of record to sign on his behalf. Okay? There must be an SPA. Now, the authorization of the affiant, which must be attached to the certification, must either be in the form of a secretary's certificate, a director's certificate, or a special power of attorney. And what are the undertakings of a party under the certification against forum shopping? I remember this was a question that was asked in the Leonan Bar. What are the certifications? Number one, that the party has not commenced any action or any claim involving the same issues in any court, tribunal, or quasi-judicial agency, and to the best of his or her knowledge, no such other action or claim is pending. Number two, if there is such other action pending or claim, a complete statement of the present status, and if he or she should thereafter learn that the same or similar action has been filed or pending, he or she shall report the fact within 5 calendar days to the court wherein his or her aforesaid complaint or initiatory pleading has been filed. Okay, now, General rule, if there are more than one, so that means two or more, all plaintiffs, all petitioners must execute the certification of non-forum shopping. And that's the case of Loquias versus Office of the Ombudsman. That's the general rule. Lahat ng plaintiffs mag-execute, lahat ng petitioners. Now, anong exception sa general rule? Okay? Under reasonable or justifiable circumstances, as when all the plaintiffs or petitioners share a common interest or invoke a common cause of action or defense, the signature of only one of them in the certification against forum shopping substantially complies with the rule. And that's the case of heirs of Dinglasan versus Ayala Corp. Okay. Example is the case of Docena versus La Pesura. The petitioners here are husband and wife. And the subject property is a conjugal property. Ang nag-execute lamang ng certificate of non-forum shopping yung asawang lalaki. Sabi ng court, not dismissible, it substantially complies with the rule. Why? Because under the law, one of the spouses is determined to constitute substantial compliance because they have the same interest on the said conjugal property. Clear? Okay. Now, why is it that all party litigants must sign as much as possible and not the lawyer? Because the party litigant is the one who is in the best position to know whether there are cases filed or not. Clear? Okay, let's talk about forum shopping in relation when the plaintiff is a juridical entity, pagkorporasyon. The certification against forum shopping is executed by a properly authorized person. It is required that a board resolution empowering such person to execute the certification as a secretary's certificate must be appended to the certificate of non-forum shopping. Dapat may authority. However, the following officials or employees can sign the verification and certification without need of a board reso. Chairperson of the board of directors. Number 2, the president of the corporation, the general manager or acting manager, the personnel officer, and an employment specialist in a labor case. Basis Cagayan Valley Drug Corporation versus CIR. And the justification for this is this corporate officers or representatives, the reason why they can sign the verification and certification of non-forum shopping even without the board, without the certificate, is because they are in a position to verify the truthfulness and correctness of the allegations in the petition. Okay. Now, when you do not comply with what will be the rules? What will be the rules on non-compliance on forum shopping? Number 1, it shall not be curable by mere amendment of the complaint or other initiatory pleading, but shall be the cause for the dismissal of the case without prejudice. In other words, nakalimutan mo talagang lagyan. Wala, nagmamadali ka. Ay nakalimutan. Cannot be cured by an amendment. It will be dismissed without prejudice. Okay. Now, when there are several petitioners, it is insufficient that only one of them executes, okay, the certification, absent a showing that he was authorized by the others. The certification requires personal knowledge and it cannot be presumed that the signatory knew that his co-petitioners had the same actions filed or pending. So a certification that was signed without proper authorization is defective and again a valid cause for the dismissal of the initiatory pleading. Fuentabella versus Castro. Okay. Now, what if, okay, okay yung certification, pero alam mo na yung nag-certify, hindi naman talaga humarap, okay, sa notary public kasi nakakulong siya. AKA De Lima versus Guerrero. Okay. In this particular case, okay, there was a petition that was filed. It was a petition that was filed by Senator De Lima. Now, the problem is di naka-notarize, di ba? Obviously, she did not appear before the notary public because she is behind bars. Okay, so what is the effect? In the case of De Lima versus Guerrero, Supreme Court said, without the presence of the notary upon the signing of the verification and certification against forum shopping, there is no assurance that the petitioner swore under oath that the allegations in the petitions have been made in good faith or are true and correct based on her personal knowledge and therefore not speculative. So the absence of a notary public when the petitioner allegedly affixed her signature, okay, negates proper attestation, okay, that forum shopping has been committed by the filing of the petition. Thus, the petition for all intents and purposes is an unsigned pleading that does not deserve the cognizance of the court. Okay, now, non-compliance with any undertaking or submission, okay, it shall constitute indirect contempt, okay? If you are going to submit a false certification, it will constitute an indirect contempt without prejudice to the corresponding and administrative and criminal actions. Okay, pag false certification. Now, if it is willful and deliberate forum shopping, the same shall also constitute a summary dismissal, okay, with prejudice of all the cases, including a petition, and you can be subject to direct contempt. Okay? Pag false indirect, pag willful and deliberate direct, okay, dismissal with prejudice of the case. Okay? Now, if the forum shopping is not considered willful and deliberate, the case shall be dismissed without prejudice on either the ground of res judicata or litis pendentia. Okay. Now, kailangan ang certificate of non-forum shopping? All initiatory pleadings, such as the complaint, your permissive counterclaim, do not forget. Okay, original special civil actions for certiorari, yan, required yan. Now, in the case of Metropolitan Bank versus Santos, the certification against forum shopping is required only in a complaint or other initiatory pleading. So therefore, an ex parte petition for the issuance of a writ of possession which is filed, okay, after a property has been extrajudicially foreclosed is not considered an initiatory pleading. It is in fact not an action. Why? Because an ex parte petition for the issuance of a writ of possession is considered as an incident and a consequence of the original either original registration of cadastral cases or a petition for the issuance of a writ of possession not being an initiatory pleading dispels the requirement of forum shopping, certification of non-forum shopping. Okay. Tell me if this is the counterclaim requires a certification of non-forum shopping. Okay. Husband and wife or father, mother filed the case against the hospital for the death of their child. Okay. On the ground na may malpractice daw na ginawa yung mga doctor dun sa hospital. Okay. And then the hospital, by way of answer, of course, denied it. Okay. And then raised that the spouses should pay the unpaid and settle the unpaid hospital bills that were incurred while their child was in the hospital. This counterclaim of requiring the parents to pay, okay, will this require the execution of certificate on against forum shopping? What's the answer? Siyempre, alam nyo, kaso yan eh. Nabasa ko digest niyan. Well, oops, the answer is, kasi hindi mo matandaan yung title. So I'm very sure digest naman. The answer is yes. Okay? Why? Because in the case, that is the case of Santo Tomas versus Surla, Santo Tomas University versus Surla. Sabi ng Supreme Court, okay, a claim for non-payment of hospital bills is a permissive counterclaim because it is something that is not connected with the alleged malpractice suit, diba? Such being the case, that is a permissive counterclaim, then the defendants must execute a certification of non-forum shopping because that is a permissive counterclaim. Clear? Okay. Okay. Now we go to Rule 8. Okay. Itong Rule 8 medyo mahaba-haba. Okay. I always take some time to discuss Rule 8 kasi mahaba lang talaga siya. Okay. So, rule, when you make your allegations in the pleading, it should always make a direct statement of ultimate facts, including evidence on which the party pleading relies for his or claim or defense. Now, if the cause of action or defense relied is based on law, then you quote the pertinent provisions. So there are two kinds of facts under the rules on pleading. Ultimate facts, and the ultimate facts refer to the essential facts of the claim. And a fact is essential if it cannot be stricken out without leaving the statement of the cause of action inadequate. So in other words, okay, the ultimate facts do not refer to the details of the probative value or the particulars of evidence or material elements that are supposed to be established. They are just the principal determinative constituted facts upon which the existence of which the entire cause of action rests. So pag sinabi mong ultimate facts, dapat ang ipakita niya right of the plaintiff, the correlative obligation of the defendant to honor plaintiff's right, and the breach. Yon ang ultimate facts. Now, how about evidentiary facts? These facts which are necessary for determination of the ultimate facts, they are the premises upon which, okay, conclusions of ultimate facts are based. Meaning, ano yung ebidensya mo? And it can be your testimonial evidence, it can be your documentary evidence, or it can be your object evidence. And both kinds of facts must now be alleged in every pleading. Okay. Ito is just by way of academic discussion only. If you do not state your ultimate facts, di ba? Di ba yung remedy mo dyan, if you're the defendant, you file an answer and raise that the complaint fails to assert a cause of action. But what is the remedy kung walang evidentiary facts? Walang nakalagay sa rules, di ba? Walang nakalagay sa rules. Kung ano ang effect ng wala kang, hindi naman siya cause of action, evidentiary fact siya. Okay. Me, this is my personal view. What is the remedy? I will make now, compel the plaintiff to disclose the evidentiary facts. And of course, the judge now will say, okay, comply, amend, and state your evidentiary facts. And if you fail to comply, then I will move for the dismissal of the complaint based on Rule 17, Section 3, because you're a disobedient party. Because wala siyang consequence. Walang nakalagay, di ba? So I think that's me, you know? That's me. Okay, now, a party may set two or more statements of a claim or defense alternatively or hypothetically, either in one cause of action or defense or in separate causes of action or defenses. Okay, so there can be alternative causes of action. So Rule 8, Section 2 recognizes, therefore, the liability of the defendant may possibly be based on two causes of action. One may be based on contract, or in the alternative, based on quasi-delict. Okay? Now, can there be inconsistency in the cause of action? The answer is yes. Because pleading alternative causes of action normally leads to inconsistent claims. But it is allowed. Okay? It is allowed. Okay? Now, how about alternative defenses? Section 2 of Rule 8, okay, authorizes not only alternative causes of action, the rule likewise permits alternative defenses. So the defendant may, okay, assert the defense, I paid already the debt. and at the same time plead alternatively, miskin di pa ako bayad, you cannot claim against me because your right to claim has already prescribed. So pwede yung ganon. Okay, now, let's talk about conditions precedent. Conditions precedent are matters which must be complied with before a cause of action arises. And when a complaint is subject to a condition precedent, the compliance of the same must be alleged in the pleading. And what are these conditions precedent that must be alleged in the pleading? Tender of payment is required before making consignation, or exhaustion of administrative remedies is required in certain cases before you can resort to judicial action, or prior barangay conciliation proceedings is necessary in certain cases if the plaintiff and the defendant live in the same city or municipality. Note, note, hindi kailangang same barangay. Okay. Has to be same city or municipality. But you don't resort, you don't resort to judicial, to barangay if your complaint is coupled with a prayer of provisional remedy. Diniscuss natin yan, no? Now, next, of course, is earnest efforts toward a compromise must be undertaken when the suit is between members of the same family, and if no efforts were in fact made, the same must be dismissed. Okay. When you say same members of the same family, so if there is a stranger, there is no need to comply with earnest efforts. So brother versus brother and sister-in-law is a stranger, no need to exert earnest efforts to arrive at a compromise settlement because of the presence of a sabit or a stranger, aka the sister-in-law. Okay? Now, arbitration may likewise be a condition precedent when the contract between the parties provides for arbitration first before resort to judicial remedies. Okay. Now, how do you allege this condition precedent? General averment. Anong ibig sabihin ng general averment? Hindi mo na kailangan on so and so date, the defendant, the plaintiff filed a complaint before the barangay on so and so date, barangay captain, ganyan, issued a letter invitation addressed to the defendant, requiring him to appear at the... No, all you have to say is this, okay? Before the case was filed, the matter was referred to the barangay, and despite efforts to settle the case amicably through the barangay conciliation procedure, the parties failed to arrive at a compromise settlement. Consequently, the barangay issued a certification to file action, a copy of which is here to attach as Annex A and made integral part thereof. General averment. Okay? Yun lang. Okay na yun. Now, failure to raise, failure to allege, that there was no, that there failure to allege what you call this that there was no really efforts to arrive at a compromise settlement, for example, or there was failure to comply with any condition precedent, you will have to raise that in an answer by way of affirmative defense. Okay, question. Okay, I filed a case, let's say, against my brother, kunwari lang. In my complaint, there was no allegation that we exerted efforts to arrive at a compromise settlement. Despite the fact that there were really efforts to arrive at a compromise settlement, but my lawyer did not allege it. Pero talaga sa totoong buhay, talaga nag-uusap kami, ilang beses kami ganyan, wala talaga. Okay, now, when the complaint was filed, my brother, filed an answer and said, affirmative defense, because there was no allegation whatsoever, there was no allegation that there was prior efforts to arrive at a compromise settlement. The case now, therefore, should be dismissed. Okay. Talagang meron. Okay, what is my remedy? In order to avoid the case being dismissed for failure to comply with the condition precedent. What is my remedy? Go to the UP chapel and pray. No? Yan. Kasi hindi kayo sumasagot eh. What is the remedy? Do you file an amended complaint? Motion to admit amended complaint kasi may answer na eh. Pwede mo siyang i-amend. Kasi talaga namang nangyari, ang bawal yung talagang hindi nangyari. Ngayon, kung nangyari dyan, nakalimutan lang, di mag-file ka ng motion to admit amended complaint. Clear? Okay. Now, capacity. Okay, ano ba yung capacity? Di ba, if you prepare your complaint, plaintiff Pedro Cruz is of legal age, married and a resident of whatever. Okay. Defendant Juan Santos is of legal age. Yan. Or plaintiff ABC Corporation is a corporation duly organized existing under the laws of the Republic of the Philippines. That refers to capacity. Okay? Kaya nga lahat ng sinusulat natin sa ating pleading, may rason yan, may rule yan. Okay. And capacity must be alleged. Facts showing the capacity of a person to sue or be sued, or the authority of a party to sue or be sued in a representative capacity, or the legal existence of an organized association or persons that is made a party must be averred. Okay, kailangan mo yang i-allege. And the party desiring to raise an issue as to the legal existence of any party or the capacity of any party to sue or be sued or in a representative capacity shall do so with specific denial, by specific denial, which shall include supporting particulars as are peculiarly within the pleader's knowledge. Example, Plaintiff Corporation. Plaintiff Corporation is a corporation, ABC Corporation is a corporation duly organized and existing under the laws of the Republic of the Philippines. Okay, that's in the complaint. Deny. I-deny. Sabi, paano i-deny? Specific denial. Defendant specifically denies the allegations contained in paragraph 2, kunwari, paragraph 2 of the complaint, the truth of the matter, that said corporation was not duly incorporated or existing under the laws of the Republic of the Philippines as evidenced by a negative certification issued, okay, by the Securities and Exchange Commission, period. Kasi you have to justify the denial by particulars. Clear? Okay. Now, okay, when you read the complaint, okay, you would know whether the person has capacity to sue or to be sued. Capacity of the complainant or the plaintiff and the defendant must be stated in the complaint. So capacity to sue or be sued when the person is of legal age. Now, if the plaintiff is a minor, then you have to say is represented by her parents or guardian ad litem. Okay? Or if he's an insane person, then must be represented by a guardian ad litem. So despite being incapacitated, whether by reason of minority or by insanity, the complaint must still be under their name because they are the real parties in interest. Now, domestic corporations, to have the required capacity, domestic corporations must be organized under the laws of the Republic of the Philippines. Okay, now, foreign corporations, just committed to memory, to have the required capacity to sue. Okay, you want the foreign corporation, give me an example of a foreign corporation. Apple Corporation. Yung ba pangalan? Apple Corporation? O, sige, tawagin natin Pineapple Corporation. Itay sigurado, okay? Pineapple Corporation, okay? You must allege either of the two, okay? Pineapple Corporation, a foreign corporation organized and existing under the state of Minnesota, USA, okay? And is registered and is licensed to do business in the Philippines, okay? Yan, that's one way. May capacity na siya to sue. The second one is if it does not have license to do business in the Philippines. Pineapple Corporation and foreign corporation organized under the laws of Minnesota and is suing under an isolated transaction. That is the only way a foreign corporation can sue. Either it has the license to do business in the Philippines, or if it does not, you have to allege that it is suing under an isolated transaction. Clear? Because if it's doing business in the Philippines, okay, but it is not licensed to do business in the Philippines, it cannot sue, it does not have the capacity to sue in the Philippines. But can it be sued? Well, of course it can be sued. Clear yan, ha? And so capacity must be alleged specifically. Clear? Okay. Now, in the case of Steelcase versus Design International, the Supreme Court ruled that when one appoints a representative or distributor domiciled in the Philippines, which transacts business in the representative's own name, it cannot be deemed as doing business in the Philippines. So kunwari, Apple International appointed me as the exclusive distributor, okay, of Apple products. That will not constitute as doing business in the Philippines. Okay, now, there is a whale of a difference between lack of capacity to sue and lack of personality to sue. And that's in the case of Columbia Pictures versus CA. When you say lack of legal capacity to sue, you're referring to the plaintiff's general disability to sue on account of minority and insanity. You're also referring to the fact that the plaintiff does not have the necessary qualifications. And so that the remedy by the defendant is you file an answer and raise lack of capacity to sue as an affirmative defense. Pagka lack of capacity to sue, kasi minor siya, tapos hindi siya represented, okay, nagdemanda siya. Ang remedy ng defendant, file an answer and raise by way of affirmative defense, lack of capacity to sue. Okay. Now, lack of personality to sue is different. Lack of personality to sue refers to the fact that the plaintiff is not a real party in interest. And therefore, the remedy, okay, is you file an answer and raise as an affirmative defense that the complaint fails to state a cause of action or does not assert a cause of action. So iba yung lack of personality to sue. Ibig sabihin niya, ang plaintiff is not a real party in interest. Example, agent of a disclosed principal. Ang nagdemanda si agent versus the buyer. The buyer, because this is a disclosed principal, okay, can file an answer and then raise by way of affirmative defense that the plaintiff there's lack of personality, okay, to sue because he is not, the agent rather, is not the real party in interest. Clear? Okay, now. Fraud, mistake, condition of the mind. Okay, when you talk about fraud or mistake, it must be alleged with particularity. Now, in case of ambiguity or failure to allege circumstances constituting fraud or mistake, the remedy is not a motion to dismiss. The remedy is you file what? Motion for bill of particulars. Because fraud must be alleged with specificity. Okay. Now, averments of malice, intent, knowledge, or other condition of the mind. Nababasa ba natin ang nasa sa loob ng utak? The answer is no. So you have to allege it generally. So what are the matters that must be alleged with particularity? Fraud, mistake, capacity. So Rules 8, Section 5, and Rule 8, Section 4. What are the matters that must be alleged generally? Conditions precedent, that's your Rule 8, Section 3. Malice, intent, knowledge, or other conditions of the mind, Rule 8, Section 5. And finally, Rule 8, Section 6, which is judgment of a domestic or foreign court, judicial or quasi-judicial tribunal, or of a board of officer provided an authenticated copy of the judgment or decision shall be attached to the pleading. Okay, clear. Now, speaking of domestic and foreign judgment, as I said, it can be alleged with generally, not specifically, sufficient to aver that the judgment or decision without setting forth the matter showing jurisdiction to render it. Why? Because it is assumed that the court has jurisdiction. And it is very important that you must attach an authenticated copy of the judgment or decision. If it's a foreign decision, then just attach an apostolized, apostilled copy of the decision. If the issuing court, the country of which is a member of the convention or Hague Convention on Apostolization, if not, then you do your regular consularized document. Okay, action based on an actionable document. Okay, I have already discussed it. Okay, but let me just discuss it in relation to section Rule 8, Section 7. Okay, so when you say actionable document, obviously it should be based on a written document. And that is the basis of your cause of action, excuse me. That should be the basis for the cause of action or the defense. Which means, example can be your promissory note, your deed of absolute sale, or your lease contract. And this document, okay, to be an actionable document, must not only be the basis of your claim or defense, the substance, the pertinent provisions of the said document must be set forth in the pleading, in the answer, or in the complaint. And to repeat, the original or a copy thereof shall be attached to the pleading as an exhibit. Okay. How do you contest an actionable document? By specifically denying the due execution and genuineness. You deny the genuineness and the due execution of the document under oath. And of course, you have to state forth the facts why you are denying the genuineness and due execution of the said document. Okay, now, if you fail to deny the due execution and authenticity of the said document, then it will give rise to a technical objection, a technical admission, okay? And sorry, nagkakalo-halo na si evidence, okay? It will give rise to a technical admission. That is, you are now admitting the due execution and authenticity of the said document, okay? And you have to deny it under oath. Okay, you have to deny it under oath. Now, the requirement of a specific denial under oath will not apply on the following instances. Number one, the adverse party does not appear to be a party to the instrument, okay? Or compliance with the order for an inspection of the original instrument was refused, okay? Now, so the complaint is based, let's say, on a promissory note. Dinidemanda ka, collection sum of money for 20 million pesos, and the basis of it is the promissory note. The pertinent provisions of the promissory note were copied and set forth in the complaint, and you attach a copy of the said promissory note to the complaint. So clearly, it is an actionable document. Problem is, you're saying, no, I do not owe you anything because the signature appearing on the said promissory note is not mine. It's a forgery. Okay. So clearly, you have to deny the due execution and authenticity of the said document. So your answer should say, okay, defendant specifically denies the allegations contained in paragraph 4, which refers to the actionable document. The truth of the matter being that the defendant could not have executed the said document because at the time of the alleged execution, the defendant was in the United States of America. And nakalagay doon place of execution is in Manila. Okay, sufficient na ba yan? Hindi pa. Kasi after matapos mo yung answer, dapat meron dyan a denial under oath. I blah blah of legal age, married, and resident of blah, blah, after being duly sworn to in accordance with law, depose and say as follows, I am the defendant in the case of ganyan-ganyan. I specifically deny under oath, okay, the due execution and authenticity of the said document, the truth being, then sabihin ko yung rason, I was in the United States of ganyan-ganyan, tapos subscribed and sworn to. So it's not just verification, huh? It is really a denial under oath. Okay, now, so if the answer does not comply with the requirements of specific denial, okay, question. Okay. I filed a complaint against, but who's our resident? What's our resident? What's your name again? My resident estafadora for the day. Okay. What's your name? Kim. Kim. I filed a case against Kim. Collection case, 20 million pesos, promissory note attached to the complaint, actionable document. She denied it. She said, anong tawag dito? That's a forgery. But she did not deny it under oath. What is the best remedy? If I were the lawyer for the plaintiff, what should I do? A, wait, okay. You filed an answer, no? A, proceed with the trial of the case. B, file a motion for judgment on the pleadings. C, file a motion for summary judgment. And D, copy the answer of my seatmate. What? Wala na akong maisip na D. Okay? So out of the three, what is the best option available? Para hindi kayo malito, ang judgment on the pleadings and summary judgment. This is how I usually explain it. Judgment on the pleadings, complaint, answer. Binasa mo yung dalawa, walang issue. Wala, inadmit niya lahat sa katutak ng negative pregnant. Wala talagang wala. Admit, tapos negative pregnant pala. Okay? Walang issue. Judgment on the pleadings. Summary judgment. Complaint. Answer. Uy, parang may issue. May issue, parang may issue, ostensible issue. But because of affidavits, depositions, and other documents, okay, that ostensible issue was unmasked to its very core. There is no issue at all pala. Kaya nga it's pure use, okay? Kaya motion for summary judgment. Kaya pag nag-issue, huwag mo sasabihin motion for judgment on the pleadings. Okay? Kasi may issue eh. At the very least, pwede ka mag-file ng motion for summary judgment para patunayan na yung issue pa lang yun ay katang-isip lamang. Pero hindi ganun ang sagot sa bar, ha? It is pure use. Yan. It appears to be, that's an ostensible issue but it appears to be spurious pala. Okay? Ganun lang yun. Minsan kasi nakakalito when you file it eh. Diba? Okay, now. Okay, I will discuss that later. Okay, so, a technical admission is the failure of a party to specifically deny the genuineness and due execution of the instrument, which will give rise to a technical admission that the said document is genuine and is duly executed. So if the answer does not comply with the requirements of specific denial, an answer fails to tender an issue. Okay. Now, what do you mean when you say it's genuine? When you say it's not genuine, then it means it is pure use, which is more difficult than not genuine. Diba? In other words, it's fake, okay? What do you mean when you say due execution? That the signature in the document was voluntarily executed, knowingly affixed, the signature was knowingly affixed, that the document is genuine, and that the party who executed it has the authority to sign it. So, if you admit the due execution and authenticity of the documents. You admit, inamin mo, may due execution, technical admission, no? So technically, inamin mo na ang dokumento ay genuine and duly executed. Well, what will be the defenses that will be cut off? Okay, the following will be the defenses that will be cut off. Okay, lack of authority to execute the document. party charged signed the document in some other capacity, that the document was never delivered, or the document was not in the words and figures set forth in the pleading. Hindi mo na yan mariraise kasi inamin mo eh. Okay? Inamin mo. Hindi mo pwedeng sabihin, forgery yan. Eh may technical admission na eh. Okay. Now, what are the defenses that are not cut off if you admit the due execution and authenticity of the document? Number one is, even if you admit the due execution and authenticity of the document, you are not barred from raising the defense, payment or non-payment. You are not barred from raising the defense, want of consideration. You are not barred from raising the defense that there is illegality of consideration, that there is fraud, there is duress, imbecility, mistake, compromise or estoppel. So these defenses, in other words, are not inconsistent with the admission of the genuineness and due execution of the instrument, and therefore not barred. Okay? Okay. Okay. Now, actionable documents are not only for purposes of being the foundation of a complaint. Actionable documents may be the foundation of a defense. Okay, now, remember this technical objection. Okay, so my complaint, my answer, hindi na deny under oath. Yung due execution and authenticity of the actionable document, which is the basis of the complaint, no? None. So technical admission, inamin na niya. Now the plaintiff, despite the technical admission, okay, introduced pa rin evidence to prove the due execution and authenticity of the document. In so doing, you're giving now the defendant the opportunity to cross-examine the person on due execution and authenticity of the document. Don't make it as an issue, in fact, in the pre-trial. Kunwari, example, the complaint answer, no denial under due execution. Pre-trial. Okay, sasabihin nyo, what are the issues in this case? Sabi ng plaintiff, plaintiff, whether the document was duly executed by the parties. Utang na loob, Diyos ko, ba't inamin na nga, ginawa mo pang issue. Waive technical admission. Okay, dapat yun, hindi mo gawing issue. Okay, another waiver of technical admission, hindi na naging issue. Now, the defendant, okay, for example, it's the defendant, so complaint answer, and then the answer has an actionable document. And then the defendant, it's no longer an issue, no? And the defendant started introducing, okay, evidence to prove, okay, the defendant, okay, so actionable document and defendant, cross-examination of plaintiff. Then the plaintiff started asking, is it not a fact, Mr. Mites, that the signature appearing on this deed of absolute sale is your signature? Yes. Is it not a fact that you were in the Philippines at the time you executed this deed of absolute sale? Yes. Eh, ang claim ng defendant, forgery. So, waiver ng technical admission because you allow. The defendant should have objected. Ano dapat objection? Objection, Your Honor, that is already deemed established because of a technical admission by failure of the plaintiff to raise in that reply, okay, to contest the due execution and authenticity of the said document, which is the foundation of the answer. Ba, very good, di ba? Pag pinakinggan mo, okay. Parang uno, di ba? Parang uno. Parang lang, no? Ibig sabihin, alam niya yung sinasabi niya. So in other words, if there is already a technical objection on your part, don't allow questions to be asked. Don't allow evidence to be introduced already on the technical objection because that will open you, okay, open you to questioning, you know, the technical objection is deemed waived. Is that clear? Okay, now, specific denial, absolute denial, I discussed that, partial denial. Okay, ano yung partial denial? Ang example niyan for example, okay? defendant specifically admits that part of the allegations in paragraph 3 insofar as the personal circumstances of the parties are concerned, but specifically denies, okay, the address of the defendant for want of knowledge sufficient to form a belief as to the truth or falsity thereof. In other words, may parte na dinideny ka, may parte na ina-admit ka. Ngayon, pag yan hindi mo inadmit, hindi mo deny, nalaktawan mo, 1, 2, 3, 4, nag-deny ka, 1, 2, 3, 4. Tapos yung paragraph 5, hindi mo siya na-deny, wala kang sinabi, nag-6 ka kaagad. Admitted yon. Okay, admitted yan. That is the rule. It is deemed admitted. Okay. What is a negative pregnant? Okay. Okay, form of a negative pregnant which carries with it an affirmation or at least an implication of some kind favorable to the adverse party. In other words, he admits more than what he denies. So a denial in the form of a negative pregnant is an ambiguous pleading, since it cannot be ascertained whether it is a fact or only a qualification that is intended to be denied. And so a negative pregnant impliedly carries with it an admission. Is that clear? Okay. So as I said, pag negative pregnant, admitted yan. Okay, admission ang kalalabasan yan. Now, there is this case, it's Capital Motors versus Yabut, no? It's a collection case based on a promissory note. And the defendant, denied, and the basis of the denial, pare-pareho, the defendant specifically denies all the allegations contained in paragraphs 3, 4, 5, 6, 7, 8, 9, 10, hanggang 10 lang yung allegation. The truth, for lack of information sufficient to form a belief as to the truth or falsity thereof. Sabi ng Supreme Court, you know, defendant, you ought to know whether you executed this promissory note. It is within your knowledge whether the signature appearing on this promissory note is your signature or not. This general disavowal, okay, if it's within the pleader's knowledge, will constitute an admission because it was not done under good faith. Kasi dapat alam mo kung promissory note, alam mo yung promissory note, signature mo ba yan, in-execute mo ba yan. Then all of a sudden, sasabihin mo, I cannot remember, I do not know. So that will not constitute an effective denial. And so the Supreme Court considered it to be an admission. Okay, let me start with, can somebody read first section 12? Can somebody read, it's kind of long. Can you read it please, section 12? Of Rule 8.
Section 12, affirmative defendants. The defendant should raise his or her affirmative defense in his or her answer, which shall be named in the list set forth under section 5, paragraph 3, Rule 6 of the following grounds. The court has done the distinction over the person of the defending party, that they is improperly given. But the defendant has no legal capacity to sue, but the pleading asserting that they gave no cause of action, and that the condition considered for private activity has not been provided. Being later to raise the affirmative defenses of the litigation shall constitute a waiver thereof. And C, a court shall not appropriately solve the above affirmative defenses within 30 days, calendar days from the filing of the answer. Letter D, as to the other affirmative defenses under the first paragraph of section 5B, Rule 6, the court may conduct a summary hearing within 50 calendar days from the filing of the answer. Such affirmative defenses shall be resolved by the court within 50 calendar days from the termination of the summary hearing. And lastly, affirmative defenses, if denied, shall not be the subject of a motion for reconsideration or petition for certiorari, prohibition of mandamus, but may be among the matters to be raised and appeal after a judgment of the merits.
Okay, now, remember that the old Rule 16 of the 1997 Rules of Court, okay, the entire Rule 16 was repealed. Therefore, because of the repeal, the defendant now must file an answer and raise as affirmative defenses the grounds mentioned in the former Rule 16. And these grounds are those stated in Rule 6, Section 5B. Okay, and what are those grounds under Rule 6, Section 5B? You have fraud, statute of limitations, the action is barred by statute of limitations, release, payment, illegality, statute of frauds, estoppel, former recovery, discharge in bankruptcy, and any other matter by way of confession. Clear. So let me refer to this group as Group 1. Group 1 would constitute the grounds mentioned under Rule 6, Section 5B. Okay. The second group is the one found, okay, under Rule 9. Rule 15, okay, which are actually also grounds for a motion to dismiss: lack of jurisdiction over the subject matter, litis pendentia, res judicata, and prescription of claims. So let me refer to that as Group 2. Okay. Then the third group will be the ones mentioned under Rule 8, Section 12. The court has no jurisdiction over the person of the defending party. Venue is improperly laid. Plaintiff has no legal capacity to sue. Pleading asserting the claim states no cause of action, and the condition precedent for the filing of the claim has not been complied with. Okay. So yung grounds ng Rule 16 dati, nahiwalay sila. Okay, first group, second group, third group. But all of them can be raised by way of affirmative defense in the answer. Okay, now, notice however, dyan sa tatlong grupo na yan, based on Rule 15, Section 12 of the 2019 rules, the filing of a motion to dismiss may be filed only on the four grounds: lack of jurisdiction over the subject matter, litis pendentia, res judicata, and prescription. Yan lang yung apat. The rest, you can only raise it by way of affirmative defense. You can raise this apat na sikat. I call them apat na sikat kasi apat lang sila. You can also raise it by way of affirmative defense, or you can raise it by a way of a motion to dismiss. Now, notice that the court's action will depend on the affirmative defense raised by the defendant. If the affirmative defense that was raised is a ground mentioned under Rule 8, Section 12, example, improper venue, lack of jurisdiction over the person of the defendant, the court shall on its own resolve the affirmative defense raised in the answer within 30 calendar days from the filing thereof. Ni hindi kailangan kang mag-oppose. On its own. Ni hindi ka kailangan as I said, mag-oppose o anong gawin mo. Wala. On its own, the court will resolve it. If the affirmative defense, okay, is any of the grounds raised under Rule 6, Section 5B1 of the 2019 rules, the court may conduct a summary hearing within 15 calendar days from the filing of the answer. The court shall resolve the affirmative defense raised in the answer within 30 calendar days from the termination of the summary hearing. So clearly, okay, unlike the affirmative defenses raised in Rule 8, Section 12, okay, lack of jurisdiction over the subject matter, over the person of the defending party, venue improperly laid, plaintiff has no legal capacity to sue, plaintiff asserting the claim states no cause of action, and a condition precedent, okay, for the final claim has not been complied with, okay. Unlike these grounds, the grounds that were mentioned under Rule 6, such as fraud, release, payment, illegality, statute of frauds, may be what? Subject to presentation of supporting evidence. Okay? Pwede. Except, of course, lack of jurisdiction over the subject matter. Notice that jurisdiction over the subject matter, you don't have to present evidence. Why? Because it is on the basis of the allegations of the complaint, okay, which comprise a concise statement of the ultimate facts constituting the plaintiff's cause of action. Now, since a motion to hear affirmative defense is a prohibited pleading, look at your Rule 15, Section 12B. Okay? If you look at Rule 15, Section 12B, bawal, okay, mag-file ng motion to hear affirmative defense. So, the plaintiff must submit his comment or opposition to the affirmative defense raised. Because the amended rules do not specify when the comment opposition may be filed. Dapat yan immediate. Now, also the court may set the summary hearing in accordance with Rule 8, Section 12B of the amended rules. Now, if the affirmative defense is denied, okay, denied, the order of denial shall not be subject to a motion for recon or a petition for certiorari, prohibition, or mandamus. The remedy is you go to trial, and in the event of an adverse judgment, appeal the same and raise the error of denial as one of the assigned errors. Okay. Next, ang sabi dyan, denial. Paano kung grinant? Paano kung i-grant yung affirmative defense? Pwede ka bang mag-file ng MR? Answer is no. Look at your Rule 15, Section 12C. The court action on the affirmative defense, you cannot file a motion for recon. Okay, hindi ka pwedeng mag-file ng motion for reconsideration. So whether it's denied or it's granted, you cannot file a motion for recon. Now, what is the remedy if it's granted? Okay, if it is granted. If it's granted, obviously that is a final order, right? It's not interlocutory. Wala nang gagawin. Na-dismiss na yung kaso. Clear. Na-dismiss na yung kaso. So that's a final order. Anong remedy? It depends. Look at your Rule 41, Section 1. Can you read it, please? Rule 41, Section 1. Okay. If it is a dismissal without prejudice, ni-raise mo as affirmative defense, venue improperly laid, granted, dismissed, you cannot appeal. Because it is a dismissal without prejudice. Correct? Okay. But look at the last paragraph. Oh, so what is the remedy? You refile in the proper venue. Pero kung talagang feel mo, tama naman yung venue mo, at the court acted in grave abuse of discretion amounting to lack or in excess of jurisdiction, the remedy will be the last paragraph of Rule 41, Section 1, and that is 65. But notice that this 65 petition, wala kang mapafile na MR. Kasi bawal ang MR sa Rule 15 eh. Diba? Section 12, bawal. Kaya pag affirmative defense granted, huwag ka muna mag-MR kasi bawal yan. Okay? I-Rule 65 mo na because it's what? Dismissal without prejudice. Because the law that did not allow you, does not allow you, wala kang choice. Kundi i-file mo kaagad yan. Because appeal is not the remedy. Clear? Parang, oh, siya. Okay. Do not worry. May mga moments talaga. Maraming ganyang moments. Kaya you just have to, wala kang masabi. Okay. Now, what if the dismissal, the affirmative defense that was raised is res judicata? What is the remedy? You filed an answer, raised the affirmative defense of res judicata, granted. What is the remedy? Mahirap na lang pahirapan, no? Well, basta yung ground. Okay, is this the question of law? Does it require facts? Okay, calibration of evidence? No. Eh di aakyat mo siya sa SC, di ba? Pero if it will require an evaluation of evidence, then the CA. Clear, ha? Clear. Now you understand why I had to say kanina mahaba-haba. Okay? Now, failure to raise. Okay. Now, in fact, ito gray area sa akin to kasi walang law na gano'n. What will happen, for example, do you filed an answer, do you have a counterclaim, di ba? And then your affirmative defense was granted. What will happen to your counterclaim? Di ba? Wala naman, nasa rules, di ba? This is my personal opinion. I will argue that the counterclaim will survive the dismissal. Lalo na kung permissive counterclaim yan, nagbayad pa ako ng filing fee. Bakit madidismiss yung permissive counterclaim ko? Okay? Now, it is a gray area because remember that under the old Rule 16, okay, the old Rule 16 says that the dismissal of the complaint on the ground of affirmative defense shall be without prejudice to the prosecution of the same or separate action of the counterclaim that was pleaded. That was already repealed. Repealed siya. The entire 16 was repealed, di ba? Di ba, ito lang yung rules of court at 15, ang sumunod 17. Parang elevator, walang 13. Di ba? From 12, naging 14. Wala. So, na-repeal yun. So, anong ibig sabihin? So, that's to my mind is a gray area. But again, as I said, I think it should survive. Okay, anyway. Now, any questions so far? You failed to raise an affirmative defense at the earliest opportunity. Okay, that will result to a waiver. Except lack of jurisdiction over the subject matter, because why it can even be raised first time on appeal. Okay, now, so yung Section 5, Rule 6, the court has the power to conduct a summary hearing. In other words, magpresentan, magtanong, clarificatory questions, magtanong anong ebidensya. Okay? But other than that, no hearing. Okay. Okay, the denial of your affirmative defense, you cannot file a motion for recon, a petition for certiorari, prohibition mandamus. And the order of denial is an interlocutory order. But an order granting your affirmative defense is a final order. Kasi wala nang gagawin yung court, dismissed eh. Okay? Now, ang remedy depende kung ano siya doon sa Section 1, Rule 41. Okay? Clear? Any questions? Okay, let me go now to, just give me a minute. I've discussed the cases, wait, Striking out, okay, I won't. Okay, by the way, you know, earlier I said if you fail to answer, deny, it's deemed admitted, except when it comes to unliquidated damages, no? They are deemed still controverted. Okay, effect of failure to plead, general rule, defenses and objections pleaded either in the motion to dismiss or in the answer are deemed waived if they are not pleaded, except the following: based on Rule 9, Section 1, lack of jurisdiction over the subject matter, litis pendentia, res judicata, and prescription. Now, failure to plead a compulsory counterclaim, barred. Okay, cannot be subject to a separate action. Now, when a pleader fails to set up a counterclaim or cross-claim, however, through oversight, inadvertence, or excusable neglect, and when the justice so requires, okay, he may, by leave of court, set up a counterclaim or cross-claim by amendment before the judgment. Okay, permissive, compulsory. Okay, declaration of default. Dalawa pwede mangyari dyan, di ba? Okay. This is ordinary civil action, okay? Ordinary civil action. Answer. Depending if it's actionable document, reply, rejoinder, pre-trial brief, pre-trial, trial. Simple case. Wala yung mga iba-iba pa. No? Now, and the answer will depend on how summons was served. It can be 30 days. It can be 60 days. Correct? Di ba? 60 by publication. Extraterritorial service, di ba? Correct?
Yes.
Yes. So 30-60. How about answer to a permissive counterclaim? Ilan? How many? Isn't it 20? Definitely not 30. How many? Permissive answer to permissive counterclaim. You should know that because pwede ka ma-declare in default. How many days? Permissive counterclaim. Nasa Rule 11 yan. Ha? Pag permissive counterclaim, ang period to file an answer is only 20. But answer in general, okay, pagka-complaint answer, depende sa service of summons. How summons was served. Kung sub-personal yan, substituted 30. Pero kung by publication, lalo na kung extraterritorial service of summons, 60 yan. Okay. Now, so yan ang pwede mangyari, di ba? Okay. To file a reply, 10 days. 10 days. Pre-trial brief, 3 days before the pre-trial, and then trial, file na. No answer. Okay. Okay, kung no answer yan, pero may proper service of summons, then the plaintiff will file a motion to declare defendant in default. Okay. And this is a litigious pleading. It's a litigious motion. And therefore, okay, if this is a litigious motion, okay, technically speaking, the plaintiff will have to file what? An opposition. But if he files an opposition, clearly he already voluntarily surrendered to the jurisdiction of the court, di ba? Okay. Anyway, so motion to declare defendant in default. Anong ipapakita mo dito? Proper service of summons. And then the deadline, the reglementary period to file answer. Okay. The receipt of the summons, the deadline to file an answer, and the lapse of the period, lapse of reglementary period, then no answer. Correct? Yan lang ipapakita mo dyan. Okay. And the court now will issue the first order. Order of default. Okay. Dineclare in default si defendant. Okay. Kung dineclare ang defendant in default, anong remedy ni defendant? Okay. Okay. This is judgment by default. Prior to judgment by default, the remedy of the defendant is motion to set aside order of default, correct? Plus, okay, fraud, accident, mistake, or excusable negligence. And your plus meritorious defenses, correct? And all must be done under oath. Correct? Okay. So pag tinanong, ano ang remedy, okay, if there is an order of default, please do not say MR. Do not say motion for new trial. Do not say that. It's a motion to set aside order of default wherein you raise fraud, accident, mistake, or excusable negligence. And then you must state your meritorious defenses and all must be done under oath. Clear? Okay. Ang natanggap ni defendant, hindi ito. Ang natanggap niya now, judgment by default. A judgment by default. Nung natanggap mo yung judgment by default, may judgment. Ano ngayon yung remedy? Okay? Within the period of appeal, so that's 15 days. Okay? And this is why 15 days? Because you have to do something, otherwise the judgment will become final and executory. So your remedy will be motion for new trial, appeal, or rule, okay, okay, or appeal. Okay. Kung nag-final and executory na to, wala kang ginawa, okay, may remedy ka pa? Yes. Rule 38, petition for relief from judgment. You can also argue, but not by jurisprudence, no? You file an independent action for under Rule 47. Okay? Pero yun ang kwento niya, di ba? So when you are asked what is the remedy, tignan niyo muna ano bang pinag-uusapan natin? Order by default, judgment by default, or yung judgment by default na naging final and executory na. Then doon niyo sasabihin kung ano yung remedy para you don't get confused. Okay. Now, what is the effect of the order of default? This first order of default. A party in default shall be entitled to notices subsequent to the proceedings. Makukuha niya yung formal offer of evidence, makukuha niya yun. Kasi kung yan ay written, but now oral no? Anything, the order of the court, makukuha niya yun. But he shall not take part in the trial. He cannot present his own evidence. Okay. What will be the relief from order of default? No, a party declared in default must make at any time after notice thereof, natanggap mo yung notice of the order of default, and before judgment, okay, file a motion under oath to set aside the order of default upon proper showing that his failure to file an answer was due to what? Fame, fraud, accident, mistake, or excusable negligence. And of course, he must have a meritorious defense. In such case, the order of default may be set aside on such terms and conditions as the judge may impose on the interest of justice. Which means kung nagkaroon ng presentation of evidence ex parte, kasi na-declare kayo in default okay, the evidence will stay. He will not start from the very beginning. The evidence will stay without prejudice now to the right of the defendant whose motion to set aside order of default was granted. He can now present evidence, cross-examine, recall the witness and cross-examine the witness. Okay, clear. Okay, now what is the effect of partial default? When a pleading asserting a claim states a common cause of action against several defending parties, some of whom answer and the others fail to do so, the court shall try the case upon all the answers thus filed and render judgment upon the evidence presented. What do I mean by that? One plaintiff, for example, plaintiff versus 3 defendants. Out of the 3 defendants, okay, they are sued on the same cause of action, Only one defendant filed an answer. There are 2 none. Okay, there are 2, two non-answering defendants. They cannot be declared in default because they are sued on the same cause of action. Otherwise, there will be prejudgment. Imagine, pare-pareho kayong cause of action, tapos yung isa hindi sumagot, dalawa sumagot, na-declare in default, tapos may judgment dito, pare-pareho kayo ng cause of action. Para may prejudgment. Kaya sabi ng rule, the answer of the answering defendant will technically inure to the benefit of the non-answering defendant. Hindi siya walang declaration of partial default. If you are sued on the same cause of action, kung dalawang defendants, ang cause of action laban dito sa defendant one is tort, the other one is contract of carriage, sumagot yung defendant na ang demanda ay basis contract of carriage, pwede din ma-declared in default yung defendant who's being sued on the basis of what? Tort. Kasi hindi sila parehong cause of action. Clear? Okay, now. Okay, where was I? Okay. Extent of relief to be awarded. A judgment rendered against a party in default shall neither exceed the amount or be different in kind from that paid for, nor award unliquidated damages. So when you're declared in default, okay, ang prayer ng plaintiff is for specific performance. Hindi pwede ang sabihin ng judge, what you call this, specific performance, hindi, gawin ito na lang natin, i-rescind na lang natin. Hindi pwede yon. Hindi na pwede mag-award yung judge ng unliquidated damages. Ano yung unliquidated damages? Moral damages cannot be. Okay, cannot be. Now, please take note, okay, where no defaults are allowed, petition for declaration of nullity of marriage, annulment of marriage, and legal separation, there can be no declaration of default. Okay, now. This is original special civil action. Huh? Notice under the revised rules on civil procedure, expedited rules. No? Okay. Complaint, proper service of summons. Period to file and answer 30 days. 30 days lamang. Okay. No answer. Okay. The court mutuo proprio or plaintiff may file a manifestation only. Manifestation meaning a manifestation that the defendant, okay, did not file an answer within the reglementary period. Then judgment can be rendered. Notice you don't file a motion to declare defendant in default under the rules of summary procedure. You don't. Bawal yun. Huh? So, mangyayari, pag no answer yan, the court on its own can render judgment based on the complaint. Okay? Or the plaintiff can file a manifestation, a simple manifestation, informing the court proper summons was served with this date, period of time to file, ito yung to file an answer, ito, and no answer was filed. So, iba na yung rules under expedited rules. Doon sa mga nag-aral na under the old rules, di ba, ang old rule noon, under the summary procedure, the plaintiff must file, okay, mutuo proprio or can file, actually, can file a motion to render judgment based on the complaint. That was the old rule. Now you just file a manifestation, just a manifestation. Wala na yung motion to render judgment. Okay? So, what are the requisites before a declaration of default can be had? First, the court must have validly acquired jurisdiction over the person of the defending party, either by service of summons or by voluntary appearance. Okay, number two, the defending party must have failed to file his answer within the time allowed therefore. Three, the claiming party must file a motion to declare defendant party in default. Or the claiming party must prove that the defending party has failed to file an answer within the period provided, okay? And of course, the motion, though there is no more notice of hearing, you should always furnish a copy of the motion to the other party. Okay. And what is the effect of order of default? The party declared in default loses his standing in the court, and this prevents him from taking part in the trial. While the defendant can no longer take part in the trial, he is still entitled to notices of subsequent proceedings. He may not participate as a party litigant, but he may be called as a witness. Okay. Now, the court may proceed to render judgment granting the claimant such relief as his pleading may warrant, or require the claimant to submit evidence such as reception of evidence, and may be delegated to the clerk of court. Okay. So declaration of default, miski ka naman dineclared in default, is not tantamount to an admission of the truth or the validity of the plaintiff's claims. It is not a waiver of rights except that of being heard and presenting evidence in defendant's favor. Now, despite the fact that the defendant has been declared in default, his right, okay, to appeal the judgment by default is still there. Okay. Now, of course, when it's appealed, the grounds may be raised in the appeal are very limited. Failure of the plaintiff to prove the material allegations in the complaint, that's one. Or the decision is contrary to law, or that the judgment is excessive or different in kind or from that what was prayed for. Why is it very limited? Kasi ebidensya lang ng plaintiff ang pumasok. Is that clear? Okay, now. Okay. So if the judgment has already been rendered, okay, and this you have judgment by default already, but before the same has become final and executory, the defendant now may file motion for new trial or can file an appeal. If the judgment has already attained finality, meaning may entry of judgment yan, the judgment is final and executory, as long as it's within the period, you can file a petition for relief from relief of judgment. Okay? Kung mapapansin niyo, it's also fame. Now, the fraud here is extrinsic fraud, not intrinsic fraud. Okay? Okay. In the case of Otero versus Tan, okay, this is the case where the Supreme Court enumerated the reliefs that may be availed of by a defendant declared in default. These are: a party declared in default may at any time after notice, okay, of the order declaring him in default, but before judgment, file a motion under oath to set aside the order of default upon the proper showing that his failure to answer was due to fraud, accident, mistake, or excusable negligence, and he has meritorious defense. Okay. And what do you mean by meritorious defense? It means that the motion must be accompanied by a statement of the evidence which he intends to present if the motion is granted, and which is such as to warrant a reasonable belief that the result of the case would probably be otherwise if a new trial is granted. Okay, now, in such case, the order of default may be set aside upon such terms and conditions as the judge may impose. Now, the second phase, judgment by default na, may judgment na. If the judgment has already been rendered when the defendant discovered the default, but before the judgment has become final and executory, what are his remedies? Motion for new trial under Section 1A of Rule 37, or an appeal from the judgment as being contrary to evidence or law. Now, if the defendant discovered the default after the judgment has already attained finality, final and executory, he may file a petition for relief under Rule 38. And these remedies I mentioned, okay, presuppose that the defending party was properly declared in default. Tama yung service of summons. Ha? Okay. Kasi, pag improper service of summons, dineclare siyang in default. Okay. Under the case of Indiana Aerospace versus Ched. Okay. The remedy is certiorari under Rule 65. Okay. Okay, now, there are other cases where declaration, when a defendant cannot be declared in default, okay, aside from petitions for annulment, declaration of nullity of marriage or legal separation. Cases involving intra-corporate controversy, bawal lang magka-motion to declare defendant in default. Rules covered by the rules on the expedited rules on summary procedure, and of course your small claims, bawal ang motion to declare defendant in default. Okay. Any questions so far? Okay. Let me just, okay. Okay. The case of Gahudo versus Traders Royal Bank, no? The mere fact that the defendant is declared in default does not automatically result in the grant of the prayers of the plaintiff. To be able to win, the plaintiff must still present the same quantum of evidence that would be required if the defendant were still present. Hindi bumababa yung quantum of evidence, no? It is still what? Preponderance of evidence. A party, okay, that defaults is not deprived of his rights except the right to be heard and to present evidence to the trial court. If the evidence presented by the plaintiff does not support a judgment, then the complaint should be dismissed. Even if the defendant may not have been heard or allowed to present any countervailing evidence, parang nakakaya, no? Na default na yung defendant, talo ka pa rin. So may problema sa ebidensya mo, di ba? Anyway, you know, I always say, lalo na pag na-declare in default, lalo mong gagalingan kasi mas nakakahiya yun, di ba? Wala ka nang kalaban, tapos natalo ka pa. Para ka sa basketball. Na-default na siya, hindi pa na-shoot. God. Okay, anyway. Okay, what else? Sorry, I'm skipping some cases kasi because they're too long. Okay. Okay, so these remedies, they are the remedies when the defendant is properly declared in default. Okay. Amendments. Okay. How do you amend? By adding or striking out an allegation, by correcting a mistake, or inadequate allegation and description. No. Amendments are allowed precisely so that the actual merits of the controversy may be speedily be determined without regard to technicalities and in the most expeditious and expensive manner. Okay. Now, amendments can be a matter of right, can be by way of motion. A party may amend his pleading once, only once as a matter of right, at any time before a responded pleading is served, or in the case of a reply at any time within 10 calendar days after it is served. And this section, and this is section 2, okay, refers, okay, to an amendment made before the trial court, not amendments before the CA. The CA is vested with discretion to admit or deny amended petitions before it. Please take note that a motion to dismiss is not a responsive pleading. And why is it not a responsive pleading? Because you're not responding to the allegations of the complaint. You hypothetically admit the allegations of the complaint, and on the basis thereof, you want the case dismissed on the ground of lack of jurisdiction over the subject matter, res judicata, litis pendentia, or prescription. Therefore, because a motion to dismiss is not a responsive pleading, once a motion to dismiss is filed, okay, you can file an amended complaint as a matter of right, because a motion to dismiss is not a responsive pleading. But please take note that that is only the general rule. May exception dyan. Okay, and I will discuss the exception. Now, what is the remedy? Okay. What is the remedy if the court refuses to admit an amended pleading when the amended answer was filed as a matter of right? Complaint, nag-file ng amended answer, labas ng court. Okay? Labas, ito lang, complaint, complaint, amended complaint, naglabas ng court ng first order. Sabi niya, no, the amended complaint should not be given due recognition by this court, okay, because no motion was filed. Okay, what's the remedy of the plaintiff? Complaint, amended complaint, then sumunod order of the court saying that the amended complaint should not be admitted because it should have been filed, you know, with a motion. Remedy. Yan yung mga gusto kong tanong yung hindi pa natin na pag-aaralan. What is the remedy? Alam niyo yan, you know this. What's the remedy? Guess lang, guess. Sir, ang ganda ng titig mo sa akin. Ano ang sagot? She was looking at me. Anong sagot? Guess lang, guess lang. Any guess? Wild guess. To determine if, okay, in the first place, okay, if the court refuses to admit an amended pleading when it is exercised as a matter of right, then it is correctable by mandamus because the trial court's duty is to admit an amended complaint made as a matter of right, and therefore it's purely ministerial. Okay. Now, can the amended complaint introduce a different cause of action? The answer is yes. Diba? The test is whether, when you say different cause of action, the test is whether such amendment now requires a defendant to answer for a different liability or obligation, which is completely different from that what was stated in the original complaint. Okay. And what is the effect of filing an amendment? The original complaint is deemed abandoned, superseded by the amended complaint only if the amended complaint introduces a new or different cause of action or demand. Okay, now, yung amended, dinavacate siya, complaint, original complaint, amended complaint. The original complaint now will no longer be deemed as forming part of the records of the case because deemed vacated na siya. Okay, but can you still use it? Can you still use the original complaint? You can use it as evidence. Okay. If you have to use it as evidence, how can you bring it back to the records to make it forming part of the records of the case? Huh? Do you just submit it? No. You will have to introduce it as evidence. Okay. Notice, therefore, this is the case of Torres versus CA. The amended complaint takes the place of the original. The original complaint is deemed abandoned, ceases to perform any other function as a pleading. In other words, the original complaint is no longer, okay, part of the record. Now, if the plaintiff, for example, desires to utilize the original complaint, the plaintiff or the defendant, as the case may be, should offer it in evidence. Okay, having been amended, the original complaint lost its character as a judicial admission, which would have required no proof and became merely an extrajudicial admission, the admissibility of which as evidence requires a formal offer of evidence. Kailangan mong i-reintroduce. Okay, so if you say that the original complaint, the original complaint no longer forms part of the records, the courts therefore cannot rely on the original complaint when it is not offered in evidence, as the original document or complaint no longer form part of the records of the case. Okay, amendment by leave of court. Okay, when is leave of court required? Okay, for an amendment made after service of a responsive pleading, or if the amendment is substantial. Okay, but please take note, such leave shall be refused. Okay, if it appears that the motion was made with intent to delay or to confer jurisdiction on the court, or the pleading stated no cause of action from the beginning which could be amended. Okay. So complaint, nag-file ng answer. Ang nilagay sa answer, okay, is an affirmative defense that the complaint fails to assert a cause of action. Nag-file ngayon ng motion to admit amended complaint, and the purpose is to amend and to show that there is a cause of action. It will be denied. Now, kung sabihin to complaint, nag-file ngayon ng answer, ni-raise niya by way of motion to this, nag-raise ng answer, there's no jurisdiction daw over the subject matter, you cannot amend it. Okay? Bawal daw yon. Okay. So even if the amendment be with leave of court, it still stands to be eventually rejected where such amendment appears to have been made with the intent to delay the proceedings. Now, can you substantially alter the cause of action? The answer is yes. Okay. Now, formal amendments, okay, anytime it can be done by the court, no? Amendment necessary to conform to our evidence presented. Okay. Notice that the court acquires jurisdiction over the issues even if the same are not alleged in the original pleadings. Okay. So even if the issues, okay, was not generated by the pleadings, the trial of the said issue, if done with the express consent of the parties, the court will be able to acquire jurisdiction over the issue. Correct? Okay, anong ibig sabihin natin? Kunwari, rescission. Okay? Siyempre, ang issue dyan, whether the contract can be rescinded, di ba? Tapos, ang dapat sumunod na issue na dyan, if it's so rescinded, whether the defendant must be required to return the money. Okay? Eh, nakalimutan. Hindi nakalagay sa pre-trial brief, hindi nakalagay sa answer, hindi nakalagay sa pre-trial brief. Hindi, wala ring issue on the attorney's fees. Wala. Okay? And then, nag-judicial affidavit ngayon yung plaintiff. Ang nakalimot si plaintiff. Sa plaintiff's complaint, okay, ang nakalagay langan doon is rescission. He did not ask for the return of the money that was paid. He did not ask for moral damages. He did not ask exemplary damages. He did not even ask attorney's fees. So answer, okay. Pagdating sa pre-trial, nag-pre-trial brief, nag-pre-trial, hindi rin nakalagay. Okay, the issue, yung return of money and payment of damages. Nada, nothing. Okay. Nag-present kayo si plaintiff. Okay. Judicial affidavit. Di ba sa judicial affidavit, dapat nakalagay na the purpose of the testimony is to prove the following. One, the factual basis for the decision of the contract, that's nakalagay. And to prove, okay, the entitlement of plaintiff for on moral damages, exemplary damages, and attorney's fees. Tapos may mga tanong, may sagot din. Tinawag ngayon, nag-presentation na. So plaintiff now calls the witness to the witness stand. The first thing the plaintiff's counsel will say, the testimony of the witness is being offered to prove the following. Blah, 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 and to prove the factual basis for the payment of attorney's fees, moral damages, exemplary damages. Sabi ng court, doon sa kabila. Comment, subject to cross, Your Honor. Ilan sinabi niya? Subject to cross. So pumasok ngayon yung ebidensya. Okay? Pumasok yung ebidensya. So, pumasok yung ebidensya, and then nag-present pa siya ng counter, okay, evidence to disprove his entitlement. Can the court render judgment on the issue of damages? The answer is yes. Why? Because the parties, by express action, in other words, okay, waived that part na hindi naman siya issue. Okay. And because of that, if the trial, okay, if you allow the trial of the issue with the express consent of the parties, then the evidence can be appreciated by the court, and the court can rule on the evidence presented. Do you need to file a motion to conform with the evidence presented? No, you don't need. You want to? Fine. Okay, because the evidence was already presented. So you can amend to conform with the evidence presented. You can file a motion to admit amended complaint on the basis of the evidence presented. Pwede yun. You don't file that motion, it's all right. It's all right because the evidence already is forming part of the records of the case. Clear? Okay, now. This rule is premised, therefore, on the fact that evidence had been introduced on an issue not raised by the pleadings without any objection by the adverse party. Kaya pag nag-trial na kayo, magkikita tayo sa korte, di ba? Litigation lawyer kayo. Okay. Siyempre ang answer, yes ma'am, I will be a litigation lawyer. Am I right?
Yes.
Yes. It's very yes. Yes, okay. Dapat lagi kayong gising. Di ba? Pag sinabi ng court, comment, basta intindihin nyo mabuti yung purpose. Kasi pag hindi kayo nag-object, di wait. Pasok lahat yan. Okay? Clear. Okay. Imagine, it's not a triable issue because it's not an issue stated in the pre-trial order, and yet you introduce evidence on a non-triable issue, deemed waive. Okay. Now, supplemental pleadings. Kung amended pleadings, okay, refer to facts existing at the time of the commencement of the action. Supplemental pleadings refer to facts arising after the filing of the original pleading. Amended pleadings results in the withdrawal of the original pleading. Supplemental pleadings does not result in the withdrawal of the original pleading. Okay? Amended pleadings can be filed as a matter of right, can be filed as what? By way of motion. Pero ang supplemental pleadings yan always by way of motion. It's always with leave of court. Now, question. I filed a complaint. Okay. I filed, then the defendant filed an answer. Then I filed a motion to admit supplemental complaint. Granted. The defendant did not file an answer to the supplemental complaint. Can I now file as a plaintiff, file a motion to declare the defendant in default for not having filed an answer to the supplemental complaint? The answer is no, because an answer had been filed. But what is the net effect of not filing an answer to the supplemental complaint? Simple, deemed admitted lahat ng nakasabi doon sa supplemental complaint. Clear. Now, supplemental complaint, technically speaking, should only supply deficiencies in aid of the original complaint. It should contain only causes of action relevant and material to the plaintiff's right and which helps the plaintiff's right or defense. It cannot be used, okay, to try new causes of action. But that is the old rule, okay, Librera. There is a new rule, okay, which says as long as the new cause of action has a connection with the old cause of action, pwede yan by way of supplemental complaint. Clear? Okay. Okay, let me just, okay. So, in the case of Ada versus Ilon, okay, a supplemental complaint may raise a new cause of action as long as it has a relation to the original cause of action set forth in the original complaint. Okay. Now, let's do Rule 11, responsive pleadings. Okay, fill in the blanks para naman magising kayo. Okay. What is the period of time to file an answer? If the service of summons was done through personal service or substituted service? 30 calendar days. Don't forget calendar days, ha? Kasi yun nakalagay. Unless a different time is okay. Now, period of time to file an answer to a third-party complaint. Third-party complaint, ha? This is served na summons yun. The motion to admit third-party complaint. Granted, summons will be issued against a third-party defendant. Tinanggap personally. Period to file, 30 days from receipt, no? 30 calendar days. Okay. Now, how about a complaint? Okay, the service of summons and the complaint was received by the resident agent. Okay, resident agent of a foreign corporation. How many days? 30 days, diba? 30 days. May resident agent of foreign corporation registered in the Philippines 30 days. Now, how about an answer of a defendant foreign juridical entity and the service of summons was made on the government designated by law to receive the same? 60 months, 60 ano? 60 calendar days, please do na. Kaya kung sinasabi, lalagay niya yun sa sagot, 60 calendar days. Okay, How about answer to an amended complaint? How many days? Think. Ulit. Answer to an amended complaint. If the answer, okay, if the amended complaint was filed as a matter of right, yan, 30 calendar days. However, when the amended complaint was not filed as a matter of right, which means an answer had already been filed. Okay? Very good. 15 calendar days from notice of the order admitting, okay, the amended complaint. 15. Ngayon, hindi ka sumagot, hindi ka pa rin madi-declare in default kasi may answer ka. But the new matters that were raised in the amended answer will be deemed all admitted. Okay. Answer to the supplemental complaint. 20 calendar days unless different period is fixed by the court. Okay. Answer to a compulsory counterclaim or permissive counterclaim. 20 calendar days, correct? Reply. Huh? 15 calendar days. Old rule is 10. Ngayon, 15. Answer to bill of particulars. 10. If a summons was served by publication pursuant to Rules 14, Sections 15, 16, and 17. 60 days after notice. 60. Notice, okay, that under Rule 14, Section 14, there is no period indicated within which to file an answer if summons was served to a foreign juridical entity through publication. That is under Section 14, Rule 14. Pero yung 15, 16, 17, nakalagay sa rules mismo, 60. Okay, answer to a complaint in intervention, how many days? 15 calendar days from notice of the order admitting the same, unless a different period is fixed by the court. So when you speak of Rule 15, gumawa lang kayo ng listahan. Okay, listahan lang. Okay. Clear? Okay. Okay, Bill of Particulars, I think pwede na kayo na yan, no? Pag Greenhand, how do you do it? You file an answer to the Bill of Particulars or you file an amended answer, no? That's how you comply. And if your motion for Bill of Particulars, parang sabi ko kayo na bahala pero ako rin nagdi-discuss. Ok talaga. Anyway, okay. If the motion for Bill of Particulars is denied, you have a period of 5 days within which to file the answer, but okay, I'm sorry. You have the remaining period within which to file your answer, but in no case less than 15 days. In no case less than 5 days. I'm sorry. Again, I filed a motion for Bill of Particulars, denied. Then I have the remaining period within which to file an answer. Okay? But in no case will it be less than 5 calendar days. Okay? So parang in other words, kunwari nag-file ng complaint, natanggap ko yung complaint June 1. Okay. I have 30 days from June 1 within which to file the answer. On the last day, I filed a motion for Bill of Particulars. Sabi ng court, denied. And I received the order denying it August 1. I have 5 days from August 1 or until August 6 within which to file my answer. Okay. Okay, sige na nga. Talagang ok talaga ako. Okay, what is the effect of non-compliance? You don't comply. Strike out the pleading or the portions thereof. Make such order as are just. Okay. Notice you cannot file a motion to dismiss the complaint. Okay. Pursuant to Rule 17, Section 3. Okay. Ito yung mahaba. Okay. Okay, I think I will end. I'll try to end in 14, but I really doubt it. I have only 30 minutes, no? So let me discuss 13. Okay. Associate the verb file, you file it in court. Okay. You associate the verb serve or service to the other party. So you serve to the other party and then you file in court. Why? Because the court will not accept your pleading if there's no proof that you served it first to the other party. And what should be filed? No? Pleadings, motions, and other court written submissions, as well as their service. Okay, now. Filing is the act of submitting the pleading or other paper to the court. Service is the act of providing a party with a copy of the pleading or any court submission. Now, in the case of UP versus Dizon, Garucho versus CA, if a party has appeared by counsel, service upon him shall be made upon counsel unless served upon the party himself is ordered by the trial court. So serve it to the party on record. Okay. Now. Okay. Okay. When there is only one party and he has a battery of lawyers from 5 different, imagine isa lang yung party, defendant isa, pero naman 5 ang kanyang law offices na niretain. Okay. He is entitled to only one copy to be served to the lead counsel if one is designated. So if you are, for example, your defendant and you have 5 hired lawyers or you engage 5 law firms, these 5 law firms must inform the court who is the lead counsel so that the pleading will be given to the lead counsel. And that is, why is that very important? Because for purposes of filing anything, the period is always will be reckoned from the receipt of the lead counsel. Now, problem is you did not, okay, you did not designate or tell the court who is the lead counsel. Kung sino unang makatanggap, doon ang simula ng bilang. Whoever first receives it. Okay, now. So lead counsel is entitled to receive a copy of every document filed. And for the purpose of reckoning periods for the submission of documents, it will be reckoned from the receipt of the lead counsel of the document. Okay. So without a lead counsel being designated, notice to anyone of the several counsels on record is equivalent to notice to all, and such notice starts the time, especially the running for the period for appeal, not considering that he received it first. And that's the case of PPA versus Sargasso Construction. Okay, now, how do you file in court? Okay, how do you file in court? Section 3. Personal. So you go to court and hand the pleading over, and the clerk of court shall endorse the date and hour of filing. Okay, so that's one. You go to court, have it stamped received, okay, and all your copies dapat ganun din. Now, by registered mail, okay, you know, I always share this because when I was a very, very young lawyer, my boss told me, okay, serve this by registered mail. And who had it served? I was the one. Sabi niya, ikaw, I was already married. Ikaw, Mawis, dalin mo sa post office na parang feeling ko, Diyos ko, an attorney. And yet, bit-bit ko, ako yung magfa-file. Literally, I was doing liaison work. At first, parang sabi ko, talagang ganito, ba't tinanggap ko yun eh? Tinanggap ko yun ng maluwalhati. Hindi ako nag-resign. Tinanggap ko. And I'm very, very grateful that I did what was supposed to be otherwise considered as a ministerial job, no? Or a clerical work. Because now I can explain. Diba? Okay. Listen to my explanation. Okay. So sabi niya, kalaban namin isa. Sabi niya, is-serve by registered mail. So pag ginawa mo ng registered, marami na ba sa inyo nag-serve by registered mail? Hindi pa. Okay. So sa registered mail, lalagay mo yung pleading sa loob ng envelope. Kalaban mo isa. Okay. So at the very least, dapat 3 kopya yan. Isa sa kalaban, isa sa korte, isa sa iyo. Ano yung isa? Huwag mo ilalaminate. Ilalagay mo lang yan sa case folder, no? Kasi may pirma ka eh. So ilalagay mo yan. So lalagay mo yan sa envelope. Doon sa labas ng envelope, okay, may nakalagay doon na registry return card. Okay, which will have to be, okay, accomplished by the recipient. to show when it was delivered and to show when it was received and by whom. And this registry return card, which was prepaid, will now be returned to you. So malalaman mo kung kailan nila natanggap. Kailan ang dating nun, medyo may katagalan ng konti. Okay, kasi i-mail yun eh. Okay, babalik sa'yo. Okay. So ngayon nakastamp yan sa tatlong envelope. Okay, ay sa dalawang envelope, court tapos sa kalaban, tapos isa sa iyo. Hindi mo i-envelope niya, alam ka email mo sa sarili mo, 'di ba? Kaya yan, rule number 1, you don't mail your own copy to you. Okay, bit-bit mo lang siya. Okay, I'm stupid, 'di ba? Anyways, bit-bit mo yan. Then I realized, dapat pala yan, hindi mo kagad isisil. Kasi pag sinil mo, bibigat ang timbang. Kasi pati yung hangin nasa loob, di ba? So patitimbangin mo muna, tapos magbabayad ka. Bibigyan ka ngayon ng registry receipt number, no? Card. It's a small piece of paper. And then, you put the registry receipt, okay, on the court's copy to prove that you registered mail, you sent by registered mail the copy to the other party. Doon mo ilalagay. Tapos yung number na yon, yung date na yon, kokopyain mo sa sarili mong pleading. So ilalagay mo doon. Tapos ngayon, saka mo ngayon isasarado yun. Pag sarado, please remember that your saliva is not paste, no? Meron doon tubig, iganon mo yun. Kadiri na ko sa yan, I learned. Kahit walang COVID noon, hindi yan ginagawa, okay? Meron nung sponge, may tubig, iganon mo tas ganyan, saka mo email. So that's registered mail. Okay. May nagtanong pala sa akin, might as well, baka kasi kulangin ako ng oras. Meron bang preferred mode of service? The answer is none under the new rules. Why? Because Section 13 of Rule 13, yung bang, may preferred mode that is personal service, you have to have a written explanation. Tinanggal na yan eh. So technically, walang preferred mode. Okay, now, so registered mail, the party filing through the said mode is given a registry return card or a registry receipt with the name of the recipient, signature, and date of receipt as proof that you mailed it to the opposing party and to the court. Now, the date of mailing as shown by the post office stamp on the envelope or registry receipt shall be considered as the date of filing, payment, and deposit in court. Okay, that's very important, huh? So you filed an answer. Okay, you filed it on the last day. Ngayon, you sent it by personal delivery. So deemed received yan nung sinabit mo sa court. Sinabit mo by registered mail. Registered mail. Deemed filed yan nung araw na yun kung kailan mo binigay dun sa post office. Hindi kung kailan natanggap ng court. Okay? Now, pero kung final mo yan by ordinary mail. Okay, ordinary mail, meaning to say, by the way, pag registered mail, huwag ka maghanap ng stamps, no? Kasi machine lang yan eh, okay? Pero ordinary mail mo final, okay? The date of receipt will be the date when it was actually received by the court. There's a will of a difference between the two. Kasi pag ganun lang nangyari, late ka ng filing kasi hindi mo final by registered mail. Next, courier service. But please take note, it has to be an accredited courier service. An accredited courier, okay, if the courier is not, okay, the date of the actual receipt of the accredited courier is the date of filing in court, no? Now, if the courier is not accredited, okay, ang alam ko may listahan na accredited, okay, let's assume lang, ha, let's assume that, ano bang JRS or FBC, hindi siya accredited ng Supreme Court. Ang date of filing yan is the date when the court receives it. Pero, kunwari, accredited yung courier, okay? Binigay mo sa accredited courier, ang filing yan, yung date na tanggap ng accredited courier, yung pleading. Okay, now. Okay. Electronic mail or electronic means. Okay, pag electronic service, okay, or electronic filing, such mode must be with the prior approval of the court. Why? Because malay mo, yung court walang internet. Malaking problema yan, di ba? Walang internet, walang ganyan. Pero halos lahat naman ng court may internet, no? May mga ganyan. So it has to be lang with the prior approval of the court. Why? Because the court must be electronically equipped. Now, the date of electronic transmission shall be the date of the filing, technically on the date you press send. And how do you get the approval of the court? By filing a motion in court, seeking the approval for the pleadings and other submissions to be electronically filed and served. Clear? Okay. So in other words, if it's a private courier, but the private courier you use is not accredited, the court will consider filing by private courier as equivalent to filing by ordinary mail. Okay? So, in other words, kung kailan natanggap, hindi ko kailan mo binigay. Okay. Any questions? Okay, now. Okay, modes of service served to the other party. Okay, modes of service can be done personally, personal service, accredited courier, registered mail, electronic mail, facsimile transmission, and other electronic means. Okay. Now, personal service, how do you do that? Personally delivering the copy to the party or the party's counsel or authorized representative mentioned in the pleading, or leaving a copy in the counsel's office with his or her clerk or person in charge, or leaving the copy between 8 o'clock to 6 p.m. at the party's or counsel's residence if known, with a person of sufficient age and discretion residing therein. So you make sure that whenever you file something, okay, when you serve something, there should always be evidence of its receipt, okay? Now, service of the petition on a party when the party is represented by counsel is a patent nullity and is not binding upon a party wrongfully served, okay? Service by mail, you have two kinds. Service by registered mail, which means you deposit a copy in a sealed envelope, plainly addressed to the party or his counsel at his office, if known, otherwise in his residence. Okay. Service by ordinary mail is allowed only if no registry service is available in the locality of either the sender or the addressee, and service may be done by ordinary mail. Okay. You know, that's very important, especially pagdating natin sa judgment. Okay. Now, substituted service of pleadings is different from substituted service of summons. Okay. So when do you do substituted service of pleadings? Okay. Sinerve mo yung answer by personal service. Pagdating mo doon, wala na yung office ng lawyer. Sinerve mo may registered mail, bumalik, return to sender because wala na yung office ng lawyer. So what do you do? Okay, you must have proof of these two modes, showing that the two modes failed. And the best, of course, when I say the best evidence, I loosely use it, is that there was failure by personal service is the affidavit of the person, okay, or your what you call this, your liaison officer, okay, went to that place, tried to serve it personally, but no more office, okay? And the best evidence naman to show that there was failure by registered mail is, of course, the return to sender. And with the RTS and the affidavit executed by the person who served it by, who attempted to serve it by personal service, then you may now go to court and file with the clerk of court a motion saying that you have availed of these two modes of personal service and registered mail, and the services now were unsuccessful, and you now resort to substituted service. The service of the pleading is complete, okay, at the time of the delivery to the clerk of court. Iba ang substituted service of pleading sa substituted service of summons, ha? Iba. Okay, don't confuse the two. Now, how about service by electronic means and facsimile? Sino sa inyo nakakita na ng fax machine? See, now I I look like a dinosaur born in the dinosaur age because she said, I've never seen one. Okay, of course I've seen one. Because during my time, wala namang uso yung electronic means. Ang uso fax, no? Fax machine. Shoot ka, tas lalabas dun sa labas, no? Now, shall be made if the party concerned consents to such mode of service. So clearly, when you do electronic means, okay, facsimile machine, you get court approval first, and you get also the consent of the other party. It goes hand in hand. Now, service of facsimile shall be made by sending a facsimile copy to the parties or counsels given facsimile number. Okay, electronic means made by sending an email to the parties or counsel's electronic email address or made through an electronic means of transmission as the parties may agree on or upon the discretion of the court. Can I serve my pleading via Viber? Diyos ko, nanonood ka ng senator, ching, kita mo, answer. Nagbibilang ka na. Can I serve it?
Yes.
If the court approves it and if the party consents to it, well, di syempre hindi ka mag-a-approve, di ba? Gusto mo mag-computer yung harap, okay? Okay. Now, presumptive service. Okay. Can somebody read section 10, please? Section 10. Can somebody read it? Just aloud. Section 10 of Rule 13. Okay.
Section 10, presumptive service. There shall be presumptive notice to a party of a court setting if such notice appears on the records have been mailed at least 20 calendar days prior to the scheduled date of hearing, and if the addressee is from within the same judicial region of the court where the case is pending, or at least 30 calendar days, the addressee is outside the judicial region.
Okay. So if the addressee is from the same judicial region of the court where the case is pending, okay, ito yung best example para maintindihan to eh. Okay. So ang court nasa Quezon City. Okay. Plaintiff's counsel is, let's say, in Makati. Defendant's counsel is in Mandaluyong. Okay. But Makati, Mandaluyong and Quezon City, they're all in the same judicial region. And we are in the National Capital Judicial Region. Okay. Natanggap ko yung hearing ko, ay yung notice, no? Sabi dun sa notice, kunwari now is July 1. Okay, natanggap ko kunwari ngayon. Ang sabi, ang hearing daw is August 1. Okay, August 1. And I'm supposed to present my evidence August 1 kasi yung huling hearing na-cancel kasi may strike. So hindi kami nag-agree. So nireset ng court August 1. Natanggap ko yung aking copy ng order July 1. Okay, now. I went to court, bit-bit ko yung kaso ko. Bit-bit ko yung witness ko. Okay, what will be the first thing I will do? I will check the records of the case. Okay, to determine when did the opposing party receive it? Okay, or when, of course, I know I received it July 1. Okay, now, since the two of us and the court is in the same judicial region where the case is pending, there is a presumptive notice of a court setting if it appears on the records that it has been mailed at least 20 calendar days before the scheduled date. Okay, so what does that mean? Okay, July 1 natanggap ko. Tapos, yung hearing August 1. Kung natanggap ko yung July 1, ibig sabihin na mail yun before July 1. Alam nga naman natanggap ko, tapos minil kinabukasan, di ba? Parang weird. So it was mailed, let's say, June 15. So it was definitely sent out, okay, mailed June 15, which is more than what? 20 days prior to August 1, the hearing date. Okay. So tinawag ngayon ako ng korte. Okay. Ready, Your Honor. We're ready to present our witness. Siyempre, wala kang narinig. Ang sasabihin ko, good morning, Your Honor. Respectfully appearing for the plaintiff, we are ready. Okay, ready to present our witness. Nakinig ka. Walang boses ng defendant. Nothing. Tapos sabi ni judge, what is your pleasure, counsel? Siyempre, ang sasabihin mo, I'm pleasurable. No, you don't say that. Okay? I'm pleasurable. No. Lalo you do not say you're pleasurable, Your Honor. No, you do not. Okay. Ang sasabihin mo ganito. Okay. Your Honor, considering that based on the record, it appears that the order setting the case for the hearing was sent out or was mailed, okay, in June of 15, okay, then that means it's at least 20 calendar days before today's hearing. Then there is a presumption that the defendant already received it. There is a presumption. And given this presumption, Your Honor, may I now be allowed to present my witness? Kasi may presumption na tawag dito na natanggap niya yung order. Clear. Kaya pwede ka magpresenta ng ebidensya. Kasi may presumption na natanggap niya and therefore informed siya ng hearing. Now, if the addressee is outside the judicial region, Quezon City, Makati, pareho kami. Pero yung kalaban ko, Zamboanga, ewan ko kung anong judicial region yan, but definitely that's not part of NCR. The period should be 30 days, 30 calendar days prior to the scheduled hearing. The hearing is August 1. Okay? Nakita ko June 15, obviously more than 30 calendar days, may presumption pa rin that now I can adduce my evidence. Clear. So, in this rule, Section 10, it is the court that sends out the notice. Okay? It's the court that sends out the notice. And that is the reason why earlier I said, when you go now to court, and you receive an order, the first thing you do is go to the staff, okay? And ask, ma'am, kailan pwede ko mahiram yung records? Titignan ko, kailan ho na-release itong order na to? Tapos tignan mo, pareho ba kayo ng judicial region? 15 days, diba? 15 calendar days. Ay 20 calendar days. Kung iba-iba kayo ng judicial region, if the address is different, judicial region, 30 calendar days. Then that's the time you invoke the presumption. Clear? Okay. Any questions? Okay. Of course, you have to change your electronic email address or facsimile number. It is your duty, okay, to inform the court. And you inform the court within 5 calendar days a notice of change of email address or facsimile number with the court and serve the notice on all other parties. Okay. Now, Section 12, when you file your notice, you don't type it. You can type it, but you can attach the pleading. No? You can attach the pleading. Okay. I will end at 13. Okay. Now, look at the title, Service of Judgments, Final Orders or Resolutions. This Section 13, therefore, does not apply to interlocutory orders. It applies to judgments, final orders, or resolutions. Okay. Now, and that is, okay, look at your Section 13. Judgments, final orders, or resolutions shall be served either personally or by registered mail. Upon ex parte motion of any party in the case, a copy of the judgment, final order, or resolution may be delivered by accredited courier at the expense of such party. When a party summoned by publication has failed to appear in the action, judgments, final orders, or resolutions against him or her shall be served upon him or her also by means of publication at the expense of the prevailing party. Okay. May judgment. Okay, nagpa-participate yung defendant. You can serve the judgment personally or by registered mail. You cannot serve by electronic evidence. Okay, cannot by electronic evidence. Otherwise, okay, if you serve it by electronic means, the service is void and therefore the running of the period in which to file an appeal, motion for recon, MR, motion for new trial will not commence running. Kasi there are only two ways, personally or by registered mail. Ngayon, gusto mo matanggap agad, pwede by accredited courier, but you have to file first a motion in court. Why do you have to file a motion in court? Because the court wants to be assured that you will be paying for the expense. Mahala magpa-accredited courier. Okay, now, look at the last paragraph, and this is very important kasi minsan the students, they do not read it eh. So the party, okay, was summoned by publication. Summoned by publication. Hindi siya umapir. Okay, he did not appear. So he was declared in default. So my judgment by default. How do you serve it? Okay, how do you serve? Okay, it will be served upon him or her also, which means in addition to maybe personal or registered, also by means of publication at the expense of the prevailing party. And you publish the dispositive portion. Now, paano kung nag-serve by publication, nag-serve ng summons by publication? Umapir, nag-participate si defendant. Now, judgment was rendered against the defendant. How will judgment be served? Not by publication, by registered mail, personal service, or upon motion duly granted by the court, accredited. Clear? Now, paano kung motion to dismiss on the ground of lack of jurisdiction, okay, over the subject matter, denied? Denied. Can the order denying the MTD, okay, motion to dismiss, be served by ordinary mail? Malapit na tayong umuwi, sagutin nyo naman. Okay, what? Yes, you can. Yes, because Section 13 refers to final judgments, final orders, final resolution. Okay. Motion to dismiss, granted. Okay, granted. It was served by ordinary mail. Okay. Period. You received it July 1. Okay. When is my deadline to file an appeal? I filed a motion to dismiss. The motion to dismiss was granted. I received the order granting the motion to dismiss July 1. When is my deadline to file, let's say, an appeal? A motion for recon or motion for new trial? Motion for recon, I'm sorry, not motion for new trial, motion for recon or appeal. When's my deadline? Yung sabing 15 days. Ha? Very wrong. Okay. Wrong lang, di very. Because the period has not commenced running. Granted siya, di ba final order siya? And therefore, kung final order, granted di ba? Granted. Grinant yung motion to dismiss. Dismiss, grant. Okay. Pag granted, final order siya, wala nang gagawin ng korte. Kasi nga, dinismiss. So, paano isi-serve yun? Dapat by registered mail, personal delivery, or upon proper application, courier service. Clear? Now, if the motion to dismiss is denied, eh di magfa-file ka ng answer. So, ibig sabihin, hindi dismiss, magfa-file ka ng answer, magta-trial kayo, di ba? May gagawin pa yung korte. Then it can be served by ordinary mail. Hindi kailangang because that's interlocutory. Clear? Okay.